Okay, good morning, everyone, and welcome to docket number 220808, the application of the United Illuminating Company to amend its rate schedule. My name is Chairman Marissa Gillette, and I'm joined today on the bench by my colleagues, the Vice Chairman Jack Pekoski and Commissioner Michael Karen. Today is our first day of evidentiary hearings in this matter, and I hope everyone gets comfortable. We have about probably 30 minutes of administrative matters to go through before we can get into the meat of things. We did request appearances to be filed in advance in this proceeding, given it's contested, but I will ask now. Sorry, Miss Laura. I will ask now, just to get us started and acquainted, if all the attorneys can verbally identify themselves so that we can make sure we all know who is here and present. So for folks sitting in the audience, I'll ask that you approach the mic, but we will begin with the gentleman at this table, please.
Good morning, Chair Gillette, Vice Chair Pekoski, and Commissioner Karen. Dan Venora from the law firm Keegan Werlin, along with Brendan Vaughn of the law firm Keegan Werlin on behalf of the United Illuminating Company.
Thank you. Good morning, gentlemen. Attorney Wheel, please.
Check. I'm not sure if this is on. Tom Wheel from the Office of Consumer Counsel. I'm here with Andrew Minikowski, my co-counsel. We've also filed appearances from William Dornbos, our legal director, as well as Jessica Govea and James Talbert-Slagle, who are newer attorneys in the office.
Very good. Thank you. Attorney Marshall, please.
Thank you, Chairman. Ashley Marshall on behalf of DEEP. Eric Annis from DEEP staff will be joining me throughout some of these hearing dates. He's not here today, but he may be questioning throughout the hearings. Thank you.
Understood. Thank you very much. Good morning.
Good morning, Chairman. Good morning, Vice Chairman, and good morning, Commissioner Karen. Nice to see you all. Lauren Bidra for the Office of the Attorney General. My colleague John Wright will be joining us for these proceedings as well.
Thank you. Good morning.
Good morning, Chairman. David Suter for NECTA.
Very good. Thank you. Good morning.
Good morning, Commissioners. Alex Judd from Day Penny here for ChargePoint.
For ChargePoint. Very good. Don't go far, sir. I'm going to have the deal with your motion in just a moment. Attorney White, please.
Good morning. Kim White for EOE. I'm joined by my colleagues Brittany Wyman, Zach Alexander, and Dave Sherry.
Thank you. Good morning, sir.
Good morning. Jay Goodman of Couch White, appearing on behalf of the Connecticut Industrial Energy Consumers.
Very good. And you're
Good
joined
morning,
by
Amanda Trinzi on behalf of the Connecticut Industrial Energy Consumers as well.
Very good. Thank you. Okay. I believe that was everyone we were expecting. Any other attorneys representing parties or interveners? Okay. Attorney Judd, if you could approach one of the items I want to deal with this morning is what I believe is the only outstanding motion at this point, outstanding motion number 58, which I understand to be a request from ChargePoint that we allow remote adoption of the testimony. I do want to clarify that we are not enabling two-way participation in this proceeding, but we will permit the testimony to be adopted by affidavit in the event that no other party has cross for your client. So at this time, I would like to poll the parties. If you anticipate having cross for ChargePoint, then I would appreciate if you would approach the mic. I will ask the company to affirmatively state whether or not you have cross for ChargePoint, please.
The company does not have cross for charge point.
Thank you. If no other party approaches the mic, I will consider the opportunity to cross charge point waived. Very good. Then Attorney Judd, if you can have your client file an affidavit attesting to the accuracy or the veracity of their testimony and as a comment on motion number 58, then we will strike them from the witness panel and consider the testimony adopted.
I appreciate the accommodation. We'll do that. Thank you very much.
Thank you. Okay, let's roll through these. Have a number of we received a number of motions for administrative notice over the past couple of days. I do just want to clarify as a reminder to folks, because I know that there have been different approaches historically. It is the authority's position that we are not required to take administrative notice of our prior decisions. So we will not be taking administrative notice of our decisions. However, the parties may cite to past PURA decisions in your briefs and such. I think there was a ruling 30 minutes ago on the Office of Consumers Counsel's request for administrative notice that was denied. However, we are allowing OCC to use the exhibits as documentary evidence in this proceeding. But not accepting, we are not taking a position on the veracity or credibility of those exhibits at this time. You can use them as documentary evidence. And I believe we have ruled on all other motions at this time. So just a advisory note that that will be how we proceed. Okay, also I want to circle back to the some general announcements about both today's hearing, but hearings throughout the next couple of weeks. For those who were participants in the Aquarian rate case, some of these announcements will sound similar, but we'll say them for the benefit of the record. We do have the opportunity to use our system here to display exhibits. If you would like to display exhibits to assist with your cross-examination of a party, a reminder that those exhibits need to be put onto a flash drive, and they need to be provided the morning of your cross to our case coordinator, Ms. Lupoli, at least 30 minutes in advance of the hearing that day. So if you want to use exhibits tomorrow, please show up at 9:30 with that flash drive, and so on and so forth. The flash drive should be labeled with your docket number, your party's name, and Ms. Lupoli will take care of connecting it to the network. You will be permitted to manipulate the computer to access the materials. Ms. Lupoli will be sitting next to you to make sure that we don't mess up anything with the live stream, that the share screen function does not interfere with the Zoom or the YouTube internet broadcast. So if there are no questions about that, we'll keep going here. You may have noticed on the agenda a couple of notes. So I do want to emphasize to people, we will only be taking 30-minute lunch breaks throughout the proceeding. We will be starting promptly at 10 a.m. every day. We will be concluding at approximately 5:30 p.m. every day. That should allow you access to the garage, as that should stay open until 6:30. And importantly, the reason that we are doing that is we are aware that the cross estimates that were provided by parties and interveners exceed the number of hours in the day that we have days that we have booked. We're aware of that. I've added, I can do math contrary to perhaps popular opinion, but we have done that. I am going to monitor our hearing progress closely over the first week of hearings to see how this progresses. As we all know, sometimes parties have duplicative cross from other parties and those estimates will perhaps go down. If after the first week we are behind or not making sufficient progress, I do want to advise parties and interveners that if we have to, we will be using the dates of March 8th, 9th, and 10th, which, you know, we all have other things booked on those and would prefer not to use those dates as it impacts our timelines for other proceedings. But if necessary, we will move into those dates. The morning of February 23rd, we will provide certainty as to whether we think we are moving into that territory. So some definitiveness will be provided the morning of the 23rd. Okay. At the start of each panel, of which we have many, I will ask any party and intervener when you approach for cross, if you anticipate having confidential cross for that panel. I would appreciate you flagging that for me at the start of your cross. The authority's overwhelming preference is for as much information to be put on the public record as possible. So if you can rephrase your questions to avoid implicating confidential materials, then that would be preferred. If you absolutely must go into a confidential session, we are prepared to do that. The confidential cross will occur immediately following the public portion of that panel. So at the conclusion of your cross for public session, if you can again catch my attention and say, you know, Chairman, I'm going to have confidential cross, we will make sure to update our notes accordingly. When we do move into confidential session, and this is more of a note for people live streaming us at this point, obviously when we move into confidential session, we will be disconnecting the live stream. So we will try to display a note, public-facing note to the YouTube channel indicating that we are either at lunch or in a confidential session. But for colleagues watching back at home, if the stream is disconnected, we are likely in confidential session or at lunch. Okay. Attorney Riley, have I missed anything that you can think of? Okay. Okay. All right. So with that, I believe those are my administrative announcements. I will ask parties now if they have administrative matters before we turn to our first panel. So I'll start with the company, please.
Yes, thank you, Chairman Gillette. Just a couple of items. First, on the hearing agenda for the cost of service panel, one of the company's witnesses, as identified, is not available for the hearings due to a medical situation. That is Mark Marini. Mr. Marini was a joint witness on all of his responses with Mr. Kulka, as well as his testimony with Mr. Kulka, and Mr. Kulka can speak to all of those matters. So we just found out recently that he was not going to be available for the hearings. So just wanting to note that.
All right, thank you. What else?
Okay. Also relating to the agenda, on the executive comp panel for the, I note that OCC's witnesses were identified as testifying separately on that topic. I would just like to request to reserve the right to cross. We have cross-examination time reserved for them under O&M, where I expected to cover that topic, but if it's, you know, it'll either shorten my cross on O&M or not happen at all. I don't expect it to be lengthy. So I'd make that request also.
Okay, so I believe I'm on page 15.
Page 15.
So in that case, the company will be, you're reserving the right?
Yes, please.
Okay, I am going to put you first on that panel. We will check in with you.
Okay.
Then.
Just two more quick items. On the ruling this morning relating to the OCC's exhibits. So those are coming in now, which is after testimony and after discovery. So we would not have had a chance to review any of those prior to them speaking to them during their testimony. Just making a request for Pyrrhus consideration whether to designate those as late filed exhibits so we actually see the documents because they actually didn't provide the documents with their motion. So I would make that request so that we can see them and potentially cross-examine on them.
Give me one moment here.
If they did file them, I didn't see that.
Okay, so, the materials have or have not been filed? I thought they were appended.
Maybe they were. If they did, I apologize, but.
Okay, I think they were appended, so, let's do this. I'm not gonna mark them as late file exhibits, but I will allow the, since they're already, in there, but I will allow the company, to, cross on those at the late file exhibit hearing.
That's perfect. Thank you.
Does the OCC, have any objection to that approach?
I have no objection to that approach, but I guess I'm a little confused because of and I haven't had a chance to review the Bureau's written decision on the motion yet. But it's my understanding, based on the chairman's statement this morning, that those exhibits aren't going to be accepted as evidence in the record and are only going to be allowed for demonstrative exhibits during cross. So I'm just not sure why we'd be cross-examined on them if they're not exhibits in the record.
Your understanding, Attorney Wheel, is accurate. If the company wants the opportunity to cross on them, then I would posit that transitions them into evidence into the record. So as they have now had the opportunity for cross-examination. So I would leave that to the company as to whether you want to withdraw their request or continue.
Can I respond?
Yes.
Okay, because I couldn't see Attorney Wheel behind me. I guess I'm not clear. Are the documents in the record as evidence sponsored by OCC, or are they something else?
I understood them from OCC's motion to be documents that they intended to use for demonstrative purposes while they were cross-examining your witnesses, and not documents that were being sponsored by the OCC witnesses.
Okay, I guess I'm just, because I'm reading the ruling and it says that it would be for use by OCC and its witnesses during their testimony. So that's the reason for my confusion.
Okay. Attorney Riley, we can clarify, or I will clarify from the bench. I think what you're saying is us trying to get a motion ruling out before the start of a hearing.
Right.
So I am clarifying from the bench that the intent of the motion ruling is to allow OCC to use those exhibits for demonstrative purposes while they are crossing your witnesses.
Thank you. Our witnesses will not have reviewed any of those documents. So but we understand your ruling. Thank you.
Okay. All right. Thank you.
But Chair, may I just reserve the right then to, since the motion was just filed yesterday, the company did not have the normal 7-day period to respond to the motion. Could I have that opportunity to file a written response?
You may, Attorney Wheel or another attorney from OCC, can you remind me which panel, what is the first panel that you were hoping to use these demonstrative exhibits for? Appreciation. The first panel.
So actually, can I narrow my request? We have no objection as to the depreciation cross using those. I think it's exhibits, the first several exhibits. It would be it would be exhibits D through I that the company would want the opportunity to respond to.
D through I.
Yeah. So I think that could facilitate today's session, and then we can maybe take back and assess and because those were.
Okay.
Thank you.
All right, so we'll revise the earlier statement. Let's table this for administrative matter tomorrow morning. We'll proceed under the authority's ruling for today's purposes with exhibits A through C. We'll take this up tomorrow with respect to exhibits D through I, and we'll revisit the potential remedy of allowing cross and during the LFE hearing. So we'll just revisit it. Attorney Minikowski.
There's no raise hand feature anymore. I don't know what's Chairman, also exhibits J and K that were appended to that motion, we will be relying on during our depreciation cross-examination today.
Okay,
That's fine. We have no objection on that
that's
either.
fine. Okay, very good. So exhibits A through C, J, and K will may be used by the OCC for the depreciation panel today.
Okay.
Okay, any further administrative matters?
Just one last one, hopefully simpler. So throughout the course of discovery, the company identified several corrections that would need to be made in a case update, and just making a request that the authority assign a late filed exhibit for purposes of the corrections to be provided.
Very good. I will assign that late file exhibit number 1. I want to be crystal clear in the prompt for the late file exhibit 1, which is that late file exhibit 1 is allowed to provide revisions and corrections based on errors that were identified after the filing of the application or during the hearings.
Understood.
Okay.
Understood. And so with respect to the filing date for that late file, would that come sometime after the hearing, after the principal hearings?
Yes, we do not have, so in the Aquarian case, we had rolling, we do have rolling late file exhibit hearings. No.
I didn't.
I'm sorry, give me 1 second here. I'm sorry, Attorney Venora, give me 1 moment.
No worries. I don't recall a rolling schedule, but that can be, yeah.
I don't believe we have a rolling schedule in this docket because we had more time. So I just want to make sure I have the right late file due date, because it would be, the answer to your question is that the late file exhibits would all be due on the same date, including this one, which is March 8th. I suppose if there are corrections to if there are corrections uncovered at the late file exhibit hearings, then we can discuss a potential supplement. But all of the late file exhibits are due on March 8th at the moment.
Okay. Thank you very much.
Thank you. Anything further?
Nothing.
Okay. Do any parties or interveners have administrative matters at this time? Attorney Wheel.
Thank you. Just 2 quick ones, Chairman. First, thank you for the clarification on the scheduling issue and the cross estimates. You may have seen we filed correspondence this morning that pertain to that. I just wanted to highlight that in that correspondence, and we made a similar. We filed similar correspondence in the Aquarian rate case recently. We just wanted to put out there what we've communicated with our witnesses as to their availability based on our expectations best we could from the schedule. So that's included on the correspondence, and we just wanted to put it out there to sort of just be transparent about our plan for when witnesses are going to be here. Particularly the last 3 witnesses we're putting on who we've instructed to appear in the last 2 days of the hearing, but all those witnesses are affected by the kind of projected overflow situation now where there's more cross-estimated than there is time. So I just wanted to bring that to the authority's attention, that filing. Also, just a quick clarification regarding the administrative notice. Is it the authority still seek motions for administrative notice for reliance on decisions from other jurisdictions, whether they be court decisions or decisions from administrative bodies in other states? Or would the authority?
Oh, Attorney Will, you are challenging my legal knowledge first thing in the morning here. Okay, so our administrative notice is governed by the UAPA under Connecticut General Statutes 4-178A and our regulations. The authority is permitted to take notice of judicially cognizable facts. The question as to whether decisions from other jurisdictions constitute that is they do not fall under that category to my knowledge. You know what, let me take that under advisement, and we can take that up after the lunch break. But I think at this point, we were expecting any notices for any requests for administrative notice to have been filed. So I'll start there. And say we do not require administrative notice of our decisions, and let me get back to you on decisions from other jurisdictions.
Thank you.
Okay.
And that was all I had. Thank you very much.
Thank you. Anything further? Attorney Marshall.
Thank you. Just a very quick administrative matter. DEEP would like to reserve the right to cross-examination on the UI panel for cost of service study, revenues, rate design, rate adjustment mechanisms, and sales revenue forecasts. We previously did not reserve our right here, and we're just requesting permission to make that modification to the agenda.
Thank you, Attorney Marshall. Am I on, is this page 4?
Page 4, yes, Chairman.
Okay, we will add you in between the Attorney General and EOE.
Very well. Thank you.
Thank you. Anyone further? Okay. All right, very good. If there's nothing further, we will move into our first panel. So for everyone's awareness, when we get to panels, we will pause for introduction of the witnesses. We will swear the witnesses in, have them adopt their materials, and then I will ask the representing attorney if there is any direct. If there is not, we will proceed into cross in the order listed on the agenda. So Attorney Venora, if you could introduce your first panel, please. Oh, I'm sorry, Attorney Vaughn.
Good morning.
Morning.
I'll begin with you, Ms. Norrie. Could you please, we have Amanda Norrie, Larry Kennedy, and April Thaberge. Ms. Norrie and Mr. Kennedy are from Concentric, and Ms. Thaberge is from the company.
Very good.
Can you hear me?
Right, but very good. So if I could ask the witnesses, if you could please raise your right hand, I'm going to administer the oath, and at the conclusion of the oath, if you can say I do. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do. I do.
Okay, very good. Attorney Vaughn, if they can adopt their pre-filed materials, please.
Yes, absolutely. Beginning with Ms. Norrie, would each of you please state your full names and positions for the record?
Amanda Norrie. Sorry.
No, it's not you.
Amanda Norrie, Senior Project Manager with Concentric Advisors.
Good morning, Chairman
Morning.
and Commission. Larry Kennedy, Senior Vice President with Concentric Advisors.
Good morning. April Thaberge, Director of Avangrid Centralized Accounting.
Mr. Kennedy and Ms. Norrie, as part of your preparation for this docket, did each of you provide pre-filed written testimony and exhibits, which for Mr. Kennedy were marked as exhibits UI-LEK-1, LEK-1A, and LEK-2, and jointly for Mr. Kennedy and Ms. Norrie as exhibits UI-LEK-AN-Rebuttal 1 through UI-LEK-AN Rebuttal 3?
Yes.
Yes.
Do you have any updates or changes to your pre-filed direct testimony or your pre-filed rebuttal testimony?
Yes, I do have one clarification I'd like to make to my original testimony, and in particular to exhibit that would be the actual report, which is, as I understand it, exhibit UI-LEK-2. At PDF page 4 of that exhibit, the report number, page 1-1, there is a statement on that page that I wish to clarify. for the commission. The statement reads, variances, age. Variances between the calculated accrued depreciation and the book accumulated depreciation as of December 31st, 2021 are amortized over the composite remaining life of account. Now, that statement is correct, but upon reading Mr. Dunkel's rebuttal testimony, I realized the statement was maybe a little bit vague enough that Mr. Dunkel may have misinterpreted the intent of the statement. I just want to clarify the intent of that statement. And that's that the accumulated depreciation variances, as stated in the first few words of that sentence, are the specific item that are amortized over the composite remaining life of the account. The depreciation rate calculations, as noted by Mr. Dunkel, it appeared that's what he was thinking we had suggested in that statement. The rate calculations themselves are calculated at a vintage level. So just for clarity, that statement relates specifically to the portion of our work that's dealing with the accumulated depreciation reserve variances. The actual depreciation rate is calculated at a vintage level. Thank you for the opportunity.
Vintage level.
Vintage level, thank you.
Thank you. And subject to that update, do you adopt your pre-filed direct testimony and rebuttal testimony as part of your sworn testimony in this case?
I do.
I do.
And then this is to all the panel members, beginning with Ms. Norrie. Did each of you also sponsor responses to interrogatories submitted in this proceeding?
I did.
I did.
I did.
Do you have any changes to any of your responses to interrogatories?
No.
No.
Do you adopt your responses to interrogatories as part of your sworn testimony in this case?
I do.
I do.
I do.
And this is to, lastly, to Ms. Thieberge. Are you familiar with UI's witness list filed as attachment A to its filing with PURA on February 14th, 2023, identifying certain non-panel witnesses who sponsored responses to interrogatories in this case?
Yes, I am.
And for purposes of admission into the record, do you adopt the interrogatory responses submitted by Benjamin Burns?
Yes, I do.
The panel is available for cross-examination.
Very good. And no direct?
No.
Very good. We will turn to authority staff for questions, cross-examination first. We'll turn to Mr. Garrett, please.
Good morning. My name is David Garrett for authority staff, and I have a few questions for Mr. Kennedy. Good morning, Mr. Kennedy. How are you?
Good morning, Mr. Garrett.
I'd like to start with this issue of the depreciation methods you used in this case. Is it correct that you're using the straight line method and the average life group procedure in this case?
We are.
And those are the same approaches you used in the prior full depreciation study?
I've used that method in virtually every depreciation study that I prepare.
Okay.
I have not followed a depreciation study before this authority before.
What was that?
I have not followed a study before this authority prior. So I was a bit confused by the question, but it's the same one I'd used with this authority before.
Okay, but on page 19 of your testimony, you discussed that you used a different approach to calculating remaining life in this case. Is that right?
That's correct. So I used a different approach than the prior company witness, Mr. Robinson. In that case, I think it was in 2016. So my approach, as I described at that page of my evidence, it's a refinement where it actually does the calculation at a vintage level. It sums through a reciprocal weighting the impacts of the resultant expense by vintage, and then it composes those up and develops a reciprocal weighted average remaining life. But the calculation to develop the expense at the vintage level is unique to this authority, in this case, to my study. I note that other witnesses that have testified and put evidence before this authority have used that same approach.
Okay, I see. And if we're distinguishing the characterization of these approaches, we could refer to the approach that was taken in the prior case as the broad method, and then the approach you took in this case is the vintage method.
Both are based actually on a broad approach, and that's why it's a very intricate, very finite refinement. So I would say one is based on a composite remaining life calculation. Ours is based on a reciprocally weighted average service or remaining life calculation.
Okay, and you reviewed the direct and surrebuttal testimonies of OCC witness William Dunkel?
I did.
Is this issue of the broad method versus the vintage method, is that one of the areas you say that you disagree with him on?
I do. It's been the method that I've used. It's been the method used commonly by at least a couple other large depreciation consulting firms across North America. It's became popular in the 1960s, 1970s with the advent of the ability to use computers to calculate depreciation rates. The method, the more broad group or composite method that's used in this case by Mr. Dunkel was popularized in the 1930s when we did calculations by hand. So it was easier to do one composite calculation over a total account than by taking it into various vintages. It's because it's more finite. Sometimes it results in a slightly higher depreciation rate. Sometimes it's a bit lower. It depends on the weighting of the investment within the account. It's been recognized in a number of jurisdictions specifically. Recently, I've had it adopted in Idaho, Illinois, Montana. I'm missing a few, but off the top of my head, it's been fairly widely adopted as simply being a refinement to the widely used depreciation method.
Okay, I'd like to look at page 24 of the depreciation study, and this is exhibit UI-LEK-2. We just give it a second. I think we can display that too. We'll skip the first one. Second case. Yeah.
The second one.
Okay.
That's a page, Mr. Garrett.
Okay, I was giving him a second. Oh, looks like we have it. Okay. And so here you're showing a table with your proposed depreciation rates and annual accruals. Is that right?
That is correct.
I'd like to look at, just as an example, account 361 toward the top of the page. Here you're showing an annual accrual amount of $644,995.
That is correct.
And a 37.5-year remaining life in column 10.
Now that's a calculated composite remaining life. Now, just for clarity, that 37.5 years was not used in the calculation of the accrual rate of 2.26. So we've displayed it there for informational purposes, mainly because we've had a lot of authorities and commissions ask us just for that calculation, so we put it on the table.
What is the remaining life that you did use for that account?
So that would be in the detailed depreciation calculations in section 8 of our report, and I can turn you to the page. 361. Okay. So in the depreciation study report in my exhibit, it's at PDF page 143 through 145.
Okay.
And that page, you would see and maybe if I can indulge the commission, just the authority to maybe describe the calculation that results in the expense in the rate that we provide on the table you're taking me to, Mr. Garrett. So on that page, and I don't think it's not up, but that's I'll try to talk to committee to talk you through it.
No, that's fine. I actually did have a few questions about that exact table. So, and it is maybe if you briefly want to describe how you got to that rate, I think that'd be fine.
Okay, so certainly. So on that, at page 145, you'll see in the second last column titled annual accrual. The annual accrual is a total based on the annual accrual amount for each vintage. And each vintage, you'll notice starting back at page 143, deals with the actual remaining life specific to that vintage purely from the published textbook annual accrual ratios that, and I know you're familiar with, and others in the room are familiar with, probably nobody else. But so that comes straight from those calculations and algorithms or tables that are available. So for example, at vintage 1939, if we take that as an example, there's $139 or $190 of original cost in the second column. We have an allocated book reserve of 148. And that leaves a future amount for our net book value to be recovered yet of $53. And we recover that over the 5.7 years. The arithmetic in that would lead to a $9 accrual requirement for that vintage. We sum those annual accruals by vintage to the $644,996. And we would divide that annual accrual requirement we would take the net book value, divide the annual accrual rate there to come up with a remaining life calculation that we would use in our calculation that would be different than the 37 years that we had shown before. The 38 years or 37 years, 37.45 to be exact, is really based on a composite remaining life that is averaged on the basis of original cost by age. And then, so in that way, it's a composite. The calculations we use are specific to those remaining lives for each vintage and the net book value. So it's representative of the average age when it's weighted by the net book value and age. So it's slightly different than that 38. Like I said, that 38 is, we asked for it so often in proceedings. We provided on that front table. Frankly, this is the first time that we've had a commission in 140 sometimes I've testified that we've gone into this level. So I think in future studies, we will be making that more clear within a study just to avoid the confusion. You can teach an old dog new tricks, and I think we will make that much more clear in terms of what that composite remaining life on the first table you took me to versus how we actually calculate our rate. And I just want to be crystal clear with that.
Okay, and I do appreciate that explanation. But so if we go back to the top table, table 1, this is for the record, page 24 of exhibit UI-LEK-2. The future accruals in column 8, this is for account 361, is the 23.6 million. Is that right?
That's correct.
And so I believe what you've described, we can't divide that amount simply by the 37.5 years in order to get your proposed.
That's correct.
Okay.
Frankly, it would be less confusing if I didn't put that composite number on that table. So that's.
But if you didn't put that composite remaining life rate, what would you say is that the period of time over which those dollars are to be recovered?
So I do know at least one other depreciation consulting firm that would actually recalculate that remaining life, and they would put on that table it would simply be that 23,692 or 23,692,000. They would divide that by the 644 annual accrual and get a number.
I see.
And so it's
that makes sense. Okay, I have no further questions. Thank you.
Thank you.
Thank you, Mr. Capozzi.
I do not have any questions, Chairman.
Thank you. No other authority staff questions for this panel? All right, very good. Thank you. We will transition to the Office of Consumer Counsel, please.
Yeah. Do this.
See that?
No, but we have. My eyes are.
Which page are you on?
Oh, no, I'm gonna.
You just tested it.
I'm just saying, yeah, this is good with me.
Yeah, just says. Oh, Jesus.
Good morning, panel. Thank you for being here today. Just by way of introduction, I'm Andrew Minikowski. I'm a staff attorney with the Office of Consumer Counsel, and I'm joined by my co-counsel, Jessica Gouveia. And this is our witness, Mr. Bill Dunkel, whose testimony you are familiar with. He will also be conducting cross-examination of his own this morning. Thank you.
Hello, I'm William Dunkel. I'm a depreciation expert working with the Office of Consumer Counsel. These questions are designed to be yes or no questions. Looking at page 19 of your direct testimony, noting that you are a member of the firm called Concentric, is it correct that starting on line 12, you say Concentric incorporates a refinement into the remaining life calculation that had been used in the prior study? And by prior study, do you mean docket number 1606-04, which established the current UI depreciation rates?
Accept that.
I will accept that. Okay. My understanding, that's the evidence of Mr. Earl Robinson in the last proceeding of depreciation.
So you acknowledge that the remaining life formula you used in this proceeding is different than was accepted by the commission in the prior proceeding?
It is a refinement to that calculation, yes.
Yeah. Is it correct that in this case, the company is proposing a 3-year rate plan, which means your depreciation rates, if accepted, would be in effect for at least 3 years?
That's my understanding, sir.
Turning to page 141 of your depreciation study, approximately 2/3 down way across the page, there's a column headed net book value.
The page number again, sir, was?
141.
Thank you. I have that.
We have a copy of your discovery request 630, OCC 630. Is it correct that in Part B?
Oops.
one
Just
second,
give the witness one moment
sure.
to get his material. Thank you.
I have that.
We asked if the amount in the net book column is, quote, the total amount that remains to be properly recovered from ratepayers. And your answer started with the word confirmed. Is that correct?
Yes.
Okay. Going back to page 141 of your depreciation study, looking at the row that is year 1926, in the net book column, the amount shown is 36,337, which I'll just round to 36,000 for the rest of the discussion. Is it correct that for the 1926 vintage, 36,000 and change is the total amount that remains properly to be recovered from ratepayers?
Correct.
Okay. On that same year 1926 row, in the annual accrual column, your proposed annual accrual is also the same number of 36,337, correct?
That's correct, sir.
Okay. Given that your rates, if approved in this case, would be in effect for each at least 3 years, and you recover approximately 36,000 per year from the ratepayers, wouldn't you triple recover the 36,000 that was still due?
Sir, I will state, the fact of the test period is the issue there as compared to necessarily the rate calculation. Now, these rate calculations are used for all vintages. If you were to take that same account, in fact, the next page, page 142, you'll see in a more recent vintage, or I need new glasses, 2020, there is an amount of $1.2 million in that vintage. The method that we are using would allocate that remaining life to be longer than would be used in the, I'll say, the previous method that was used before this commission, or also in your evidence, Mr. Dunkel. So in other words, we are accruing a lower amount because we are using a longer life than the composite remaining life would be for that 1.2 million. So and that will also occur, that different amount will also occur for the next 3 years. So there is puts and takes on some of these accounts. There is an over recovery perhaps given the 3-year test period, but on other larger accounts with more investment, it goes the other way. Always is account recovering slightly less because we are using the more precise remaining life calculation by vintage. So sir, I would agree. These amounts are going to be recovered for each of the next 3 years, or are going to be applied against the planned balances. The rates will be applied against planned balances, which will result in a recovery of such. The fact is though, the calculation deals with that same phenomenon in reverse on newer vintages as compared to what you're demonstrating on the older vintages.
Is the response to my prior question yes?
Objection. The question's been answered.
It has not been answered. The question was, would you triple recover on that vintage?
Yes, and I will under recover by triple on the younger vintages.
Is it correct? And I can give you the exact date, but did the current depreciation rates go into effect in or around January 1, 2017?
I'm not sure the precise dates that the the current rates were established on.
All right, assuming hypothetically, they went into effect somewhere around that time, is it correct they're still in effect right now?
I understand them to be.
So the rates that are established in this case, although we know for sure will be in effect for 3 years, it's possible they might be in effect more than 3 years. Would you agree with that?
I can't predict the future, sir.
Okay. Now, we just discussed, and what is in fact the first account in your study, and the dollar amounts there were fairly small. I'd like you to look at page 171 of your study, which has a similar issue, but the dollar amounts are quite large. Now, this is account 370.10, automatic meter reading system. Looking at the year 1987 vintage, are you caught up yet or not?
I am now.
Okay. Looking at the year 1987 vintage, is it correct the net book column shows $500,000, 554?
That's what the page says, sir.
And as we previously discussed, that means $500,000, 554 is what is left to be properly recovered from the ratepayers. Is that correct?
Yes.
In that vintage. On that same year in 1987 row, in the annual accrual column, your proposed annual accrual is also 500,000, 554, correct?
That is correct.
And as we previously discussed, your rates will be in effect at least 3 years. So isn't it true you would over recover by approximately $1 million in that one vintage, in that one account?
In that one vintage, I will point out vintages later, 2017, for example, that has $21 million of original cost, and 2015 that has $22 million of original cost, again, has the same phenomenon going the other way as compared to the more composite level of calculation.
Was the answer to my prior request yes?
For that specific vintage, I'm just pointing out other vintages go the exact opposite way.
I still didn't hear yes or no. Is the response
Objection
yes?
to the question.
No.
The witness has answered your question.
We're just looking for a general confirmation of yes or no, whether that was accurate or not.
Okay, I think I heard the witness say yes for that specific account, but
Thank you.
no.
Yes. Looking in the next vintage in that same account, on the next vintage, which is the 1988 vintage, you show a net book value of $473,656, correct?
Correct.
And the annual accrual you propose is the same dollar amount, 473,656, correct?
Correct.
So for that vintage, you would collect, assuming your rates will be in effect for 3 years, which we've all agreed to, you would collect approximately $800,000 more from the ratepayers on that vintage than was owed. Is that a correct statement?
For that specific vintage, and again, it would go the other way on other vintages.
And that was a yes to that?
I think I said for that specific vintage, yes.
For that specific vintage, yes?
Yes.
Okay, good. If I told you in the vintages on that same table, we've talked about 2 of them, the ones that go from 1981 through 1987, if you add them up, they total over $2 million. Does that look approximately correct?
Approximately.
Okay. So for those vintages, and again, you have this, for those lines, you have the same amount in the annual accrual as you have in the net book value column, correct?
Correct.
Okay. So for those vintages, if you collect 2 million, if you owed 2 million, the ratepayers owed 2 million, and you collect 2 million for 3 years in a row, you will over collect 4 million in those vintages, correct?
Not correct.
Why not?
Because those vintages are the ones that are most apt to be retired over that 3-year period. At the time they retire, they will recover no further depreciation expense.
Okay. Do you have a second set of rates in which the rate which you recommend for this account drops the second year, or does that same rate stay in effect?
The same rate would stay in effect, but it will be applied against a lower original cost balance. And so therefore the expense will be reduced by the amount of that rate times the original cost that's retired.
Okay, so your testimony is that the depreciation rate will stay the same, but in the second and third year, it will be applied to a lower plant and service balance, and therefore, is that correct?
It may be, yes.
We have a slide loaded which shows the company filing, and then the company shows, and I'll represent this, we can show you, oh, well, never mind, we'll go to it. In your direct testimony on page 19, starting on line 19, you refer to a textbook named Depreciation Systems as supporting your specific life formula. Am I correct? You do not refer to the NARUC Public Utility Depreciation Practices as supporting your method?
The depreciation systems textbook explicitly explains the method that I use. NARUC simply provides the calculation indicating that, and I'm going to paraphrase a bit, the net book value adjusted for salvage over the remaining life of the assets. It makes no comment as to whether that should be applied to the account total or to each vintage.
Okay, but specifically it is depreciation systems that you rely on, is that correct?
Well, because it's the most commonly used textbook that explains it in some detail, yes.
On that same page 19, starting on line 21, you state that the specific formulation in depreciation textbook that you used is under the title, quote, adjustments. We can put up on the screen, well, in fact, one of your exhibits, your rebuttal to is from depreciation systems. Looking at page 5 of that document, is the word adjustments near the middle of that page, the term adjustment that you show indicates your method?
What we were referring to there, and I haven't got it, I'm reading the screen at this point, but the category called adjustments appears at the middle of the page, yes. I'm not sure if you took me to that paragraph, that title, or if you took me to the word adjustments that starts at the second paragraph underneath.
Mr. Kennedy, would it be helpful if we increase the size? Or
no, I'm actually, surprisingly enough, I'm actually able to read this.
Better than I am, thank you.
All right, going one page further into your handout from depreciation systems, there's a table 6.3. Is that the table that shows the detailed calculation method you used?
Yes.
Yes.
No, I'm just saying, Mr. Dunkel, the table that we were specifically referring to was table 6-4, which appears on page 151 of depreciation system.
All right, let's look at it. Stay on the same slide, just go down several pages. No. There's an IR response. Now, is it correct, table 6.4 is just a summary table? It does not show detailed calculations, just showing the numbers that were calculated elsewhere. Is that a correct statement?
I think I'd have to check for sure, Mr. Dunkel, to clarify, but that's a long chapter that it works through. Bear with me. I think we actually dealt with this precise question in an information request response that we're just taking a look to see if we can find quickly. I think it's actually. Mr. Dunkel, we responded to this question in response to OCC 0631, the information request. And in that information request, we go through this calculation and in some detail and resulting in the determination of that page. And importantly, we relied on the comments at page 152 following that page that gives the depreciation system textbook its opinion on the suggested approach that we would prefer.
Is the response to my prior request yes?
I'm going to need you to repeat the question, sir.
The question is table 6.4 a summary table that does not show the detailed calculations?
I will agree, sir.
Okay. Now, and of these different columns, which is the column or columns that you relied on?
It would be the information summarized in columns D and E of that summary table.
Okay. Now, the top number in column, and I can't even read it, the second column, which is E, is that number calculated on table 6.3?
Sorry for the delay, sir. You took me to the second line, the 634 cent number.
The first line, and I can't even see it from here.
It's the first line, column E is 759.10. That number is calculated on schedule 6.3. You had asked me about the second line, and
I'm not asking about the second line.
Okay, now we're clear. So it is, yes.
So the 6.3 is the detailed calculation that you relied upon. Is that correct? For the first line.
The depreciation systems relied upon in its summary of the calculations, yes.
Let's go to table 6.3.
I have it, sir.
looking at this table 6.3, there's a column named future accrual. Is that the same as what in your calculations you called net book value?
Yes.
Okay. And that again represents the total amount that has not yet been recovered from ratepayers, correct?
Yes, as adjusted for the future salvage estimate.
Okay. Now we're going to discuss how we calculate from the column that shows the amount still owed to the column of the annual accruals. In your response to, and you may know this, you may not need the response, but in this response to RRU 0477, you were asked to show your formulas you use. Is it correct that you provided an Excel file which shows that in your calculations, the way you calculate your annual accrual is you start with the net book value number, divide that by the remaining life years, and that's how you get the annual accrual?
We get the annual accrual for each vintage in that manner.
Thank you.
We then sum the annual accruals, and so you end up with a reciprocally weighted number.
Okay. So it's net book value divided by remaining life equals annual accrual, correct?
Or just to be clear, it's net book value, and that net book value, as it shows in these tables, is adjusted for the net salvage expectation or requirement. So it's the future amount to be recovered, which is the net book value adjusted for the future requirement of net salvage.
The answer is yes to my question?
Well, I just wanted to be clear, it's not pure net book value.
The answer was yes? That's how you calculate the accrual. Net book value divided by remaining life equals annual accrual, correct?
So I just want to be really clear, sir. Yes, as it's net book value is calculated on this table, which is adjusted for net salvage.
Okay, staying on table 6.3 of the depreciation systems, they'd use the same calculation, correct? They use their similar net book value column divided by remaining life gives an annual accrual?
Yeah, exactly.
Yes, okay. Now at the top of table 6.3, for some of the older vintages, the remaining life is listed as 0.
Yes.
Do you remember in school they taught us you can't divide by 0?
I do.
Okay. Well, let's see what depreciation systems did. Please look at the year 1966 vintage. Is it correct that there is a dollar amount in the future accrual column, happens to be $3.77, but it has a remaining life of 0? When depreciation systems had the problem of trying to divide by 0, is it correct what they put in the annual accrual column was 0?
Yes.
Yes. Is it correct in your calculations when you have the problem of trying to divide by 0, you did not put 0, but instead you put a number like several $1,000s?
The difference in the calculation, the one that's presented here, doesn't necessarily have the same phenomenon that we had in the account you're looking at, which was massively under depreciated. So there wasn't enough accumulated depreciation accruals to make the calculations that's done in systems. But I will agree, sir, depreciation systems displays the calculation here where they accrue 0 amounts for those pieces that are beyond the life curve of the Iowa curve.
Is the answer depreciation system says even if you have a net book value and the remaining life is 0, when you can't divide by 0 because you can't, you are supposed to put 0 in the annual accrual column, but instead of doing that, you put a dollar amount. You put several $1,000s, which you then allegedly try to collect from ratepayers, correct?
Well, I would say the example displayed in depreciation systems shows that calculation. I don't know that those words are here anyway.
I'm looking at the example. When they have to divide by 0, they put 0 in the annual accrual. When you have to divide by 0, you don't put 0. Is that a correct statement?
Well, when I did, I covered that investment over the 1-year period. Yes. The depreciation systems showed an example. And that example shows that. I'm not certain that it says that in words anyway.
Since we've all had grade school mathematics, do they have to say it in words? Look at isn't that what it says? If you have a dollar amount in the not recovered, divide by remaining life of 0, they say you have to put 0 in the annual accrual column, right?
Well, sir, I think we have to be a little bit careful when we look at this example. If you look at the 5th row down, in this example for 1970, it shows a future accrual amount of $5.09. It divides that by 0.14 and predicts an annual accrual of $36 because it's dividing by a fraction of 1. We don't do that either. So there's calculations in this example that I think that 5th column, for example, over accrues by a factor of 7, that one vintage's accrual as well, because it's dividing by 0.14, a number less than 1.
To the extent you have claimed that this is the document that supports your method, your modified method, isn't it correct that when the remaining life is 0, you did not follow what it chose?
I did not, in two circumstances. One is I would recover that whole amount of net book value in 1 year, but I would never divide a remaining life, use a factor of less than 1 to end up with a multiplication factor, as we see in the same example as well.
Is the answer to my request yes?
We have made modifications to, which are, in my opinion, as doing depreciation studies for over 40 years, a reasonable assumption that when we cover that as a remaining life of a factor of 1, and we never use a remaining life of less than 1.
Did you just say that, in fact, you made modifications to the depreciation system calculation?
I said precisely that I think in these two specific circumstances, that is not reasonable. I did, in fact, intentionally and knowingly make changes based on my many years of doing these calculations to make a fair and reasonable assumption.
All right. Now we're going to go back to one of your calculations, which is page 141.
Of your depreciation study.
Right.
I've come to the conclusion, I'm not sure which works better, the electronic version or the old-fashioned paper version.
I noticed on several of the older vintages, you have blanks. I also note that the remaining life, as you go up, you're going older. The last remaining life you show is half a year. Is it correct the ones that are blank are actually a remaining life of 0?
Or they're less than 1.
The last one you show is half a year. Is it correct as you get older, the remaining life declines?
It does, sir.
So isn't it correct all the blanks are actually 0 remaining life?
Oh, okay. I'm sorry. I misunderstood your question. Yes.
Yes.
Okay. Sir, I will point out on this page, there is a calculation on the first remaining life that you see in remaining life column is 0.5. You will note that we treated that as a remaining life of 1. And so we did not over recover the net book value in that vintage year.
Thank you. The question was, are the blanks 0 remaining life? And the answer is yes.
Well, the textbook definition is remaining life of 1 or 0. I'm sorry.
Well, using this, we're going to check your math. On this same table, we will use the line that has 36,337 in it as the net book value.
And that would be related to vintage 1926.
Okay. And that has a 0 remaining life, is that correct?
It is beyond the Iowa curve definition of what that curve would show as a remaining life, yes. So it's beyond the end of the curve.
Isn't the last number on the Iowa curve 0, 0, 0 remaining life?
Yes, it is.
So if it's older than that, isn't it also 0, 0, 0 remaining life?
For the Iowa curves, yes.
Yes, okay. Now, if you have a calculator with you and anybody else has a calculator, might join in. No?
I have a phone.
Phone will work.
I have to turn it back on, sir.
Okay.
Second. Okay.
And is it correct on this line, you have shown the annual accrual of 36,337?
Correct.
Okay. Using the accepted formula, we put in the net book value 36,337. We divide by the remaining life, divide by 0, hit equal. I would represent, I do not get a number that you have of 36,337. I get 0 and an error sign lights up. Do you agree with that? Is that what happened to you also?
That's what happens. You cannot divide a number by 0, sir. So as to be clear, and I want the record to be clear as to what we've done, is we would assign that a remaining life of 1. It doesn't show it here, but our calculations will not accept a column less than 1.
So the Iowa curve, as we've previously discussed, says the remaining life is 0, but you replace that with 1, although that's not what's shown in the Iowa curve. Is that correct?
We establish a minimum remaining life of 1 to avoid both the error message that we just saw, and also so we're not dividing numbers by fractions and coming up with a larger amount to recover in a year than the remaining life.
And by dividing by 1 instead of the real remaining life, you put dollar amounts in the annual accrual column that you now propose to collect from ratepayers?
We recovered that net book value by a remaining life of 1.
Which is not what the Iowa curve says.
Because it's beyond the curve.
All right. Go to slide 14. Slide 14. I show you data on the Iowa curve, the same one which we're using in this account we've been discussing, from the book Depreciation Systems. And the investments are getting older as we go down this table.
Mr. Dunkel, just so we're clear for the record, what page are you looking at?
338. 338.
338.
Yeah, it's not a page that was in our studies. It's a page from the Depreciation Systems textbook.
Right. Now,
Just for the clarity of the record, this is one of the fabled pieces of demonstrative evidence that was attached to our motion, just for the record. I think it's A. It's Table D.
Table D.
Depreciation
Exhibit A.
systems.
Okay.
Thank you.
Thank you, Attorney Minkowski.
Let me back up a step. You have been referring to depreciation systems previously, and you used it in your testimony. Are you aware that in that same textbook, near the back, there are some Iowa curves that are listed?
Yes.
Okay, and this, you're familiar with this existing in that book?
Yes.
Okay. Going down this table, you're getting older as you go down. Is it correct on the 100 line, it shows a remaining life of half a year, 0.5000?
Correct.
And when you go one step older, does it show a remaining life of 0.0000?
It does.
Okay. So if you went 1 year older than that, it would still be a remaining life of 0. Is that correct?
I don't think you can get any less than 0 in this case.
So it would be 0 for a remaining life of a vintage older than that.
That's correct, sir.
Okay. We're now going to look at documents for other cases. And specifically, we're going to address what they do when the remaining life is 0. In discovery response, in response to request 632.
That's OCC 632 for the record.
Thank you.
Here,
You were asked to provide some documents from other cases which you had contended supported your method. Is that what you were asked, essentially?
Essentially, yes.
Okay. And you provide several documents. I would represent, I have looked through the documents you provided, and I would represent, I never found a case where the remaining life was either 0 or blank, and they had any amount in the annual accrual column that was anything other than 0 or blank. Can you now disprove what I just said?
Might have to flip through all the pages, sir.
Sure.
So I'm going to ask you to repeat your question now that I've had a chance to look through these.
The question is, I would represent, I have looked through these documents and I did not find any document which on any line or any vintage where the remaining life was 0 or blank, that there was an annual accrual amount of any dollar amount that is anything other than 0 or blank. And please disprove, please hand me the document that disproves my statement.
I think the only time you would have seen that in these documents, sir, are in circumstances where those vintages were already fully accrued. So it's not appropriate, there's no future accrual left to recover. So in other words, if you have 0 net book value, you have 0 life, 0 divided by 0 is 0.
Is the answer you cannot show me any document in which the remaining life is 0 or blank and the number in the annual accrual is any number other than 0 or blank?
I think we need to be clear, the cases where these show zeros, there is no net book value left to recover. We don't have a circumstance in these examples where there is a future accrual number left to recover that we're dividing. So because we have no future accruals, there can't be any future accrual to take.
Is it correct that you were the one that selected these cases as the ones that support your calculations? And you were the one that selected what pages to provide in response to this discovery request. And with that great freedom, you have not been able to provide any page from anybody other than your document in this case, in which the remaining life is 0 or blank, and the dollar amount of the annual accrual is anything other than 0 or blank.
I would say that part of the reason for that, sir, it's quite a rare occasion when we have the phenomenon we've seen in a few accounts in this case, where they have very old assets and the account is so under recovered, in part because we're using the composite method for a number of years in this jurisdiction. Those accounts became so under recovered, you get this phenomenon with very old, 100-year-old assets that are not yet recovered. So in those cases, we did what we had to, and we used a minimum remaining life of 1. Very few of the cases, as we've demonstrated in these other examples, that you have that phenomenon where you have very old assets that go beyond the curve that are not yet fully recovered.
Is the answer to my prior request, yes, you cannot demonstrate this in another case?
And I think, to be fair, so we use these calculations to show the manner in which we use the remaining life. We don't have a lot of studies that have that. So we selected these to demonstrate the mechanics and the use of a calculation by vintage. And the calculation by vintage is widely used, as these cases demonstrate. Very seldom in those cases do we have a situation where the accounts are so under depreciated that you end up with a phenomenon where we have to do the calculation and use a remaining life of 1 on the assets with costs left to recover. It's a function of the method we use here, that this utility is massively under recovered in these accounts.
Is the answer to my prior request, yes, you cannot find any such example that is similar to what you filed?
There's none in this set of examples that we filed here.
Thank you.
In this response.
There was another discovery request, this one, I believe, from staff, RRU-0476.
I have that in front of me, sir.
And this request asked, is Mr. Kennedy aware of other depreciation analysts who calculate depreciation rates in the same manner as he is proposing in this proceeding? And is it correct in response you provided documents from some other cases which you selected which cases you wanted to provide, correct?
Yes.
Okay. I will again represent to you that I went through the 2,000 pages of documents which you provided, looking for the same calculation I have seen you do in this case, which is when there is a remaining life of 0 or blank, and I would represent in no case where there was a remaining life of 0 or blank did I find a dollar amount in the annual accrual column that was any number other than 0 or blank. Can you demonstrate from the documents you provided that I just made an incorrect statement?
You did not make an incorrect statement, sir. I noticed the page is now up on the screen. Again, in every case, there is no net book value left to recover when you get to that age. And that's a function of using this more refined and accurate depreciation method. We don't find ourselves in those circumstances.
Are we good on that? Okay. Going to move to a different subject here. On page 15 of your rebuttal, starting on line 15, it states, the traditional net salvage approach, as used by Mr. Kennedy, assumes that the future inflation or the future rate of inflation will be similar to that in the past. Is it correct your net salvage method effectively includes future inflation?
Yes,
Yes.
at the same rate as the historic indications are provided.
As a depreciation witness, are you familiar with the FERC uniform system of accounts?
I am, sir.
And do you agree that the FERC uniform system of accounts is the standard that applies in a regulatory utility proceeding such as this?
I believe it's the standard throughout North America, quite frankly.
Is it correct that under FERC Order 631, for certain future retirements, FERC does inflate for future inflation, but then they also take the present value of that inflated future retirement cost?
Yes, that would be commonly known in depreciation circles as a constant dollar net salvage approach.
I will also just clarify for the record once again that FERC Order 631 is one of the documents attached to our motion that the authority has taken. I already forgot the term. Demonstrative evidence. Thank you.
Is it correct in your calculations in this case, you did effectively inflate the retirement cost for future inflation, but you do not take the present value of the future inflated retirement costs?
I do not. We make the assumption that the traditional method is used as FERC allows in its definition of service value and depreciation. So the traditional method of net salvage, as it's been widely known as, is totally consistent with FERC and allowed by FERC. I've got a number of decisions from FERC that specifically allow. The FERC also provides for another calculation based on forward future looking inflation rates, where you would take your database, you would normalize everything to current dollars, which would remove the impacts of historic inflation. You then select an independent forward-looking inflation rate, inflate, and then you discount over some discount factor today. That's that approach, while FERC notes it, has been specifically disallowed in some jurisdictions, but in jurisdictions that allow it is also an appropriate method. The challenge is picking the future rate of inflation and picking the appropriate discount rate to use.
Did I hear the word yes in that answer somewhere?
I don't think you did, because it's not the only method that FERC describes.
Let's try again. Is it correct that in your calculations, you inflate the retirement cost for future inflation, but you do not take the present value of the future inflated retirement costs?
I do not.
Okay.
I don't discount it back because it's already discounted.
You do not take the present value?
Well, inherently it is discounted already, sir. I don't make a second discount. That would be double discounting.
I'm still not sure I got a yes or no. Is the answer to what I just asked yes?
Objection to the question. He's asked and answered it several times, and it's not a yes or no answer.
Would you like to be heard, Attorney Minkowski?
Not particularly. I think we have what we need in the record, so we can move on. Thank you.
All right, sustained. Thank you.
Thank you. Now, we just discussed FERC Order 631. You're familiar with that?
I am. I have not read it in a little while, sir, to be fair. I noticed that, I think, and I'm reading the screen here, I thought that was the order relating to the standard for asset retirement obligations.
Fine.
And and I do want to point out that's a very specific calculation. It's not necessarily known as a salvage calculation. It's an asset retirement calculation used mainly for purposes, largely for financial reporting purposes.
Okay. On page 3 of that FERC order, which we have up on the slide, in paragraph 5 of the introduction, if you can read it, does it say the accounting for asset retirement obligations in this rule is consistent with the accounting and reporting requirements that jurisdictional entities will use in their general purpose financial statements provided to the shareholders and the Security Exchange Commission? Does that sound like something it says?
It says that, and that's my point. So it's for financial reporting purposes, not necessarily regulatory purposes.
And is it correct that the calculations that are done for statements to the shareholders and Security Exchange Commissions are done under what is called GAAP or FAS?
Or any other recognized accounting standards, such as the International Financial Reporting Standards.
And FAS is part of that, is it not?
Yes.
Okay. Now let's look on page 5, again, at FERC Order 631. And looking at paragraph 9, is it correct that this states the only difference, it effectively states, I'll paraphrase it and you can correct me if I misstate it. Is it correct the only difference between a future retirement that is considered an ARO and a future retirement that is not considered an ARO is that for the ARO, there is what is called a legal obligation requiring the responsible party to actually perform that retirement activity in the future?
You paraphrase that a little bit much on me. I need to digest it a bit.
Well, would you explain what's the difference between a future retirement that is an ARO versus a future retirement that's not an ARO?
A future retirement that is an ARO is normally not included in any depreciation calculations. It's the ARO is separately recorded, and the accretion expense associated with that asset retirement obligation is separately put into the revenue requirement. So I think there's a very distinct calculation there. In that the ARO calculations seldom form part of a depreciation rate. In fact, they never form part of a depreciation rate. If they do, it's not done correctly. Secondly, asset retirement obligations, as you noted, are subject to the requirement to, I'm going to book it the other way. The requirement to establish an ARO is when you have a legal obligation to remove the asset.
Okay.
So it's a very specific subset, but in my experience, and again, I've been doing this for 40 years, and I've been doing this since the ARO standards came into effect in the early 1990s. One should never have an ARO calculation be inherent in a depreciation rate if you have an ARO. So you can't double count that future obligation. It's either in your salvage rates or it's in an asset retirement obligation.
Okay, on this same page 5 of the FERC order, is it correct that in footnote 8, FERC specifically refers to SFAS 143 as the source for what they are adopting in Order 631?
Yes, and sir, that FAS standard has now been modified, as you are more than aware, I'm sure.
We're now going to look at the calculation from SFAS 143, which has also been adopted, as we just discussed, by FERC Order 631. Looking at the calculation page, is it correct that near the middle of this calculation, it starts with a amount of 283,500 as the retirement cost, which becomes, and I'll round these numbers, it starts with 283,000 as the retirement cost, which becomes 419,000 after increasing for future inflation.
In the ARO calculation, yes.
Yes. And on the bottom line, after the present value adjustment, the number that had been 419,000 becomes 194,000 after the present value adjustment. Is that correct?
That's correct, sir.
Okay. So if one omitted the present value calculation, that would result in a much higher future retirement cost than if one does the present value calculation, correct?
I'm gonna get you asked that again, sir.
Sure. Let's put it this way. The present value calculation greatly reduced the number that you result with, correct?
Yes, after it's
Okay.
been specifically inflated, remembering you're starting with an inflation-free number on the very top line. So it's a very different calculation, sir. And again, it's used primarily, if not exclusively, for financial statement purposes.
Okay.
Once again, just to clarify for the record, the line of cross we just finished referred to Exhibit J, which was attached to the OCC's motion and is documentary evidence. Thank you, everyone.
Because of chemical preservatives used when UI or any other utility has treated poles, is it correct there are specific regulations which require specific certain treatments when you retire a treated wood pole?
There's various regulations for that in various jurisdictions, and they vary widely. I could not quote the exact circumstance. I will stipulate that many poles are treated, yes.
And are there, can you take a creosote treated wood pole and just toss it in the public trash, or are there regulations that prevent you from doing that?
I would suspect there's regulations, but I could not quote such regulations.
Okay. Is it correct that nationwide treated wood poles are generally treated as an ARO? That is because of the hazardous, or I'm not saying they're hazardous, because of concerns pertaining to the chemicals they're treated with?
I don't think that's a correct statement, sir.
If I would state that the Edison Electric Institute has published a list which shows items that are traditionally or normally treated as AROs, and treated wood poles are on that list, would you agree with that statement or dispute it?
Can we see a copy of the document you're referring to?
Sure. Yeah, I've got one. Somewhere.
Just a moment. Thank you, everyone.
I only have one copy. This is in my backup book.
We'll circulate it for inspection.
One second.
While Mr. Dunkel is retrieving that, Chairman Gillette, how would you like us to handle this particular document in terms of the record? We'd be happy to file a copy publicly.
I think, I mean, the company has no position at this point. I just want to make sure the witness is at least aware of what Mr. Dunkel is talking about.
Okay, let's have Mr. Dunkel provide his copy to the witnesses. And if there is no objection, we'll have OCC supplement its exhibits with a copy of that after today's hearing.
Mr. Kennedy, a few minutes from now, we will hand you a document which is from the Edison Electric Institute, Introduction to Depreciation for Public Utilities and Other Industries. And I would ask you to look at a list on the top of 138 and see if treated wood poles is an example of an arrow.
Just to be clear, for then that was an April 2013 document, correct?
That's correct.
Okay.
Mr. Duncan, I'm not sure this is the most current version of this document, but I haven't got a newer version with me, so I can't prove that. I will note that on this page, for the purposes of this document, it treats treated wood poles. Wow. As an example where you could calculate an ARO, not saying it have to calculate. And I'm just conferring with my company expert here, and maybe she can provide some clarity on what the company does with regard to asset retirement obligations.
Right. The company doesn't record any separate asset retirement obligations for this affiliate.
Say that again, please.
Sorry. The company doesn't record any separate asset retirement obligations for this affiliate. Though we have them in some other jurisdictions, so I'm familiar with the concept.
Okay, so your company does not choose to consider them an ARO?
Correct.
That's okay.
And just for clarity, for the record, by affiliate, you mean United Illuminating?
Correct. United Illuminating.
Moving to a new subject here. Looking at page 8 of your rebuttal testimony. On line 15, it states, one feature of the remaining life method used by Mr. Dunkel is that all vintages are assigned the same remaining life. I will put up on the screen, and you can refer to, it's already been pre-filed, Exhibit OCC WWD-Surrebuttal-2, which was attached to my surrebuttal testimony. Look at column D, which is the remaining life. Is it correct for the 2021 vintage, Mr. Dunkel assigned a 74.83 year remaining life?
Sir, I'm not aware that you used this calculation in the determination of your annual accrual expense. I understand this was used to develop your theoretical calculation.
You understand incorrectly. All right, let's back up a little bit. Look at the very top of the remaining life table. Does this calculate an average remaining life of 69 or 67.97 years?
Yes, and certainly I also noticed the top of your page indicates this is a calculation in accordance with the generation arrangement, not a broad group average group life calculation, as you claim you used.
All right. Is it correct in my calculations as shown in the schedules attached to my direct testimony, the remaining life I used for this account, the average remaining life is 97.97 years, and I have my schedules here if you'd like to see them.
Yeah, I'm not sure that's correct, sir.
Okay. Looking at a exhibit attached to my direct testimony, which is OCC-WWD-9, page 303, for account 360, in the average remaining life year column, column L for WDA proposal, does it show 67.97 years, which is what I calculated on this schedule?
Can I get you to just give me that exhibit number again, Mr. Dunkel?
Sure. It's exhibit number OCC-WWD-9. Actually, it's been hole punched. I assume it's 9.
Yes, I think it is. Your average remaining life, sir, is 67.97. You asked me in your question about an use of a 97.67.
I'm sorry. I apologize. Going back to this exhibit that's on the screen, is this the exhibit I used to calculate the remaining life that I used in my calculations?
I'm not sure, so you never provided the detailed calculations.
Okay.
I found it interesting that it came to the same remaining composite remaining life that we had calculated on a composite basis for this account. So it seemed to be not calculated on a vintage, but we did not have the detailed calculations to support that average remaining life.
Isn't it correct that in cross-examination earlier by the staff, you said that the remaining life that you displayed on your exhibit is not the effective remaining life you actually used?
That's correct, sir.
Okay. Fine. Let's go on. As I was saying, on this work paper, which I have previously filed and has been provided in response to discovery, when on the 2021 vintage, I used a remaining life of 74.83 years. Is that correct?
I'm sorry, which vintage was that again?
2021.
Okay. Yes, you used the remaining life for that vintage of 74.83.
Okay. And on the next page, for the 1956 vintage, is it correct I used a remaining life of 9 years.83?
That's correct, sir.
And is it mathematically correct that the 74.3 year remaining life Mr. Dunkel used for the 2021 vintage is not the same as the 9 year.83 remaining life Mr. Dunkel assigned to the 1956 vintage? I think I dropped a digit out of there. 74.83 is not the same as 9.83. Do you agree?
Sir, I agree. And I think that was used only in your determination of a composite remaining life for this account. I'm not aware that it was used for your determination of the actual accrual expense. And again,
was that supposed? Never mind.
Okay. And again, sorry, I know this is a generation arrangement calculation, and you indicated you used an average group life broad group calculation. This calculation is not in accordance with that.
Is it correct, your testimony, that I used all vintages are assigned the same remaining life, contrary to what is shown on this work paper?
If this work paper were used to calculate depreciation rates, it would be contrary. This is not the work paper, I think, that was used in your calculation.
What proof do you have of that statement?
All right. The question is withdrawn. Thank you.
Okay.
Moving to a different subject. On your rebuttal testimony, page 20, starting at line 3, the question is the practice of multiplying actual historical costs of removal by a fixed number appropriate? And your response begins, Mr. Dunkel appears to attempt to mitigate the above criticisms by multiplying the average cost of removal from the last 5 years by 2.2 times. Is it your claim that for every account, I used a 2.2 times factor?
No, I agree with you, sir. This was your your factor you used for this account, or more likely, you provided a net salvage percentage that results in this factor, and that net salvage percentage had never been indicated, or the calculations supporting that percentage have not been entered into evidence in this proceeding.
Are you claiming I used 2.2 times for every account, or is that the average of varying numbers from the numbers that varied by account?
That's true, sir. I would agree. It's the average of the numbers from all accounts.
Okay. We will show you Dunkel Direct, page 31.
I have that, sir.
Is it correct that for account 361, the last two columns shows that Mr. Dunkel's proposed net salvage annual accrual is 1.8 times the average net salvage incurred?
You're gonna have to help me with that, sir. Oh, okay. Oh, I'm sorry, for the first line, yes.
Yes, okay. And looking at the next line, account 362, is it correct that this shows that the net salvage accrual Mr. Dunkel recommended is 3.7 times the average net salvage incurred?
That's correct in your calculation, sir.
Okay. So Mr. Dunkel did not apply a 2.2 factor to every account, correct?
No, it would be on average, you applied a 2.2 factor.
Please look at page 14 of your rebuttal.
Attorney Minikowski, can you let me know when a good time to stop for our lunch break is? If you can let me know when it's a good time to stop for our lunch break.
This is fine.
This is fine. Okay, let's go ahead and take our lunch break. It's 12 o'clock now. We'll see everyone back in 30 minutes. Thank you.
Huh?
We can leave stuff here.
Okay. Okay, we got this here.
Hey, we're moving in a good way. That's why. It's always our motivation, Laura.
He's in college. He played 2 years in college. Did he really?
Oh, don't worry
Could
about
have
it.
played.
Come back.
Starting and stuff. But he was starting. He played his freshman year.
He's grabbing stuff. I don't want to leave it here.
Nichols? I didn't touch yours. It's my class.
Actually,
Yes.
It's like,
Probably know each other.
yeah, it's like a little bit on two.
Okay.
I know everybody else is like,
He was really good at high school. But my son got sort of sick of it with COVID and the amount of commitment is even for a D3 school. It's like a job. It's like 30, 35 hours a week. They want you at the gym at 5:30 in the morning. Do lifting, do all your conditioning, go to classes, then do all your different stuff. So he's to the point of with them being canceled, they want to be almost like in lockdown up there, you know. So he got to the point. He said, he's like, he goes, I'm not ever going to play pro ball. It's like not a career choice. Well, when it's no longer fun. No, that's what he said. The fun thing is losing. He's supposed to be what do you call it? He transferred to Central this year.
So my son
totally disappointed me in the sense of baseball. Oh. So he was, I'll say he was starting junior year of high school.
Yep.
I mean, kind of was rotating in and out. But he started. Senior year, he had a lock on left field. And he started with Chase Gross on high school track. Because he was fast. He's like, Dad, I'd rather run the rubber.
Yeah.
He goes, what? However many seconds. For me, it might take more than a minute.
Yeah.
But he's like, no, I just, you know, we didn't have great team chemistry. We
Yep.
had one punch.
That's so weird.
You know, it was just like, he was just like, I'm not enjoying it. Go do something you enjoy. So he ran track and field.
He's like, Coach, my son's he's, you know, finishing his last semester, I hope. Another guy's we're going back.
So now is the one. But let me tell you. Well, what? You got it. Yeah, well, this is the one though, the two just came out a long ago. Oh, okay. Oh, this is not part of the plan. Okay. You said you liked that. Voila, 60, right?
Thank you.
Oh, that's how you're asking. Never mind then. That's funny. I should have given it back and been like, oh, this isn't the right one. Take it back. Take it back. Take it back. No, I need to do work. I told her, I tell you this. Yeah. No, it's not even that. I'm right there with you. So like, okay. Well, I'm very well, thank you. Hopefully have a day I woke up this morning, got a migraine. So that was awesome. You want? I woke up this morning, got a migraine. So yeah. So now like I should probably be imaginable so that we can get rid of it. I'm crying. That is not good for us today. There was literally no one else to cover at the end of the day. But I want that here. Yeah, well, you know that. Yeah. Like, you know, does this say work? Yeah. So where's the work? This SD card right here. Yeah. So it's that whole lot. Yep. And I think I don't know. So there's two. So you have two backups. There should be a backup SD right here, and then your regular SD. But yeah, do you like it? I do. It was way cool because I had the when somebody had I had another. They had it. Nope. They had them there. I had something. Oh, but then it's that. Okay. And they're almost through. solution. Yeah, it does. Yeah, it does. Especially later on, for sure. So are we in the middle of an exhibit? Is this piece of the you know, I see that sound it's like yeah, in the flow. Yeah, yeah. Yeah, yeah. Take your time. After that, just after you did it. Oh, you're getting ready for that? I'm gonna get my jacket. Let me go to check the lunch. He's like 12:30 to 1 every day. I'm like, oh, okay. And then I came out of the bathroom and I'm leaving. I'm like, are we going to choose our going for 5:30 today? She says 5:30. I don't know about today. Section, yeah. I mean, sometimes they used to divide these things in threes. Really? Mm-hmm. They take an after the break, do they not? Yeah, yeah, most time, yeah.
Because, I mean,
A lot.
we'll see, but coming up, like the next couple of pages look okay after this.
Yeah.
So, all right.
Thank you.
Bye.
Have fun. Thank you.
I forgot to do this. Everyone was like, where'd everybody go? And I was like, all right, now it's my turn to go eat.
Yeah.
Let's do it.
Hurry up now.
How are you? Hey, 3 years no see. Seriously? Yeah.
System more sitting. We'll sit here. Companies there. And lawyers here. Okay. Now, there used to be, other staff may actually. Well, they're gonna follow us up on any questions.
Good questions.
We're just, we're questioning this afternoon. We just want to make sure we got the lay of the land.
Okay, yep. So you're with,
We're at Daymark.
oh, okay.
Working
Okay,
with
so
staff.
you'll be here when you're doing your
Yeah.
jobs. Yeah, okay.
And where would they sit if they followed up?
They, meaning,
Well,
Josh
staff is, other staff people are gonna come right after us on some of
yeah,
this.
you're gonna go, they're gonna clear out and you're gonna go here. So you're gonna be on the panel with Rich, because it's being all that, right?
Yeah, but I think we're gonna be up there just without Rich and.
Okay, then you're gonna go here. They'll
And,
clear
and,
out.
and they'll have, but will they kind of hang out back here?
They'll
Or-
probably go back there.
Oh, okay. All right, that's what probably makes it easier. I mean,
So if you have exhibits though that you're gonna want to show on the screens, Jim Riley or the lawyer will be doing it from here.
okay,
I'll be helping you.
okay, that's the.
Yeah, I'm Laura.
That's the
Lugo, by
advan,
way.
that's the,
I'm Laura Lugo, the case coordinator.
hi, John Athos.
Oh, nice to meet you, John. Hi.
I've got
Nice to meet you.
1,000 emails
Email,
from you.
that's what everybody says. They know me by my emails.
But, yeah, I haven't been in here since since you had the screens and
Oh, wow,
stuff,
that's a
so,
long time ago.
yeah.
Okay, yeah, so our staff and you will be here. The company's attorneys will be there.
Yep.
And the witnesses over there, obviously.
Yeah, I mean, I was here many times prior because I used to work for NU.
Okay.
Yeah, but that's a while ago. That's like
Okay,
25
yep,
years
then
ago.
it's the same, yeah.
But I like the furniture.
Yeah, it's nice.
I remember when they were just playing tables.
It's much nicer now, it looks more like a courtroom, so.
Okay,
Okay.
so I think we'll have plenty of room for us.
Yeah, I think I'll bring everything.
This is of no use.
Oh, this works. It does work. Testing 1, 2.
Oh, that works.
What happened? Test 1, 2. Okay. So that's good.
And I thought that was the phone.
Probably like a dual, I would say.
Okay.
Unless they'll have. Yeah.
We are.
Where we start? Schedule 5. Schedule 5.
Slide 5?
Slide 5.
What is that?
It's, starts with C-3.29.
Oh, I can't. What is that? Can I do something with this? I have to wait.
Oh, okay.
Oh, yeah. We'll be back to take it down.
They're outside if you want to take that up. I'll take it off.
You want to take that off? Yeah.
Yeah.
This one? What is that?
Right.
All right, I think we can go back on the record and we're going to resume cross by the OCC, please.
Thank you, Chairman.
Yes. In response to a prior question, you stated that with your depreciation rate, the depreciation expense might go down in future years to the extent the investment declines. I'd like you to look at an exhibit, which is one of your company exhibits, which is Schedule C-3.29, and there are parts A, B, and C. Is it correct? First of all, is it correct that when the depreciation rates are applied, the company applies them to what is then the then current plant and service dollar amounts? Is that correct?
Yes, to the gross investment dollars, yes.
And this is it correct that what the schedule shows is that in each year of your 3-year plan, the depreciation expense is increasing, which indicates you are applying the depreciation rate, the same depreciation rate is getting applied to a higher plant and service amount each year. Is that correct?
It's my understanding that the schedule is based on the projected net additions, which would include the disposals from gross investment and also future investment in those years.
So that's essentially a yes?
That's my understanding, yes, of how the
thank you.
schedule is prepared.
Please look at your rebuttal testimony, page 14. Starting on line 8, it states, Mr. Dunkel fundamentally misstates the concept of debt salvage, particularly relating to terminal retirements. Please look at your response to OCC 633. Part A asks, admit or deny that witness Dunkel did not mention terminal retirements anywhere in his direct testimony in this proceeding. Is it correct? Your response was confirmed. Mr. Dunkel does not discuss terminal retirements in his testimony. Is that correct? Okay.
That's correct.
Thank you. Now, discussing net salvage, is it correct the net salvage method you propose in this case is the same net salvage method United Illuminated proposed in the prior case, docket number 16-06-04?
Based on my review of the evidence of Mr. Robinson in that proceeding, I think it is, yes.
Is it correct that in the authority's decision dated December 14, 2016, in that prior case, the commission rejected the net salvage method proposed by the company, stating on page 46 of that decision, quote, the authority adopts Mr. Dunkel's recommended net salvage rates and net salvage factors?
I think that's what the decision stated, yes.
Is it correct that in both your calculation and Mr. Dunkel's calculation, we use the same net salvage dollar amount? For example, in the year 2016, in account 368, and it doesn't matter what the number is, but I use 152,706, and you use 152,706. Is that correct?
Yes, I would only state that Mr. Dunkel or yourselves only used the more recent vintages. You did not use an as extensive experience span as I had used.
But the dollar amount each year is the same. We both use the same dollar amount.
For those years that you used.
Is it correct? A major difference is you then divide that dollar amount by the original cost of the plant that retired that year.
That's correct, sir.
Okay. And Mr. Dunkel does not do that division.
No, and I do that. You're correct, sir. I do that in order to recognize that we are accruing today for the dollars of retirement that will occur in future years. In other words, the whole original cost of an account will eventually retire.
When the company has a construction project, is it your belief that the cost of removal or the cost incurred in that project is divided between the cost of removal and the original cost of the facilities that retire?
I need you to try that again, sir.
Okay. Let's skip that question. You should say that more often.
Yeah, I know. I'm thinking that.
There's too much levity here.
Let's go to slide 36. In your depreciation study, we're going to look at account 365, which is page 116 of your depreciation study. First of all, is it correct that the over $6 million of removal cost you show for the year 2021 is incorrect? And in fact, that's the removal cost for all distribution accounts, not for this one account?
What number are we?
I would have to further check if it's related to all distribution accounts, but the nature of why that balance is higher is because at the time that removal activities are occurring, the crews are recording their costs as removal, but we're not able to confirm which plant account that should be attributed to until we know what was actually retired. And there can be a lag in the as-built process where they come back and say, you know, this was related to poles or overhead conductor. So we make a temporary classification for our reporting purposes until we have that clarity, and then we reclassify between the right plant accounts or the final plant accounts when we have that information.
Is it correct that $6 million figure is not for this account, but all distribution accounts are included in there?
I don't know if it's all distribution accounts. I would say it is not entirely for this account. It's probably some portion of it is for this account, and I would need to follow up to break that apart into the actual accounts where it would have been reclassified in 2022.
Would you agree we should not place any weight on that $6 million figure in this account?
I mean, it's a balance in accumulated depreciation. I guess it would depend on what you were doing with it, but I can say that it's overstated as it's related to 365 because it's a temporary classification.
Okay.
Yes.
If you would look at a few of your other accounts, I think you'll see zero in the 2021 cost of removal. Is that correct? All the other distribution accounts except this one?
I just looked at a couple of them, 366 and 367, and I see zero. Yes.
Okay, thank you. On your calculation for account 365 on the year 2017 line, for cost of removal, you should have a percent you calculated of 226%. I will show you a page in Mr. Dunkel's direct, page 17, in which he makes a representation as to how you calculated that 226%, and then we'll have you either agree or correct that calculation. Is it correct in calculating this percent? You used an amount in the numerator that was expressed in 2017 dollars, but you divided by a dollar amount in the numerator that is stated in the original cost dollars from decades or years prior.
Definitely, the numerator is in today's cost dollars, or the period in which the removal occurred, and it's being divided by the original cost dollars in the period in which the asset was originally installed.
Which could be years or decades prior.
It could be, yes.
Okay. And there was a discovery request, OCC 107. And one of the requests asked if, part C, asked if the dollar amount that had retired in 2017 had gone into effect in the year, had been installed in the year 1980, then were the dollar amounts that were included in the denominator for that investment stated in year 1980 dollars? And is it correct you agreed that they would be?
That's correct, sir.
Okay. We provide a copy of the U.S. Labor Department's CPI index. And going to the third page of that, they provide, it's an index. And if you can see it, for the year 2017, which is what we agreed your numerator is stated in, is it correct that the cost of a basket of goods and services is $245.12?
Can you scroll up?
It's the last column, the year average column.
I'm going to get you to ask your question again, sir.
Certainly.
I'm having a hard time seeing the screen.
On the,
I didn't have this document.
in year 2017 dollars, is it correct the cost of a basket of goods and services is $245.12?
Do you have a printout of that?
Yes.
Thank you.
Oh, there we go. Oh, there we go. No, I do not see the 244 point. I didn't see that as a decimal place. I saw it as a comma. And I was.
While we're here, I'll point out once again, for clarity in the record, that this is one of the documents that was appended to OCC's motion for administrative notice that was ruled on this morning. Thank you.
And this is a document I am not familiar with whatsoever.
We could omit the 12 cents if you like. Is it roughly $245?
Now that I know where the decimal place is. Yes.
Okay. Okay. And is it correct in 1974, the cost of a basket of goods and services was $49 and a few pennies?
According to this set of statistics, yes.
So is it correct that the value of the dollar in the year 1974 was roughly 5 times the value of the dollar in the year 2017?
For this basket of consumer goods, yes.
Okay.
So this is why I don't always use CPI type of indexes, because it includes many consumables that have no relationship to utilities. I'm looking at inflation indexes. I try to find indexes that are specific to utility construction, or at least construction, as compared to a broad band of indexes that include things like bread and milk.
In any common index, would the dollar in the year 1974 have a much greater purchasing power than the dollar in the year 2017?
I would agree there's been a significant amount of inflation. I'm not sure I can confirm the numbers from this index to this relevant case.
Now let's move to your depreciation study. Slide 14. Okay. Is it correct in your depreciation, on page 14 of your depreciation study, you state there are 4 widely accepted methods of accounting for the collection of net salvage?
That's based on my experience of over 40 years, correct?
Is it correct of the 4 widely accepted net salvage methods, the one that you are proposing in this case generally produces the highest net salvage cost?
I'm hesitating only because I'm trying to think of the periods. The constant dollar net salvage approach or the constant dollar approach can, depending on the inflation index you use and then on the discount rate you use, get close to it. I would definitely say though, most analysis that we have done, it is the one that produces the highest net salvage rate. But when you look at it prospectively in future studies, it's the one that most often results in minor differences of what's required versus what's spent. In other words, even though it's the highest cost in depreciation expense, it more often than not reduces the issue that we see in a number of studies when we come in, that the accumulated depreciation reserve is so underfunded. And so admittedly, it is perhaps a higher cost item, but it's the most fair, in my opinion, the most fair method to recognize the future generations that are going to have to fund any under recovered reserve at that point in time.
Now, in that same page 14 of your depreciation study, you state your opinion as to which of the 4 commonly used net salvage methods is most widely accepted? And you say in North America. First of all, are you including Canada and Mexico in your statement about North America?
I'm including Canada, sir. I am not sure about Mexico.
Okay. On the attachment to your resume, is it correct that you show one page in which you have cases, you have evidence entered into the proceeding in the United States, but 6 pages in which you show evidence entered into the proceedings in Canada? Is that correct?
That's correct, sir. And you notice most of those US cases are within the last 5 years, 6 years, I guess.
Okay.
Where I've been much more active in the US since my connection with Concentric. And prior to that in Gannett Fleming, around the Gannett Fleming Canadian office. So I was very involved in Canada, although I did assist the Gannett witnesses on some matters in regard to US cases when they required assistance. But I did not sponsor testimony.
Please look to our data request OCC 414. In this, we asked, in the northeastern United States, is it correct that the state utility regulatory commissions in New Jersey, Delaware, Pennsylvania, Maryland, and the District of Columbia generally do not accept the net salvage method, which is the method you're proposing in this case? And the last sentence of your response is, Concentric is unable to confirm or deny the net salvage recovery methods used in Delaware, Pennsylvania, Maryland, and the District of Columbia. Is that your response?
It is.
Okay. So is it correct that in 80% of the cases we asked about, Concentric or you did not know and was not able to determine what net salvage methods are accepted in those jurisdictions?
In those specific 4, we weren't able to confirm.
Okay.
So we stated the response based on what we knew, and that's the case. I will confirm that there is many states that accept the traditional method.
All right. Now, looking at the first 2 sentences of your response to this request, the first sentences are not confirmed. The state of New Jersey Board of Public Utilities accepts and uses the traditional net salvage method. For example, in docket number DR 18080925, Atlantic City Electric Company was awarded an overall rate of 16% net salvage applicable to all capitalized costs. Was that your answer?
That was my answer, sir.
Well, let's look at the traditional method, as you call it, that New Jersey uses, and specifically in that case.
And I will interject for the record once again that this is one of the documents attached to our motion for administrative notice.
We are showing you pages from the depreciation study and testimony filed by Atlantic City Electric Company witness in New Jersey in the docket number of the case that you provided, or you discussed. Looking at the last page, in a minute. Should be slide 35.
That was where we printed out.
No. Oh, you got it? Okay, last page.
Okay, can I just, for the record, so would this be Exhibit C on OCC's exhibit list?
That's correct.
Okay, and is it the full testimony or only excerpts of that testimony from that case?
I have provided excerpts.
Okay. All right, I think, well, let's see how this goes. We may want to ask the full, be put in. Thank you.
In what you have termed the New Jersey quote traditional unquote net salvage calculation, is it correct that is shown on this last page? So one more page we can go down? One more. One more. One more. There we go. That's it. Is it correct that what the company witness, not your company, but the company witness in that case filed was in fact showing the cost of removal and salvage, which is how you calculate net salvage, for each of 5 years, and then took the average of those 5 years net salvage dollar amounts and did not divide by the dollar amount that had retired those years. Is that a correct statement?
It's what that witness filed. My understanding of that docket is Mr. Alice, who was the depreciation witness in that proceeding, spent a significant amount of time in his evidence describing he preferred the use of the traditional method, and the company had directed him to file on this basis, and that in future applications they will be seeking approval of the traditional method.
So the question is, what the company witness filed was the 5-year average of the incurred net salvage over the last 5 years, not divided each by the dollar amount that had required that year, correct?
That's what he filed at the direction of the company. His evidence stated he preferred the traditional method in that case.
Okay. I show you one of Mr. Dunkel's work papers in this proceeding. And it's already been provided in response to discovery.
And it was provided in interrogatory. Are you 548?
And here again, Mr. Dunkel is looking at the net salvage dollar amounts for the last 5 years and took an average, also not dividing by the amounts that retired those years. Is it correct that Mr. Dunkel's work paper in this case is much closer to the work paper in New Jersey than is your work paper in this case?
I had no work paper in New Jersey, sir.
You had no work papers in this case?
In New Jersey, he asked me about.
Okay, let's start over. Is it correct the work paper in New Jersey filed by the company is much closer to the Dunkel work paper in this Connecticut case than it is to your work paper in this Connecticut case?
It's, again, I think I noted this before, Mr. Alice, when he calculated the rates that were ultimately part of the application, which I note, sir, was settled by stipulation, so we're not sure that what the commission viewed, but that case was settled by stipulation. In his study, he did include a I don't know if he included this calculation. Okay, Ms. Norrie's telling me he actually did, because she went back and read this last night. So his paper there at the direction of the company included this style of calculation. But again, I stress that Mr. Alice in that case was very specific about asking the board or telling the board in his testimony that he would be seeking a traditional method of net salvage for Atlantic City in future studies.
Is the work paper that this company witness filed in the New Jersey case closer to Mr. Dunkel's work paper in this Connecticut case than your work paper in this Connecticut case is? That's a yes or no.
Could you be more specific, Mr. Dunkel, and which work paper are you referring to from the Alice testimony?
The one that's on the screen.
That's from this case.
I think that's your work paper that's on the screen.
Okay,
That one that's on the screen.
We'll go
Okay.
back one. Did
Okay.
you go back one? Yes, there we go.
Okay.
That's the one from New Jersey.
Okay.
Which does not divide by the dollar amounts that retired that year, just as my work paper in this case does not divide by the dollar amounts retired, but Mr. Kennedy's work paper does divide by the dollar amount retired that year.
And so notice this schedule you had on the screen was table 2. There was a table 1, if memory serves me correctly, that actually does it in the same method that I did.
Do we have an answer to the question?
Well, I'm not sure that I've seen. I'll answer it this way. I will agree that in that case, it appears the normalization method or the method that you're using was ultimately used by the company. I'm simply saying that that was not Mr. Alice's prime choice.
All right. Moving on. Slide 37. Let's look at another case, which in fact you provided.
And just for reference for the record, this was provided in response to RRU 476.
In discovery request RRU 476, you were asked to provide work papers that supported your method, and you got to choose whatever state you wanted to file them from. And is it correct, one of the 4 cases you provided in response was a testimony filed by Mr. Wiedmeyer on behalf of UGI Utilities in a Pennsylvania case? I can give you the docket number. Docket R-217-264-0058.
Spirit this for 1 minute while we pull that up from in our work brief. Just have here. This world of electronic documents, I'm having to look at 3 different computers to find what I need. Yes, I do have that in front of me.
Okay. Now we'll go to the last page of the slide that we've copied out. Here again, this was as filed by the company. Does this show that they are using the dollar amount of cost of removal and the dollar amount of gross salvage, and the difference between those is net salvage, not, and I believe they averaged over 5 years, not divided by the dollar amounts that retired those years?
I get to use the other computer. So the question that was asked in RRU 476 was specific to the life calculations, not to the salvage calculations. In fact, if you read the question was referring to the generally to the issue of the appropriate depreciation rate formula to use in this case. Mr. Kennedy is aware, et cetera, but specific to the life piece, it did not deal with the specifics of the salvage piece. So we were providing evidence in here to speak to the issue that we were talking about earlier this morning about the depreciation rate calculation. And that's why this document was provided.
Are you saying that in looking at the life data, you inadvertently filed the work papers, company work papers, and study from a case that in fact is consistent with my method, but you didn't mean to do that?
No, not at all, sir. I strongly believe in transparency. If I'm going to file a document, I'm going to file the document as complete as possible, such that I don't get accused of picking and choosing what I like in the document. That document supported our position on life. I bet it may have supported your position on salvage, but I don't play games, sir. I'm going to put in the record the complete documents in the issue of transparency.
When you selected this as a case, since you had a free choice, when you selected this as a case to provide, were you aware that the calculation in this case is much closer to what I do on net salvage than what you do?
I think we were just focused in this case on providing evidence that matched our depreciation rate calculation. Had we noticed this, we probably still would have put it in because we were answering a question in support of our rate calculation. If I wanted to play games, sir, we would have left this out. I don't do that.
Is it correct that this calculation in the Pennsylvania case, which you selected for perhaps other reasons, is much closer to Mr. Dunkel's calculation in this Connecticut case than it is to your net salvage calculation in this Connecticut case?
I would agree seeing this, yes.
Okay.
But again, we provided that in response to a question concerning life.
On page 20 of your rebuttal testimony, starting in line 11, you say, the other foundational depreciation text, depreciation systems, is similarly clear in support of the use of cost of removal divided by historical retirement dollars to calculate the salvage ratio and as the basis for net salvage estimates. Is that a statement you made?
Yeah, thank you, sir. Although you mentioned this is page 20 and I couldn't find this at page 20, it's actually at page 18.
What page is it?
18.
Page 18, yes.
Can I get you to try your question again?
Okay, are we good? You found it?
I found it now, yes.
Okay, good. Is the term salvage ratio a name for the net salvage method you propose in this current proceeding?
The term salvage ratio would reflect this method that we use, in other words, the salvage ratio, the cost of the net cost of salvage as compared to the original cost dollars being retired.
So is that a name for the method you use or you propose?
It's a component of the method we use, okay. Yes.
And on line 17 of that same page, you have a quote from depreciation systems. And is it correct that in the middle of the quote, it discusses, quote, constant dollars, unquote?
It does.
Okay. Is it correct that the term constant dollars means you use an inflation index such as the CPI or some other inflation index to convert all dollar amounts into dollars of a common year?
So, sir, I'm just reading the sentence above where you were. The quote includes the statement, and I'm not sure if I agree with you or disagree with you at this point. So the quote above it says, if the cost of the replacement when measured in constant dollars is equal to the cost of the first unit, then the replacement cost measured in inflated dollars is etc. So I'm just trying to determine if that.
Do you know what the term, the question is, do you know what the term constant dollars mean?
Or a normalized, constant dollars would be a normalized dollar to both components of the equation, such that the numerator and denominator would be in the same dollar cost.
You would use an inflation index to convert all dollars into the same value of dollars. Is that correct?
Well, you may inflate one or you may deflate the other, but you get them to the same cost base.
Okay.
Yes.
We will show you pages from the end of the same chapter of depreciation systems that you were quoting, but a different page, the last page. Please look at the last paragraph of page 61 of depreciation systems. Does it say, quote, "A first step in salvage analysis is to convert the observed dollars to constant dollars"?
Yes, and that's in a chapter called Conversion to Constant Dollars. So obviously, it's going to convert to that. Now I also know.
Is that the name of that chapter?
Yes, it is. It says Conversion to Constant Dollars at page, the section. At page 60, the heading occurs under a section title.
That's a section title.
Okay, yes.
Okay. Is it correct statement that in your calculations, you did not convert observed dollars to constant dollars?
We do not. And I note, sir, that if you look at the words that you have up on the screen right now, it says it's a first step. The question is, what's the next step? And that's described, strangely enough, this book is written in a manner that it puts the second step before the first step. Why? I'm not Dr. Finch nor Mr. Wolf. And in the first step, back at pages 52 through 53, it talks about doing what we did in the traditional method. In other words, including an inflation factor. And it includes the quote, pages 64, 53 to 54. At page 53 and 54, it describes using a salvage ratio. And it describes the fact that if the historic rate of inflation can be assumed to be similar to the future rate of inflation, and if the historic life characteristics can be assumed to be the future life considerations, the use of the traditional methods are appropriate.
Okay, I think you answered that you did not do a conversion to constant dollars, correct? Okay, no. Thank you. New subject.
Well, I'm still on the old subject. I did what was consistent with pages 53 and 54 depreciation systems.
Okay. Turning to page 17 of your depreciation study, starting at line 7, and reminding us all that you are from Concentric, a firm named Concentric. Does it say, quote, "While Concentric believes that a net salvage ratio of up to negative 100% may be warranted, in the interest of gradualism and moderation, Concentric recommends a stepped-in increase be utilized for this account. At this time, Concentric recommends that a negative 20% net salvage estimate be used in the depreciation calculations within this study." Is that your statement?
That's my statement. I'm going to ask Ms. Norrie to speak to that piece. Ms. Norrie prepared that section of the study.
Okay.
Yeah.
Is it math? No, I'm sorry. Is there a question out you're answering? Or?
No, I was just
okay. All right. Well, I have a question for you then.
All right.
Is it mathematically correct that everything else equal, a depreciation rate calculated using a negative 100% net salvage will be a higher depreciation rate and higher expense than a depreciation rate calculated using a negative 20% net salvage?
Were that to have been our recommendation, yes, that would have been higher. However, our recommendation was negative 20%.
Thank you. So is it correct that if this commission were to change to the net salvage method you propose in this case, which is the method that produces a negative 100% net salvage, then the depreciation rate you filed in this case, which uses a negative 20% net salvage, does not show the full impact of converting to the net salvage method you propose?
No. That's not correct, no. Negative 100 would be an appropriate number for this account. However, changing methodology does not obligate us to go to negative 100. In the next depreciation study, we will look at the circumstances at that time If there is a further need for an increase, we will come before the commission at that time. However, at this stage, -20 is the correct number.
So everything else equal, if the commission selects your method, and let's say the world doesn't change a whole lot, you would file the next case with numbers that say you're entitled to a -100% net salvage. And although you might, out of the goodness of your heart, not ask for that full amount right away, you would have proof that that was appropriate, assuming this commission in this case accepts your method, correct?
No. I would say in the future, the next study, we will look at the circumstances of that study. Even if we have the same math, I would never go to the commission to ask for an increase from -20 to -100. That would be preposterous. I would continue to select the correct net salvage ratio at that time.
So if this commission adopts this method, it might take a few cases before you get up to the full impact of the new method, correct?
And so, Mr. Dunkel, I think the important part here is as we look at large step changes, -20 to -100, we recognize that has a massive rate increase and it has a massive impact on customers. And one of the things that we really would always suggest is to take these things in moderation. The worst thing is if we would move to -100, the next case comes by and we say, gee, 5 more years or 3 more years down the road, that -100 was impacted by some things that have not continued. So the trend didn't continue and maybe we only need -50. Well, we've now massively over-collected on the backs of the customer. So one of the things that we do, one of our overriding principles is we treat big step required changes over multiple studies, always ensuring that the trends continue to show in future studies the path that we've started on. So we give ourselves a chance that this may be an anomaly for the last 5 or 6 years, and so we don't overstep that. We want to ensure that the customers it's a fair treatment to the customers. In such case, it's a moderated step. If in this next study we still see a need for -100, we'll probably take another small step. And at some point in time, yes, you will eventually need to get to where you need to get to, but it will be over multiple studies rather than any next big step.
Turning to page 21 of your rebuttal, starting in line 3, you make a similar statement, which is there are some accounts for which the data indicates a far more negative net salvage rate would be appropriate. In future studies, if the historic data continues to show that a more negative net salvage amount is correct, we will recommend a further increase. Is that your testimony? Or we may recommend, we may recommend a further increase.
Yeah, that's, I was going to take exception to that.
Okay.
And so, yes, I mean, we'll look at the facts and circumstances at that point in time and take a reasoned approach to the implementation of rates that we think are appropriate.
Is it correct that the further increase you may recommend is based upon the assumption that the authority in this case will accept and adopt your net salvage method? Is that the assumption that leads to those possible further increases?
Well, that'd definitely be, I think, a pretty key fact. But if the commission or the authority here decides to not adopt our approach, but we continue to see a need of increasing salvage requirements, we may come back again. I'm not sure. We'll have to look at the facts and circumstances at that point in time.
And when you discuss the possibility of needing further increases, as the quote data indicated, the data, is it correct? The data you are referring to is the data produced by your calculation in which you divide the dollar amount in the numerator that's stated in recent dollars by a dollar amount in the denominator that's stated in dollars from years or decades prior.
Certainly, because we always are going to be retiring an asset. It's not brand new. It's got some age to it. So you always are going to have a retirement cost in today's dollars, and you're always going to have the asset that's being retired to be in somewhat an older cost.
And the data that could possibly lead to future increases is data that has been processed in the way you want to process it, correct?
I'm not sure what you mean by processing.
taking a numerator that's stated in recent dollars divided by a denominator that's stated in dollars from years or decades ago?
That would likely be what we would bring forward. We also may look at other options. Maybe we get to a point in time, as we do with assets that become very aged, often we will look at a different approach, i.e. sometimes we will look at lifespan approaches. We will get hard cost estimates and use those. So I do think, given this company, in 3 years, we'll probably be recommending the approach that I've recommended here.
And if the commission does not change to the net salvage method you want, that would remove the foundation for your future increases, correct?
Well, my suspicion is if the commission continues to do that, we will be seeking very large increases to the depreciation rate because we will be significantly under recovered.
And you have no, that's your opinion, correct?
That's the opinion I've seen based on a number of studies. You put a study before me a few minutes ago from New Jersey where they are about $60 million under recovered for a variety of reasons. And
do you have any data to support that number you just gave us?
I think, well, but there's a, I'll restate my answer. They noted in their study that they were significantly under recovered with regard to net salvage.
Who noted that?
Mr. Alice in his testimony.
The company witness?
Yes.
Okay, thank you.
And so I'm just saying that's the phenomenon we get to. But depreciation expense will greatly increase. And that's the risk.
Thank you very much. I have no more questions.
All right, I'd like to thank the witness panel for their time and their testimony this morning. The Office of Consumer Counsel has no further cross at this time. Thank you, Chairman.
Thank you. Okay, let's proceed with our list here. So Attorney Thompson on behalf of NECTA, any cross? I'm sorry, it was Attorney Suter. Suter's listed differently on here.
Chairman, it's very no cross.
Okay, thank you. Thank you. Attorney Bidra. Thank you. Attorney Wyman. Thank you. Attorney Venora. Oh wait, I'm sorry. Commissioner Karen.
No, Madam Chairman.
Mr. Vice Chairman. I also didn't have any questions for this panel. Attorney Venora, would you like a moment to consider redirect?
Yes, if we could. We'll step out in the hall and confer. And be
sure.
ready.
We will recess for 5 minutes.
Hey, where did they come back? Cross on it? Okay. Good job running the slides too. You kept up with me. I was trying to test your slide speed. My slides. Yeah. No, that worked.
This is that one thing, I had actually turned on a different page. So I was ahead of me. And we were it's just. Oh, no. For 12, yeah. Right. I enjoyed it. Years, decades ago, I was with redirect. And and they didn't say they would have their yes. So we would go into the hearing, just the witness would sit there. We did our own philosophy of the party. We do our own objections. It's not like, oh no, we're amateur attorneys. They would let us do that. Sort of like jury. Yeah.
Yeah, I think it might be. Only 30,000.
I'm almost guessing we don't.
I know.
Yeah. They come up with something outrageous, I might.
Well, sometimes.
But it's way better than the old business.
Oh, I see.
Had a hearing, each day that we would have to update. After this, the next day. When they changed that, I was like, thank you. Yeah. Yeah, and it's like, what are you supposed to do?
My wrong spot. Doesn't matter.
I know it's SOB.
Yeah.
Thank you, Attorney Venora. Any redirect?
Yes, we just have just a few questions on redirect. Starting out with Mr. Kennedy, do you recall the discussion with Mr. Dunkel regarding the various net salvage methods?
I do, sir.
And is it correct that Mr. Dunkel's net salvage method, in your experience, is used in very few states?
That's my opinion. By far, the traditional method is used throughout North America by most regulatory jurisdictions. The normalization method, I'll call it the normalization method to put a title on Mr. Dunkel's testimony, is used in a few states. I won't say it's no states. I imagine it's 5 or 6 or 7 states throughout North America, or jurisdictions throughout North America. The traditional method is used in many, many more. So it's far more widely accepted and used than the normalized method.
Okay. Thank you. And do you also recall the discussion with Mr. Dunkel regarding asset retirement obligations, or AROs, and SFAS 143?
I do.
And in your experience, do electric distribution companies have AROs for electric distribution assets?
Based on my review of a number of distribution companies, I don't think I could think off the top of my head of any that have an ARO on distribution assets. And there's two kind of key reasons for that. One, the asset retirement obligation requires two things. One, it generally requires a legal obligation to remove plant. Secondly, it requires an ability to calculate an end date. And to the extent that distribution systems tend to have an ongoing entity assumption, in other words, if you retire some poles, you're going to replace the poles. You don't really have an end date to the world of poles. They're going to be replaced over time. And without that end date, you cannot make the asset retirement obligation calculation because you have no period. You need to have a distinct period to inflate the assets and to discount the assets back. So without that distinct end period, few utilities can make a reasonable assumption of the end life of those assets. Therefore, they don't calculate asset retirement obligations. Like I say, I see them on assets such as generation equipment. We see them on some transmission lines. We see them on pipelines, but we don't see them on electric distribution assets. Like I say, in my experience, if at all. And I think that's consistent with the Avangrid group of utilities as well.
Okay. And lastly, Ms. Nouri, do you recall the questions from Mr. Dunkel? He was asking about one of the accounts in your study where you applied a moderation to the results with respect to the negative 20, applying a negative 20%, whereas the study would have indicated a negative 100%. Do you recall that?
I do, yeah.
And what was, again, was that done through a number of accounts in the company, in the study?
It was. We applied the same methodology to a significant number of accounts.
Okay, and what was the purpose of doing that?
Ultimately, we want to ensure fairness both for the company itself and for customers. And in order to ensure that, we applied a process of moderation where possible.
Okay, and moderation would we think about that in terms of like gradualism? Is that how you think?
Exactly.
Okay, thank you. That's all we have. And Chair Gillette, I can also report just for planning purposes, the company will not have any cross of Mr. Dunkel.
Very good. Thank you. All right, thank you to this witness panel. You're excused.
Thank you, Madam Chair, for the opportunity to.
Thank you. Very good. Then we will transition to our second panel of depreciation of the Office of Consumer Counsel. And having waived cross from the company, we will begin cross for this panel with the authority staff after we go through the administrative matters. So I will ask OCC's counsel to approach the attorney stand and for authority staff to approach the cross-examination table, please.
Stand.
I get every table?
Very majestic.
Okay, and Attorney Minikowski, when ready, well, we've been introduced to your witness, so I'll swear him in before.
Do you mind if I sit at that table for a minute? I just want to make a complete circle here.
Okay, Mr. Dunkel, if you can raise your right hand for me, I'm going to administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you. Attorney Minikowski, pre-filed materials.
Your button on, by the way, should be green.
I'm sorry.
Your button on should be green. Base.
The button on the bottom, Mr. Dunkel. Hello?
Yes.
Yeah. There we go. All right, thank you, Chairman. Mr. Dunkel, could you please state your name for the record?
My name is William W. Dunkel.
And is it correct, Mr. Dunkel, that you filed testimony and rebuttal testimony in this proceeding on behalf of the Office of Consumer Counsel?
Yes.
And do you have any corrections or edits to that testimony at this time?
No.
And do you adopt that pre-filed testimony and pre-filed rebuttal testimony as your sworn testimony here today?
Yes.
Mr. Dunkel, is it also correct that you sponsored certain interrogatory responses on behalf of the Office of Consumer Counsel in this proceeding?
I provided drafts for responses. They go through the attorneys, so I don't know if they went out word for word, but I provided certainly input to some responses.
And Mr. Dunkel, do you have any edits or alterations to those responses at this time?
No.
And do you adopt those responses as your sworn testimony here today?
Yes.
Thank you. Chairman Gillette, the witness is prepared for cross-examination.
Thank you. Very good. We will start with cross from authority staff. Mr. Garrett, please.
Good afternoon, Mr. Dunkel. How are you doing?
Very good.
I think these issues of depreciation methods and net salvage have been covered quite a bit today. I do have a few more conceptual kind of follow-up questions based on OCC's cross of Mr. Kennedy. I'm sure you recall, since you were the one asking the questions, but going through an exhibit of Mr. Kennedy's calculating remaining life, and you had some questions for him about instances in which whether we could divide by zero and having an accrual amount when there's no remaining life for a particular vintage. I guess just conceptually, if those types of issues were addressed, would you have a disagreement otherwise with that, the type of calculation that he conducted for remaining life?
There's two questions there. When we get a study, we take the inputs that the other party has used and we run them through our program. And immediately what popped up is the depreciation rates that our program calculated were different than his, and so that flagged to us there was a problem. So at that point, we went ahead and just did it correctly. Now, we've proven today he's triple recovering on some amounts. Whether we took that one problem out and then he would be fine, I don't know, because once you are proven his calculations are invalid, I bill by the hour. I can't then say, well, I have now spent a week finding 6 other problems. Once I have decided he's not doing it correctly, he's triple recovering or quadruply recovering, depending on how long the rates are in, I just set that aside, knowing the same witness that would do that probably did other things, but I'm not going to bill my client to guess whatever, to dig out whatever else they did. Once I know the study's bad. If it's bad, it's bad. You set it aside.
So when you say run the numbers through your program, do you, in other cases in which you work, do you run into a similar situation where you put the other witnesses' numbers in your program and you're seeing the same problem?
No, it's really just a formality normally. If you have the same net salvage, the same remaining life, the same plan and service, the same depreciation reserve, you put it in my program, it'll produce the same depreciation rate the company filed in 99.9% of the cases. This is one of the few cases where you do it and, I'm using the same remaining life, same net salvage, same, everything's the same, and he gets a drastically different answer. No, that does not happen. Just like I've never seen these things where you divide by 0 and you get a dollar amount. This is the only case I've ever seen that happen. And my answer is run.
Okay. Do you recall, and I'm sorry, I don't have the exact discovery question, but where Mr. Kennedy, they had produced from other cases examples of similar other witnesses who had conducted a similar type of calculation, and I think you'd said something along the lines of there were thousands of pages and you went through them all. Were you the witness in at least some of those cases for an intervening party?
I don't know. I didn't really pay that much attention. What I did is I flipped through the documents he provided from cases he selected to see if I could even find one page that looked like what he did in this case, and I did not. Everybody else in the world, when they divide by 0, does not get a dollar amount like $10,000. He's the only one I know in the world that does that and gets a dollar amount.
Okay. Thank you. I have no further questions.
Okay.
Mr. Capozzi?
I just have a few questions. Thank you. You'll have to forgive me. My knowledge of the terminology is a little lacking, so I'll probably use layman's terms. So please correct me if I'm misstating something. But
right, could you lead into the microphone a little bit?
Yeah, sure. Sorry, Steve Capozzi, Authority staff.
Okay.
So my first question, our first couple questions are about the salvage ratio method. That's the correct term?
Yes, that's the correct term.
And that was the methodology used by in Mr. Kennedy's study?
Yes.
Okay. And it's fair to say you oppose that methodology?
Let me, he qualified that. He says that's part of his method, but that is a common description of what he's doing, yes.
Okay. In that methodology, actually, let me take a step back. If we're calculating a depreciation rate, the purpose of that depreciation rate applied to a specific account is to do two broad things. One, recover the remaining initial investment, and then to recover salvage costs.
That's correct.
Okay. So when you're doing a study at a point in time, sort of a snapshot, are depreciation studies essentially snapshots? Is that fair?
Yes. The depreciation study uses the investment and the plant and service at a certain point in time, looks back we look at historic data, both for life and net salvage. And you look back from that point in time back on historic data. So yes, it's a snapshot.
Okay. So if I'm trying to recover one part of that rate, I'm trying to recover the initial cost for each account of the plant. That initial cost is a known quantity, right? Is that correct? Okay. What's unknown is essentially and sort of the purpose of the depreciation study is to determine the best estimate for the remaining life of all of those pieces of infrastructure in that account.
One of the unknowns is when they will retire. And what you do in that case is you look at historic data. How long have they been living, essentially? And then you assume normally, however long the historic data shows they live is what you will expect them to continue to live, unless there's something, change, something has happened that would change that. But that's sort of the starting assumption is, if historically the data proves they live 50 years, then you would assume that going forward they will live 50 years, unless something has happened to change that assumption.
Okay. And now with salvage or negative net salvage, there's what are we doing when we develop the negative net salvage percentage or ratio? Are we, I just need a moment to think how I'm going to phrase the question. For each account that you're applying a specific depreciation rate to, incorporated into that depreciation rate is some factor to account for the negative net salvage or salvage.
Right. As you said, we have two goals in depreciation, and sometimes they are even filed as different rates. You have one rate that is trying to recover the original cost by the time it retires. Your goal is to have it paid off the day it retires. I mean, basically, that's the idea. The other is when they retire the plant in the future, there is a very good chance that the cost of removing it will be larger than the salvage they get from it. Even if they get some copper, it's more likely the labor will cost more than the copper was worth. And so you also collect from ratepayers an allowance for that future cost. You don't know what that future cost will be, but again, you look at historic numbers and from there make an estimate, but it's only an estimate. Okay. That's one thing you have to understand. There's no precise number, precise calculation. It's basically an allowance. We think current ratepayers are using this facility to their benefit. It's going to cost something net in the future to retire it. So you should take a reasonable amount of contribution from the current ratepayers, put it in the reserve, depreciation reserve, which it remains there. And when the company actually retires that item, they take the money out of the depreciation reserve to pay for the net salvage cost.
Okay. So you anticipated my question a little bit. So with the depreciation rate, the remaining life, there's really only one, and it's more complicated than this, but there's one unknown. It's essentially the remaining life. With the net salvage, there's more than one unknown, which is the remaining life still is an estimate, but also the future cost is an estimate. Okay. So that was my question. Now, when a company is retiring and incurring costs to retire old infrastructure, the cost to do that is that is now somehow built into the old accumulated depreciation. Here's what I'm feeling with my terminology, but they take that actual cost, those known costs to retire, and now incorporate it into the account, and that cost now needs to be depreciated? Is that how it works?
No.
Okay.
What happens is when we establish a depreciation rate, or the commission establishes a depreciation rate, that gets charged to the customers as a part of their bill. So they collect the money from the customers from the depreciation rate. It's put into the depreciation reserve. That's where it all goes. All the depreciation expense or the money collected from the customers goes into the depreciation reserve. It then stays there until the company actually retires the facility. When they retire a pole, for example, if the pole has an original cost of $1,000 and they've got $1,000 on plant and service, they will eliminate that $1,000 from plant and service, and they'll also take $1,000 out of the reserve. That's ratepayers' money will be used to pay off the $1,000 plant that just retired. That's one part of it. They will also have collected from the ratepayers money for the future cost of removal. That also goes into the depreciation reserve. And in the future, when the company retires that pole, the cost of removing it, their labor, et cetera, is taken out of the reserve. That's the double bookkeeping. That's the payoff. If it's cost of removal net is $200, they will take $200 out of the reserve. It's a hair more complicated. They do the cost of removal and salvage separately, but it's the same thing. If the actual cost of removal is $200, you take $200 out of the reserve.
And so the reserve, if there was some discussion earlier about a potential under recovering based on depreciation rates for certain accounts, the reserve is how you determine whether you're under recovering, sort of what's in the reserve, or how are you determining what?
Over the years, you track the depreciation reserve, and it's usually tracked as a percent of original cost. And if it's rising, if the percent reserve is rising along with, compared with the original cost, it doesn't prove anything, but you start wondering if maybe your depreciation rates are too high. And that alone is not evidence, but it's a hint to start looking closer. If the percent reserve compared with plant and service is declining over time, then again, that's a hint that maybe there's a problem that you should look a little closer, that maybe the rates are too low.
Okay, thank you. And when you're determining the salvage ratio, using the salvage ratio method, or some variation on that, you are looking at the total, so for a specific account, you're looking at the total value of the plant installed. And you're looking at the amount you've incurred to remove those facilities when they've been retired, for that account. And you're dividing one by the other. Is that how it works?
What I do and other states do, as we've seen on the screen today, is you look at what the actual costs of net salvage have been in recent years. For example, if 5 years ago in this account, the company spent $5,000, and 4 years ago they spent $6,000, and this year they spent $7,000. And now what you're trying to estimate is what they're going to spend for net salvage in the future. And you go from that. I look at I look at the last 5-year average, I look at the last 10-year average, I look at the last 3-year average for every account. And what I'm looking for is I don't want to make a decision based on one fluke year, either high or low. So that's why one reason I look at the 10-year average. And then, New Jersey, the way they do it, they do the 5-year average and they make the assumption that the net salvage in the future will be equal to what it was in the last 5 years. And that there's no judgment. That's why they do it. I just say, well, whatever the average is we've spent for the last 5 years, that's what I'll assume we'll spend in the future. What happens, of course, is in the real world, costs tend to increase over time. And so what New Jersey does is they will have a true up. In the next rate case, they will look back and they say, here's the amount we collected in the last 4 or 5 years, whatever it was between cases, that we collected from the ratepayers for net salvage. Here's the amount that was costs that were incurred, how much we actually spent. Usually, because they were sort of looking back, they have not collected as much as they actually spent. So then they do a true up. In that case, they will take that difference, the amount they under recovered, and add it on, amortize it over the next several years, collect it from the ratepayers. That's one way to do it, and it eliminates the question of, well, you don't do any judgment. That's fine. I prefer, knowing from experience that the net salvage costs tend to go up over time. I prefer to select a depreciation expense that is higher than the historic number. So that you're not only, because first of all, it's going to be that, but that way the current ratepayers are in fact collecting money, putting money into the reserve, growing the reserve so that there will be money in the reserve in the future when the company actually retires the facilities. And I'm sometimes pretty generous with that. I think they had said my average was 2.2 times. So whatever the company has been actually spending on net salvage in the last 5-year average, I'm recommending we collect 2.2 times average, all accounts average from the ratepayers for that. So that's a very generous allowance for inflation, growth, or whatever you want to call it.
Okay, thank you. Do you recall what increase you recommended in the prior rate case with UI?
No, not offhand.
Okay, and the salvage part of the, so if we're talking about the salvage ratio method again, you're also sort of assuming you're part of what percentage you want to recommend, whoever's following this methodology, they're forecasting future, they're making a guess or forecast on future removal costs, right?
Well, I don't really use that method, so I can't really say. I think we've had an admission from Mr. Kennedy that they are incorporating future inflation, assuming future inflation is the same as past inflation. So they're including a huge amount of future inflation. Now, let's talk about that. Future inflation means the future dollar will be worth less than today's dollars. So if it was going to cost you $10,000 to remove something today in today's dollars, if we assume future inflation, it'll cost 20,000 in 50-cent dollars in the future. What they do then is they say, well, we're going to take that $20,000 that's in 50-cent dollars and make the ratepayers pay whatever it was, 1/50th of it, but they'll pay it in today's dollars. So you calculate the cost in low value future dollars and then collect it in today's higher value of dollars. An example I always use is, let's say you did a cost study and you said something costs $1,000 in Canadian dollars. Therefore, we want to collect $1,000 from ratepayers in today's US dollars. I think everybody would say, well, wait a minute, Canadian dollar is only worth 75 cents compared to US dollars. If you're going to calculate the cost in a lower value dollar, you have to do some sort of conversion, but they don't. I mean, that's the heart of that, is we calculate the cost in future low value dollars and start collecting that in today's higher value dollars. Now, the FERC's offset for that is they say, fine, go ahead and inflate it. If it costs 10,000 in today's dollars and it's cost 20,000 in lower value future dollars, fine, inflate it. But you also have to take the present value. The present value of $20,000 in the future is not $20,000 today. It's a lower number. So what FERC did with any future retirement that you actually know is going to occur, because there's a law or regulation that says it has to occur, is they inflate it. They start with the current cost in today's dollars, inflate it, which makes it a higher number, but then they present value it, which makes it a lower number again. You end up back almost, not exactly, not a perfect offset, but you end up back more or less where you started. The method I use essentially says you do neither. Either do both or do none. To inflate it, which is what Mr. Kennedy does, but not present value it, is a one-sided adjustment. If you're going to say this cost is in the future, therefore I have to inflate it to cheaper dollars, fine. But this cost is in the future, therefore the present value, the cost to ratepayers today, or the fair cost to ratepayers today, is less than 20,000 in future dollars. So it's either, there are states that actually do both. They do the present value calculation for all the accounts, the polls account, the wires, everything. They inflate it and then they present value it. But it becomes very complicated calculation with all the polls, thousands of polls, different vintages. And there's always arguments. The formula gets complicated and then there's argument. What discount rate do I use to present value it? But I've been in dozens of these cases and the answer you always get is somewhere close to where you started. So the simpler way is to do neither, which is essentially what I do. And I'd also point out, no one knows what it's going to cost to retire something 50 years from future. I mean, we're assuming it's the same technology. When they replace a conductor, you have a live conductor, men are working or women are working on poles, insulated poles, moving the wires around. Are we going to do that 50 years from now? I don't know. I mean, we can't do precision on future net salvage. We don't know what it's going to cost 50 years from now to retire a conductor or a pole. So we make a reasonable assumption, a reasonable allowance, collect a fair amount from the current ratepayers so they are contributing to the depreciation reserve, growing the reserve, having money available when the company does retire the poles. There will be money from today's ratepayers in there to help pay for it. But if you're trying to say, I know a perfect number, no one knows it.
Thank you. And one more question. Do you think using the salvage ratio method and proposing a gradual approach introduces a disincentive to the utility to look for ways to efficiently dispose of or retire equipment? Meaning if you're more or less down a path of, we expect increases in this for this account, for example, any account, you're introducing a disincentive for them to, find ways to efficiently dispose.
I don't, well, I've been in most cases, I didn't do it in this case, but my standard request, at least for COVID, is I would ask a utility, I'd like to come out, I'd like to observe your workers actually installing poles, removing poles, installing wires, etc. So I've been in dozens of those inspection trips. And I don't know that the workers or the managers that are retiring a pole have any complete understanding or care about what depreciation rates are. I mean, they're concerned about how many labor hours it takes to remove it, removing it safely, not getting anybody hurt while they're doing it. I don't think that that has any association with it. What you have heard today is if you adopt the company's method, their method inflates the cost greatly. It inflates the cost for future inflation, doesn't present value it, doesn't adjust for the fact that's in lower dollars than current dollars. And once you let them do that, you have now established the base that they are going to use for future rate increases. The real issue in this case is not what they filed in this case. The real issue is to have whether you have an order that essentially says, here's the foundation for a huge future rate increase in the next case. So I would recommend you adopt my net salvage rates, even if they were the same dollars as they had, because my net salvage rates do not assume any future increase or decrease. They are fair. Their net salvage method assumes that this is step one to huge future increases. So even if the dollar amounts were the same, I would not recommend you accept their method because you're laying the foundation for future huge increases, undeserved huge increases. My method, like I said, I'm putting 2.2 times average money from the current ratepayers into the reserve, 2.2 times what the company actually spends in recent years, taking out of the reserve. I am definitely growing the reserve rapidly, and no more should be taken from the ratepayers than that.
Okay, thank you. And one last question. So there was a discussion earlier about the moving away from net salvage. There was a discussion earlier about the I hope I'm not getting these wrong. The broad group procedure and the vintage group procedure. And right. You recommend in your testimony uses the broad group procedure. Is that?
Yes, he doesn't actually do what's called a vintage group. He does the broad group, and there's another name for that. I'd have to look it up. There's the broad group and what is sometimes called the average life group are that really the same thing. But he says he's doing vintage group, but he's not doing vintage group. He does this modified version where he triple recovers costs. I mean, it's good for the company, but it's not good for the ratepayers. I also point out, in this case, the average lives right now are 5 years longer than when they were in the prior case. That longer lives reduces the depreciation rate. The ratepayers should be getting about a $4 million reduction in this case because of the lives are longer. And this is not me saying that. That's the company filed lives are 5 years longer than they were before. That should have been a multi-million-dollar reduction for the ratepayers. Mr. Kennedy, with these various schemes, triple recovering, et cetera, has taken that reduction away from the ratepayers and he's raised the depreciation rate just a little bit, and he's setting a foundation for huge future increases. This case should be a several $1,000,000 reduction for the ratepayers, not an increase and laying the foundation for huge future increases.
So my question is, which methodology is more commonly accepted and used across other jurisdictions?
Okay. Number one, unlike Mr. Kennedy, I don't pretend to make a judgment like that without a survey. He has no surveys. He actually works in Canada more than he does in the US. We even asked him about 5 specific states. He didn't know what they use in 4 out of the 5. So his testimony as to what is most commonly used in the United States by commissions is based upon nothing. All right. I haven't done a survey. I haven't seen a survey. And so I can't really say. I will say this, the companies do push the method which creates the highest depreciation rate. Out of the 4 common net salvage methods, Mr. Kennedy admitted this, the one that he proposes is the one that produces the highest rates. And the companies know that. So in cases where I'm not there, I'm sure they're proposing for the one that produces the highest rates. Now, what happens in those cases I'm not in, I can't tell you. But if there's not a reasonable opponent there, I'm guessing the company could win. Possible. I hope that, and that's not the case here. You have at least a reasonable opponent.
Thank you. Those are all the questions I have, Chairman.
Okay.
Thank you.
Attorney Riley? No. Okay. Thank you. Let's see. NECTA, any cross? No, we said no cross. Attorney Bidra. Thank you. Attorney Wyman.
I had one, but you answered it subsequently, so I'm good.
I'm also all set. So Attorney Minikowski, would you like a moment to consider redirect?
If we could have a brief recess, that would be appreciated. Thank
Sure,
you.
let's recess for 5 minutes.
We done? Oh.
Just a moment, please.
Please be seated. All right.
We should look redirects.
Okay, we can go back on the record. Attorney Minkowski, any redirect, please?
No redirect, Chairman. Thank you.
All right, thank you. Sir, you are excused.
Thank you very much.
Thank you very much. Okay, we are going to transition into our third 3-day-long panel. So we have our cost of service study, revenues, rate design, rate adjustment mechanisms, sales revenue forecast. So I recognize the company has a number of witnesses for this panel, so I'll leave it to you to decide how to arrange yourselves up here, but I will need to have access, or the folks who have not yet been sworn in will need to have access to mics. And I believe we're going to start with cross-examination for this panel by authority staff. So I'll get them situated. And we will go from there.
No, I think I can take it back to the next 4 days or so.
One, 2, 3, 4, 5, 6, 7, 8, 9.
I know, yeah, that
Gosh, I'm already hungry. I'm already hungry.
Are you gonna sit here? I'm gonna sit here, you're gonna sit there.
So if you might, you haven't been sworn in yet, you just make sure you have, get up here and take the oath and adopt your testimony and all that stuff. And then we can shuffle out.
Just secretly, I'm gonna sit.
Hello, Greg. How are you doing?
How are you?
I didn't get the name.
Okay, if we're getting roughly all situated here. Attorney Vaughn, if you want, I'm looking at this witness list. I think we've sworn in only one. So if you just want to briefly read out the names of your other witnesses, and then I'll administer the oath in a group.
Sure, absolutely. Thank you, Chair Gillette. The witnesses on this panel for the company are Mark Kolka, Manager Pricing for UI. Mark Marini's listed on the witness list, but as we discussed at the beginning of the case, he's absent on a medical issue. April Thurbridge, Director Accounting Avangrid, who is previously sworn. Jack Jessup, Director Networks Accounting Avangrid. Greg Therian, Vice President, Concentric Energy Advisors. Vicky Ramal, Assistant Vice President, Concentric Energy Advisors. Michael Adams, Senior Vice President, Concentric Energy Advisors. Michael Pertel, Director of Regulatory at Avangrid. James Clementi, Director of Transmission Analytics at UI. And Charles Eves, Vice President of Electric Operations for UI.
Thank you. If I can ask the witnesses to raise your right hand, I'll administer the oath. And then if you can say, I do. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
I do. Thank you. Attorney Vaughn, if you want to have them adopt their pre-filed materials for this panel.
Yes.
Thank you.
I'll start with Mr. Kolka, Mr. Ramal, and Mr. Therian. As part of your preparation for this docket, did you provide pre-filed written testimony and exhibits, which for Mr. Kolka were marked as exhibits UI-MC-MM1 through UI-MC-MM3? For Mr. Ramal were marked as exhibit UI-BR-1 through 3. And which jointly for Mr. Kolka, Mr. Ramal, and Mr. Therian as exhibits UI-RP-rebuttal-1, and which jointly for Mr. Kolka and Mr. Therian were marked as exhibit UI-MC-MM-GT-1.
Yes.
Yes. Yes. And do you have any updates or changes to your pre-filed direct and rebuttal testimony at this time?
No.
No.
No. And do you adopt your pre-filed direct and rebuttal testimony as part of your sworn testimony in this case?
I do.
Yes.
Yes. Mr. Adams, as part of your preparation for this docket, did you provide pre-filed written testimony and exhibits which were marked as exhibits UI-MJA-1 through UI-MJA-3 and rebuttal testimony as UI-MJA-rebuttal-1? And do you have any updates or changes to your pre-filed direct or pre-filed rebuttal testimony? Do you adopt your pre-filed direct and rebuttal testimony as part of your sworn testimony in this case? Thank you.
Yep. Mr. Adams and Mr. Kolka, if everyone can check the green lights on their mics and pull them a little closer, please. Thank you.
Mr. Pertel, as part of your preparation for this docket, did you provide pre-filed written testimony and exhibits which were marked as exhibits UI-MP-1 through UI-MP-3?
Yes, I did.
And do you have any updates or changes to your pre-filed direct testimony at this time?
No, I do not.
Do you adopt your pre-filed direct and rebuttal testimony as part of your sworn testimony in this case?
Yes, I do.
Okay, Mr. Clementi? As part of your preparation for this docket, did you provide pre-filed written testimony jointly with Mr. Eves, which was marked as exhibit UI-CJE-JC-rebuttal-1?
I did.
And do you have any updates or changes to your pre-filed direct testimony at this time, or rebuttal testimony? Excuse me.
I do not.
Do you adopt your pre-filed rebuttal testimony as part of your sworn testimony in this case?
I do.
Thank you. Mr. Eves? We're getting there. As part of your preparation for this docket, Mr. Reeves, did you provide pre-filed written testimony and exhibits as exhibits UI-CJE-1 and UI-CJE-2 and UI-EPP-1 through UI-EPP-2, as well as rebuttal testimony marked as exhibit UI-CJE-rebuttal-1 and jointly with Mr. Clementi marked as exhibit UI-CJE-JC-rebuttal-1?
I did.
And do you have any updates or changes to your pre-filed direct testimony or your pre-filed rebuttal testimony?
I do not.
Do you adopt your pre-filed direct and rebuttal testimony as part of your sworn testimony in this case?
I do.
This would be a question to all the panel members. Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Yes. Do you have any changes to any of your responses to interrogatories?
No.
No.
No. And do you adopt your responses to interrogatories as part of your sworn testimony in this proceeding?
Yes.
And lastly, Mr. Kolka, are you familiar with UI's witness list filed as attachment A to its filing with Pura on February 14th, 2023, identifying certain non-panel witnesses who sponsored responses to interrogatories in this case?
Yes, I am.
And for purposes of admission into the record, do you adopt the interrogatory responses submitted by Paul Werner and Paul Gray?
I do.
Thank you. This panel is available for cross-examination.
Very good, thank you. We will begin cross-examination for this panel. Mr. Athos, I believe? Nope.
Thank you. Just my colleague and I will be working in tandem somewhat here today for this part. And but I'm John Athos. I work with Daymark Energy Advisors as a vice president and principal consultant, and working today on behalf of Pura staff.
I'm Stan Freniers. I'm principal consultant with Daymark and also here on behalf of staff. Okay. Thank you, Madam Commissioner and commissioners, parties. I have a number of questions for the panel in three areas. One is the allocated cost of service study, and we'll start with that. The other is the revenue allocation. And then I have some questions on rate design, and then we'll turn it over to Mr. Athos, who may actually pipe in if I've forgotten anything, as well as Mr. Ryer for staff. The first set of questions on allocated cost of service study. I believe these will be directed for the most part to Mr. Kolka and Mr. Remau, possibly Mr. Therian. And let me just go ahead. I think this is for Mr. Remau. On page 5, lines 3 to 4 of your testimony, you state that the fundamental principle underlying an allocated cost of service study is that cost allocation should follow cost causation. That's correct?
Yes, that's correct.
Mr. Remau, in your opinion, does the company's proposal to allocate in the present rate case all revenue increases on the basis of test year bundled revenue result in rates that achieve that objective, despite the results of the allocated cost of service study?
I mean, the statement is for how to conduct a allocated cost of service study. It's not necessarily how revenue is allocated.
I just pull the mic a little closer. Nice. Did we hear the response or need?
I didn't hear all of it. Thank you. Could you repeat that, Mr. Remau?
So what I was saying was that statement that you just read was for how to conduct an allocated cost of service study, well, not necessarily how revenue gets allocated.
Thank you. Are there other rate-making principles that you believe are priorities in setting rates? And if so, which ones behind the premise that cost allocation should be driven by cost causation? And which of those would be the most important?
So can you rephrase in terms of like setting rates or conducting cost study?
I'm talking about general rate making principles as espoused by Bonbright or in the NARUC manual. I think these are, at least the NARUC manual has been cited by the company.
So I mean, cost causation is the fundamental, especially for cost allocation itself. But then in terms of rate design, revenue allocation, there are other considerations like gradualism, fairness. So, like other factors.
Are those your main priorities behind cost causation, those gradualism and or is there any others that take precedence here?
Ideally, we would want to have rates that were completely cost-based, but there are other factors, as you mentioned, Dr. Brombyte. His 8 or 10 factors, they all matter. And we looked at the cost of service study when we were making our decision on how to do this. And we realized that there were some changes that we thought were going to be too large to fit gradualism. And in particular, the difference between rate R and rate RT that came out of this. We didn't want to see, we didn't think it was a good idea to have such a large differential between those two optional residential rates because a residential customer can choose either or. So we proposed in our pre-filed testimony to do a deeper dive into all these issues in either a rate design docket that was docket 17-1203 RE11 or in the AMI docket 17-1203 RE02 where there will be some rate design there. So given that we had a fairly short window to look at this, that's why we proposed to do the method that we're showing here with the average bundled change based on the bundled rates, and then defer to another case where we could look at this in more detail and where there could be more stakeholders putting substantive input into the cost of service study and the rate design and the rate allocations, the revenue allocations.
Thank you, Mr. Kolga. I'll return to that subject in a bit. Have either Mr. Rimal or you, Mr. Kolka, prepared or examined the results of previous company cost studies in the 2013 and 2016 rate cases?
Yes, I did those.
Were they reasonably consistent in terms of the overall construction and results over this last decade, generally speaking? I mean, were there any major changes to the approach used?
No, 2013 and 2016 used the same approach.
What did they indicate with regards to class by class relative rates of return? Were they similar to what the present study produced?
They were different.
Can you follow that up? Were they, were the disparities in class by class revenue, class by class rates of return, were they wider in those previous studies, narrower, or about the same?
I believe I answered a couple of interrogatories. I'll have to look for those. But we answered those questions specifically with regard to what the previous cost study showed. And I think there is one, that escapes me right now, but I'll find it, that shows what the 2016 and I believe the 2020 come out to be. But basically we have, the big difference I see is being in the rate R and RT allocations between the 2016 cost of service study had a much narrower difference between rate R and rate RT than the 2021 study does. We don't know why at this point because we haven't delved into it deep enough to find that out. But that is really the primary reason why I suggested that we push the rate design to its own docket so that we could get through this part and then look, and all the stakeholders could have input into the cost of service study and the rate design and the revenue allocations.
Taken as a either group of R and RT or just R, do you recall whether the previous studies showed a relative rate of return as low as you're showing in the present study for those
No.
classes?
I believe the 2016 radar rate of return index was close to 1. And the radar T was a little over 1. So the radar one in this study is lower than 1. And I think it was about 0.24, 0.25.
0.27.
0.27.
I think you just testified that you haven't dug in enough to determine why such a drastic change from one study to another.
Correct.
Taking the results of the present study and looking at the disparity in those class by class rates of return, would you consider those results to be sort of within acceptable limits for rate making purposes? That disparity with a very low residential rate of return, is that something that the company finds to be generally acceptable as is, or?
This is why we propose to do a deeper dive in a different docket.
We were wondering, you mentioned the short window and not being able to do it for this docket. Can you kind of elaborate on that? It seems like that timing for this docket would have been have a lot of control over those issues.
No, the rate design docket 17-1203 RE11, that has been going on for 2 years. That's the kind of timeline I think that we would need to really do a deep dive into a cost of service study where all the different groups that want to participate can, instead of putting just the company model out and having that as either being accepted or rejected, that there would be plenty of time for all interveners to go in and propose other models too.
I think this is probably for Mr. Ramal. So given the results of the disparity in the class by class relative rates of return, just on behalf of work you've done for other utilities, would you consider that disparity to be within acceptable limits or reasonable for going forward rate making purposes?
So by disparity, do you mean the returns?
Yes, relative rates of return. Yeah.
Within the current case study?
Yes, your present study.
Yeah, so I mean, I think we see similar variance. It just depends when you conduct a study based on how much each class is contributing to their cost of service. So I think it just depends on when you're starting out, how much revenues they're contributing and how that compares. So it's hard to comment on whether it's reasonable here or not, but we support the study we did, and the results are based on cost of service study.
So I think I touched upon this earlier. Given the results of the present allocated cost of service study and those relative rate of return results, do you believe that UI's proposed revenue requirements allocation in this case is actually driven by cost causation?
No.
Thank you. Have you ever prepared an allocated cost study for or advise other clients about class by class relative rate of return disparities as significant as you found in this study in Table 1? And let me put it a little more simply, would the residential class at a relative rate of return down in the single digits, is that normal? Is that something to be concerned about?
So from my perspective, that's what I'm struggling because each utility is so different. And again, I think the revenue contribution and comparison to cost depends on where each company, like what type of rates they have, how customer profile. So it's hard to do a comparison, but I have seen instances where there is variances like this, and then residential are severely under contributing.
In your opinion, how important is it that the company address those disparities?
Address the disparities
In
in the
relative
cost of
rate?
service study or in its application of revenue allocation.
Here I'm talking about the allocated cost of service study results, the relative rates of return.
So when you say application in terms of how revenue allocation is done?
No, in this case, I'm not yet talking about revenue allocation. I'm just, in general, you found in your table one that there's quite a fairly wide bit of relative rates of return disparity, and I'm just wondering how important it is to the company to address those.
I mean, I can speak to that. That's the result of the cost study, and those are the indication of how each class is contributing. And to make the statement that, what you're asking, I think it has to get to revenue allocation.
Would the revenue allocation then, in this case, start to address those disparities in relative rates of return?
Yes, but we have to be careful because we have these two residential rate schedules, R and RT, and they're optional. So we can't have a huge disparity between those two rate schedules that can't be reconciled by changes in customers' on-peak, off-peak behavior. So if a customer is able to shift, now that's what RT does. Not in distribution. We don't have a distribution time of day differential in the price. We used to, we don't now. That time of day differential is in other rate components that customers can respond to. And if a customer can respond and shift to the off-peak, then they can save money. And that's good because we believe that is cost of service based. But when it comes to distribution, if we change the distribution rates such that R and RT are vastly different, and that difference is even greater than would belie a cost of service study, we could have a tremendous migration from the higher rate to the lower rate, resulting in a revenue loss that'll have to be caught up in decoupling, and just a lot of migration that is difficult for the company to manage.
Yeah, thank you for the mention of how radar and RT differ. I'm generally speaking about radar versus, say, the commercial rates. Those disparities where you see radar residential customers by and large under contributing here, and the commercial class rates of return indicate they're over contributing. Those are the disparities I'm talking about.
Well, we would ideally, once again, the company's viewpoint has always been the ideal position is to have all classes at equal rates of return. That's what we said in all our previous rate cases, and that hasn't changed. The question is how to get there, and how to get there under a new operating environment that we are seeing now, as opposed to the operating environments in which the cost of service studies were done in the past. There's been a lot of changes in the industry, and there's a lot more coming up. So we need to be careful about how we apply these results so that we can get to a spot where pricing is fair in a rapidly changing environment. And And what I mean by that is we have new tariffs, we have a lot more behind the meter generation. There's a lot of differences today than there were in the past.
Yeah, thank you. I was going to ask about what those changes were you were referring to. Do you believe those are behind some of the relative rate of return disparities we're seeing here?
I can't say that objectively because we, like I said, we haven't done that deep dive and we haven't had viewpoint from other stakeholders too, that we would get in a specifically directed docket.
Okay. Thank you. If I could turn to the company's minimum system study. And again, feel free, Mr. Remal or Mr. Kolka, to respond. Did the present study, I think there was some interrogatories asked about changes. Did either Mr. Remal or Mr. Kolka, did you oversee the previous study in docket 1606-04?
Yes, I conducted that.
Okay. Has that methodology for the minimum system study changed over that time?
Details I'll defer to Mr. Ramal, but we did contract with Concentric Energy Advisors to do this cost of service study to the methods that they use. So we didn't specify anything. We just asked them to do this cost of service study for us.
Similar question to the allocated cost of service study in general. Are the results between those two studies, minimum system studies, reasonably consistent from 2016 to the present one?
We showed a minimum system set of allocators in that, but we used the minimum intercept method from 2016. Now they will generally, not always, but they'll generally result in lower customer-based charges, allocations, and higher demand-based allocations. This minimum intercept method that we use, as opposed to minimum system.
Thank you. Is the present minimum system study at all responsible for the proposed decrease in the basic customer charge that was calculated? I think it went down from 1284 to 1134 per residential customer per month.
There are inputs from the allocated cost of service study, but the primary driver for that, I think, is just decreases in the cost of those includable accounts. We don't know why those costs have decreased. I believe, I'm pretty sure one of the factors is that there was much more plant and service related to software in the previous, in docket 170112, I think that was, because, and I'm not a depreciation expert, but software depreciates at a much quicker rate than others. So I did look at that in this, when I prepared this MRCC, and most of the specifically directly assigned software, FERC account 303, intangible plant, is fully depreciated.
Can the difference between the two studies, the impact on the basic customer charge, be fully quantified, and have you done so?
I believe it can be fully quantified. We would have to go through and really compare cell by cell in that calculation. It's nothing that I have done now. I mean, we went through the entire calculation, but went through it with the eye to make sure that the calculations were correct, but not comparing to what happened in the last time. We can do a very simple comparison as to what accounts changed, but why did those accounts change? That's a deeper dive. Have not done that.
Thank you for that distinction. Is it possible to do so here and provide a late filed exhibit?
It is possible.
Would you do so similar to work paper 1.0?
Work paper 1.0. Is that work paper 1.0 in which?
I believe it's work paper 1.0 where you filed the detailed results of the allocated cost of service study. It doesn't matter that it follow that particular example. I was just trying to provide a model.
Yeah.
Yes,
I think it's, Mr. Farron, just to clarify for the record, so in Mr. Amal's testimony, his first work paper is work paper 1-1.0, I believe. Is it, the witnesses follow that? I'm looking at page 3 of.
Are you looking at the results of the cost study, the summary page? Or
Yeah, in terms of this late filed exhibit, I'm just trying to offer a model. However you respond to it would be fine. We're
Yes.
really just looking for an answer to that question. Sort of
Yes.
what happened.
I mean, the MRCC calculation is set up to tear down into the details, so that won't be a problem.
Thank you.
Okay, I apologize. I lost the prompt in there. So if you can just summarize the prompt for me, please.
Yes, Madam Chair. I was looking for a quantification of the difference that led to a lower basic customer charge from the $12.84 presently per residential customer per month to the $11.34 proposed here.
Thank you, sir. So that is late file exhibit 2.
If we could turn now to the testimony of the Office of Consumer Counsel's Mr. Chernick. I assume you've read that carefully?
Yes.
Mr. Chernick avers that he critiques the minimum system study and suggests on page 7 of his testimony, lines 14 to 18, that quote unquote, UI overprices the cost of minimum poles, misclassifies conductors, poles, and transformers, fails to account for the load carrying capacity of its assumed minimum system when allocating costs, overstates conductor requirements due to the demand-driven requirement for multi-phase service, and overstates feeder length and pole count where multiple circuits on the same route are built to serve demand, end quote. You're familiar with that piece of his testimony?
yes,
If Pura were to determine that some or all of these criticisms were valid, could UI produce an alternative minimum system study that corrects its assumptions as Mr. Chernick suggested?
can you repeat the question, the last part?
Sure. If Pura were to determine that some or all of Mr. Chernick's criticisms were valid, could the company produce an alternative minimum system study that corrects its assumptions and costs as Mr. Chernick suggested?
I mean, first off, I think we have rebutted his positions there. Notwithstanding that, still, I think, there are certain limitations, especially just from a data perspective as well. Like we can't, for example, regarding the minimum size, like we are following New York manual, which says you can constructing a minimum system using the minimum size assets currently being installed. If we were to use a different minimum size, we would not have cost information because the storeroom or UI does not maintain cost of something that's smaller than the minimum size currently being installed. So even if some of his assertions are correct, there are some limitations which will prevent us from doing the study as he is contemplating.
Okay, thank you. That answers that question. Just on the point you just made about use of equipment currently being installed, the allocated cost of service study is an embedded cost of service study. Is that correct?
Yes, it is.
Based on 21 test year?
That's
numbers? Right. Okay. And does the use of the quote unquote currently installed equipment, does that suggest any inconsistency with an embedded cost study?
Well, I mean, that's based on guidance from the NARIC manual. It's clearly stated, currently installed.
Okay. Would the allocated cost of service study, which is an embedded study, generally represent costs of equipment currently being installed, or rather 21 test year embedded costs?
From a cost perspective, it would be the embedded cost.
Thank you.
But sorry, I just want to make one clarification. So it's currently being installed in terms of the equipment itself. So that's the guidance from NARIC manual. The sizing, like how you pick a particular pole or a conductor, should be what's being installed currently.
Thank you. It sounds like you're unable to replicate or to prepare another minimum system study based on the critique by Mr. Chernick. Do you have any sense of were his criticisms to be addressed in another minimum system study, what the impacts would be on customer related and demand related classifications overall?
I mean, without really conducting the study, I can guess, but I think it would be lower. That would be my guess.
Which would be lower, customer related or demand related?
Customer related.
Thank you. Is having, read and carefully and rebutted Mr. Chernick's testimony, is he correct that if the minimum system study were altered to address his concerns, that the customer costs allocated to the smallest customers, including residential, would decrease? And I think he states this on page 11, lines 1 to 3.
Yeah, I generally agree with that because, smaller classes have more customers compared to larger classes, like throughput per customer on that basis. Like if comparatively they have larger customer base, and if customer costs go down, then they would get lower allocation of cost.
Okay. Particularly for the residential customers, if that happened, can you opine on what would be the impact on the MRCC, the maximum residential customer charge?
So I don't think there is a direct correlation because the MRCC has a very specific prescriptive in terms of what accounts can be included. And some of the accounts we're talking about where we're doing this minimum system are distribution accounts. So the customer demand classification, I don't believe should impact the MRCC directly.
Yeah, that's correct, because the minimum system is going to hit poles, overhead circuits, underhead circuits, and line transformers. Those accounts are specifically excluded in the MRCC calculation.
Thank you. I think you've answered this, Mr. Kolka. I just want to confirm what you're suggesting is that the decrease in the proposed basic customer charge, about 12%, going from 1284 to 1134, that, in your view, is primarily due to the specific allowable accounts that compose a lot of the construction of that customer charge?
Yes, absolutely.
Thank you. One final question on the basic customer charge, and I'll turn it over to my colleagues if they have any follow-up. With the lower charge proposed in this case, has that been impacted at all by the guidance that Pure offered in its decision in docket 17-01-12 that might have otherwise been allowable under the statutory definition of Connecticut General Statute subsection 16-243 BB? In other
Well,
words, is there anything in the docket prescription which was far more detailed in terms of the construction of that charge that's inconsistent with the statute or that led to lower customer charge generally?
No, I feel that 170112, that's where the statute was interpreted, and that was the model that was found to conform to the statute.
Okay, thank you. I want to turn it to another observation or another bit of testimony offered by the OCC witness, Mr. Chernick, and that's on the use of non-coincident peak to apportion distribution demand costs. Particularly where on page 18, lines 5 to 9, he suggests, quote, the sizing of distribution equipment investments are driven by the coincident demand placed on each portion of the system. Almost all substations and feeders serve more than one class. So the peak load on the equipment does not necessarily align with the non-coincident peak hour. The peak load on various pieces of equipment will occur at different times, end quote. You familiar with that bit of his testimony?
Yes.
Do you agree with that characterization? And if not, why not?
I generally agree that, like individual substations might not necessarily, when they peak, might not coincide with class NCP.
If I could add just a little bit of flavor, we've talked about this in previous rate cases before, and I think it makes sense is that load diversity increases the farther you get away from the customer. So there's essentially no load diversity at the customer meter. And when you get to the substation, there's a lot more diversity because you have a lot more customers all doing different things at different times that show up at the substation. So the NCP is used as a model, an accessible proxy to model that complexity. And that's where it comes out. But there could be an argument made that you would use coincident peak at the substation and parts down there and then change to something else and then get to the sigma NCP or the sum of all the customer loads right at the customer. But that's complicated, and that's probably more complication than a cost of service study can really generate results for.
And I mean, if I may just add to that, the other thing that makes it more complicated is when we're doing cost allocation, we're doing on a substation account. So we're not allocating, we don't have cost or revenue requirement by individual substation. So I think that's why Mark is saying like NCP is a proxy which accounts for the load diversity. If we were trying to allocate, like if we had revenue requirement at the substation level, then maybe something like Mr. Chernick is suggesting where we're looking at how each individual customer is impacting that particular substation could be that could be a consideration. But again, we need to keep in mind that we're trying to allocate like FERC account level revenue requirement and cost.
Thank you. This is probably better answered by Mr. Kolka. Just as a follow-up to that, the point you were making, the UI system has quite a number of circuits. Generally speaking, how mixed is the customer, the types of customers on those circuits? I assume that one reason why you've suggested the use of NCP and is that it's hard to essentially differentiate at the substation level or upstream from there, sort of the mix of customers being served by those circuits. Is that generally the case where you've got quite a mix of different customer types on each circuit?
I think generally, yes, but I defer that question to, I don't know if that's something that we've looked at in the past. Yeah, but that would have to go to or through system planning and working with us. I don't think that we have done a detailed circuit by circuit analysis of which customers on which. I think we answered some interrogatories on this too, that our load research is not designed to do it at that level. So our it's a total system approach, which makes sense because we're generally not going to charge by location. We're not going to do any locational pricing. So we really like to model the system as a whole, as a composite circuit, if you would. And NCP is an accessible and something that can be implemented at that level of granularity.
Thank you, Mr. Kolka. So I take it that the company would be unable to presently, as suggested by Mr. Chernick, and this is on page 18, lines 20 to 22, quote, use newly available customer load data from the smart meters to estimate the contribution of each class load to the sizing and aging of transformers, underground lines, and overhead lines?
It's really not possible today. It probably will be in the future, and that future may not be that far away. But we don't have everyone on AMI right now. There's still a significant amount of customers on one-way AMR meters. So we're not collecting this level of detail from each meter. And to do that and to store it, storing, we collect 15-minute increment, energy readings from all those meters. To store that data so that it's usable en masse it's just a massive undertaking and expensive. So that's why we still use load research. We have a robust load research program that seeks to do exactly that, but not for every customer. There's a sample taken and we use those samples in anything we need load research for.
How often does that happen, the load research? Is that on an annual cycle or?
It's continuous because we need the load research results for the ISO energy market settlement, ISO New England energy market settlement. So that's continuously run. They come up with load curves continuously, but in order to get like the NCPs and the load research results that we need, that's a bigger lift. So they only do that once a year, and it takes a few months after the year ends to have all that available. So for example, we don't have 2022 load research available at this time. It'll become available in the next couple of months. Once again, it's load research, it's a sample.
Thank you. On allocated cost of service study, that's all I had. Does any of my colleagues here have any follow-up?
Yes, thank you. Couple of things that I just wanted to make sure I understood. That when use of the word proxy for data not being available at a substation, could that be translated into that the results of the cost of service study are somewhat approximate of cost causation?
I guess that was not my characterization. It was more proxy may not have been the right word. What I meant was that data in terms of having a hourly or like peak at each substation and using that, what would be more appropriate is if we had revenue requirement by substation. That's when I think like that data would make it okay, valid cost allocation. So if we had revenue requirement at substation level, then we could essentially look at what Mr. Chernick is saying in terms of contribution of each class at when the substation peaks.
Okay, so you're saying that there would be no utility in a sense, no usefulness to have the data analyzed like that unless you were going to have revenue requirements and then bill based on location.
You don't necessarily need to go all the way to rate design and bill, but even from a cost allocation, if we knew or if we had revenue requirement at substation level, then we can figure out, okay, what is the peak at each substation and who's contributing to that peak, like just from a cost allocation to even like without even having a locational based actual rates.
So there's but now I'm not sure if I follow. So let me try this then. So you're saying that the calculations we're talking about wouldn't be more accurate indicators of the causation effects between the residential and non-residential customers on the distribution system?
The data, the analysis that Mr. Chernick suggests here requires massive amounts of data. It would require, it would require sampling. First of all, you have to sample what you're trying to measure. And what we're sampling right now are the total system. We're not sampling according to circuit. So in order to get results that would be valid, we'd have to set up a sample design to sample those customers that are on those circuits. We know where all the customers are. That's in the GIS. It's marrying that data, that locational data, with their loads. We would have to pick samples to do exactly that, and that's expensive. And you would probably, I don't know this for sure, but I think you'd probably need more sample points to do that type of analysis. So, and that costs money and time, and it's just nothing that's been done in the past because we won't price by location.
Sure. And I appreciate that full characterization, but my question was, if you did it, would it be more accurate cost causation?
It probably would.
Okay, thank you.
Yeah.
That was, I wasn't asking about doing. I wanted to come back to the issue when you were talking about rates R and RT and them being optional, just for clarity. Is there a limitation for how quickly or whether a customer would be able, after they choose one, would have to, or if they choose RT, would they be able to come back to R?
1 year.
1 year. Okay. And would is part of the underlying rationale for not wanting to break up that, have a wide split of those two rates until you understand the reason for those allocations coming out so different? Is that because you're uncomfortable with the pricing signal that it sends with to make a change every year?
We're not uncomfortable with pricing signals themselves. In fact, we believe pricing signals are good. We have to make sure that the pricing signals are accurately reflecting cost of service. And in the situation where R and RT are separate rate schedules with separate samples at any one time, they come up with separate NCPs, separate CPs for non-bypassable, separate 12 CPs for transmission. That's how we allocate those others. So, and we do that as a snapshot. Over the span of a year, we'll have the load research that comes up with those allocators that we use to allocate between those, well, between all the rate schedules, but between those two that we're talking about. Then we get into the operating year where then we calculate rates. And then we get into the operating year where people can choose one or the other. And if there is some kind of reason for them to migrate, that the revenue can't catch up with, if you will. And there's a disparity in the rate. So in this example, let's just say that the distribution rate for RT is much lower than the distribution rate for R. And it was enough to drive people over to rate RT who were previously on R. You'd see a revenue decline that will show up significantly and have to be recovered through the revenue decoupling mechanism, which then gets spread to everyone. So there's impacts of migration between rate schedules when there's a vast difference in the price between the two.
So I was just trying to, again, trying to come back to and understand that right now, without delving deeper, you're not comfortable that the results using the allocation methods that you have used here between the R and RT are accurately lining up true cost causation because there's been too much spread.
No, I'm not saying that it's based on accuracy. It's based on the fact that if we set the rates in two, vastly different, we're going to get migration. My worry is we get a lot of migration from R to RT that will, number one, result in a revenue deficiency because we'd be setting the distribution rate for rate RT much lower than for rate R. That in itself may cause migration. People will respond to their total bill, but that distribution differential could contribute significantly to a bundle difference. The migration will result in, one, a revenue loss that'll have to be recovered through decoupling, and two, it'll be hard to manage such a drastic change in a short period of time. Whereas if we do something to moderate that over time, we could get to a point where there's not going to be significant migration at any given time. There's going to be some always.
Is it within the information that you'd have, if you're worried about migration, that you could estimate or even determine which customers would be better on which rate?
Yeah, well, we can. That requires some number crunching, but we can.
Okay, so that and it would it be in your interest to have the customers on, assuming both rates give reasonable price signals, would it be in your interest to have the customers on the rate that is most advantageous for them?
Yes, it's always good to have the customers on their best rate, and the company believes that.
So is there, so are we back to that short window that you used earlier as the reason for not being in a position to want to do that calculation to understand migration and other effects of the cost of service study between the R and RT?
A rapid migration will be difficult to manage and will result, if we don't design it into the rates going forward, that migration will result in a loss of revenue. So that's where we need to give it a lot more thought about how we would need to transition that, which is the reason why we would like to do this in a specially directed docket.
Thank you.
May I supplement that just to try to broaden that out a little bit, if I could? So in our response, it was our rebuttal testimony, we made mention of two other open dockets, and that there are specific cost allocations and rate considerations being performed in those other two dockets. So we're caught in this window of a general rate case and two other generic rate making dockets. So the thought here was, in the spirit of gradualism, which is Von Bright's probably most important principle, of trying to avoid whipsawing, okay, which is to take the results of a allocated cost of service study and a specific utility rate case, make material rate case allocation changes including radar, which the panel's already discussed, has some results that we want to dive in a little deeper on. Go ahead and make those changes and then have these generic dockets provide results that would unwind that. So we're trying to avoid some whipsawing of rates, either one way or the other between classes or even intra-class. That's the reason why.
I understand that. I appreciate that. I'm just
May I
trying to.
finish? I'm almost
Okay.
done. Which may help avoid that whipsawing, hence the reason why the company proposed to just do an across-the-board rate increase.
Mr. Athos, if you could just give me 1 second. Mr. Theron, can you clarify what 2 dockets you were just referencing?
Yes, I can. They're referred to in the rebuttal testimony. My panel can help me out. I know one of them is
I
17.
know it's probably the AMI docket, 171203 REO2, where we're talking about a lot of time of day differences. And then RE11.
Which is done. Okay, so there are not 2 open dockets. There's 1. Is that, I just want to make sure that I was not missing anything. I mean, RE11 is done.
RE11 is done for the low income discount rate.
It is done. Okay, well, let me put that in the form of a question. What about RE11 do you think is not done?
When it was brought up, it was for new rate designs. So now if it's done and there are going to be no more new rate designs, then we'd have to go through REO2 to see what the time of day differences we're going to do then.
Okay, so the short window, and I know you've now had this question two times, but I'm still not sure I understand. The short window that you're referring to is what? What is the short window? What do you mean by that?
We have this cost of service study that is built right now with the existing rate schedules as they are, and basically with the same techniques. You know, there was minimum intercept in the past, minimum size right now, but even though those are different approaches to get the demand and the customer split, it's still fundamentally the same type of analysis. But we now have a number of more tariffs that are not modeled in the current cost of service study. We don't know what the effect of the low income discount rate is and the lowering of the rate for those. We don't know how that's going to affect cost of service study and consumption. There hasn't been any work to incorporate that into the cost of service study. We also have, the electric vehicle initiative. Well, they're just going to be, according to the state policy, a lot more electric vehicles that will be coming on. We have new tariffs for those. Those have not been modeled in the cost of service study either. There's no data to do that right now. They're still embedded in their GS and GST. And then we have the economic development rate. We don't know how that's going to affect. So this cost of service study that we have right now is very much business as usual. And we've also had, since 2015, a tremendous amount more of behind the meter generation, which affects loads, it affects costs, and that's not modeled in there either. So, and that's only going to get more. We're going to get more and more behind the meter generation as we get to our zero carbon world.
Okay, so by short window, you mean there's only a short window in which the company's cost of service allocation study is actually good for. Is that what you mean?
Well, partially. In a changing environment like this, the environment just wasn't changing that much in the past. It's changing a lot more now with the drive to zero carbon and the drive for all these other clean energy initiatives. So none of those are modeled in there. But really what I was trying to get to with the short window is that we just didn't have time
But isn't, when you say you don't have time, isn't it totally within the company's control when to file for a rate case? I'm just not sure what you mean when you say you don't have time.
I think that's going to be a multi-year process to get these into a cost of service study and then to get that cost of service study to a point where people are comfortable with it.
Okay, so you're putting forward a cost of service study in this case that you concede is not representative of what the likely future is, and you're asking us to allocate revenues based on a cost of service study that's going to be almost immediately outdated. And then you want us to come back and have a separate cost of service docket that's going to be multi-years long.
Exactly.
Okay. All right. Thank you.
Thank you. So earlier, and I just wanted to make sure that they're connected. Earlier, I believe you said that, I forget who actually now, that there are changes in the industry affecting the cost of service modeling and the relative rates of return that the cost of service modeling can't keep up with.
My belief is that, yes, these changes have resulted in changes to the allocators.
So when we said earlier, that's the kind of stuff you just described in a little more detail is exactly what you mean by the changes in the industry.
Yes.
Okay, thank you. And earlier you mentioned that the ideal situation would be to move all classes to an equal rate of return or an RROR factor of 1.0.
Yes.
Okay. Is there any, given the uncertainty around the matching of over the time period that rates would be in effect and the cost of service study that you would use for a basis of that, is there any degree of comfort that the company would put forward that instead of moving to equalized rates of return, that there would be a bandwidth around the equalized rates of return that you would consider to be consistent with the, I'll use the word, but I know you don't like it, the approximations that are in the current cost of service study?
Yes. The ROR of 1 is, or the ROR index of 1 is an ideal, but we don't live in an ideal world. So we have other considerations. So yes, a bandwidth, that's fine. There may be reasons of gradualism. There may be reasons of, we just say that we don't know this stuff with absolute certainty that would allow a bandwidth to be reasonable around there. I don't know what that bandwidth is. I don't know if there is a single bandwidth that's can hold rigor. That is really more or less of a policy decision. I think that people have to get comfortable with that. Yes, we can have a bandwidth around there and then look at these ROR indexes and come out with some kind of agreement that this is where they should be within.
So, and I understand all those factors. Thank you for listening. So within the information that you've presented for this case, for this application of the cost of service study and the uncertainties around those policies and is there is the use of a bandwidth something that the company would think is reasonable?
I think it's reasonable, yes.
Would any ranges of pop into your head that suggest as that to digitize that range as being reasonable given the information that you've put forward in the application?
I wouldn't want to put forth a number right now.
Okay.
I mean, certainly I think it would have to be above 50 and 150%, but I mean, that's a range. It could be 75 to 125. I know these are all ranges that are possible. Any range is possible. It's, we could make a proposal, but we're not in a position right now to make that proposal as to what we think those bandwidths should be.
And are bandwidth used, are you aware of whether bandwidths are used in any other jurisdictions?
I'm not aware.
Yes, I'm aware that that's one methodology. I would also add that there's an inherent bandwidth in rate setting regardless. So if the goal is to get all classes to 1.0, you run your allocated cost of service study and there's variation. Gradualism suggests that you should be moving towards that 1.0. And commissions then approve rates saying that these are just and reasonable, knowing full well that not every single class based on the cost of service study has resulted in 1.0. So there are overt bandwidths in certain jurisdictions. There are also bandwidths on rate increases, like Massachusetts, for instance, says, no one class should be increased by more than 10%. So there are those type of constraints out in the industry.
Understood. Those, some of them are output de facto bandwidths. Some of them are design bandwidths.
Correct. Thank you.
What type of bandwidths have you, if you're familiar with them, have other jurisdictions used as design bandwidths?
So New York has around ROR 0.85 to 1.15 of return.
Thank you. Are you aware of anyone that would be wider than that? Again, as a design bandwidth, obviously you have a bandwidth in your proposal that's definitely outside that. But are you aware of anybody using a bigger bandwidth than 0.85, 1.15?
Nothing comes to mind.
I think there are, and unfortunately, sir, I can't recall it. I want to say 125 and 75, but if you would like me to do a late file, I can check some notes that I have back. It's up to you.
No, I think I'm comfortable with the information that it likely exists.
Can I clarify real quick? When you say 125 to 75, you mean 125 to 175 or 75 to 125?
0.75
5 to 125.
1.25.
Got it. Thank you.
So, which just to make sure that we're having the same conversation, I should have checked this in the beginning. As the 0.75 is the equivalent to the number where you calculate, as you mentioned earlier, the 0.27 for the residential rate class. It's the same number that we're talking about.
Exhibit 1 is a 0.27. Is that the ratio? Yeah. Yes, that's correct.
Okay, that's why I just want to make sure that that somehow we didn't have a conversation talking past each other. That would have wasted everybody's time. So in the last rate case, it was discussed that it would be great to move an objective to move customers to equalized rates of return over the next 4 years. And we're past that mark and we didn't get there. Would you care to comment on how much you, what levers you pulled to try to get there?
We'll have to go back to the 2016 160604 rate design order, which I don't recall in detail right now. We could take that as a late file. Generally speaking, and I'll go back a couple of rate cases before that, 2005, 2008, 2013, and 2016. We found in 2005 that the residentials were under contributing. They had RORs less than 1. And we moved residential rates. And these are in those orders, and I could get those orders for you if you wanted to see those in a late file. But we moved in 2005 and 2008, we moved residential rates higher relative to the other rate schedules. And then when we got to 2013, they didn't look all that much different. And then when we got to 2016, rate R was pretty close to the system ROR. So we considered that to be having moved sufficiently that we didn't need to work on that specific rate class anymore, and that everybody would get the same distribution increase. I'd have to go back and look to see what we actually did in 2016.
Well, I certainly don't want to put that burden on you for what you described with all those cases, but I wonder if if we could have a late file exhibit that would be specific to the issues of what actions did the company take in its to fulfill its objective of moving toward equalized rates of return in 4 years since the last rate case.
Okay, so I will answer that, but with a caveat that we would only follow an authority order. There'd be nothing that we could do on our own. This is all done through pricing. And with that, we always implemented the prices approved. So we would be in the rate case when we proposed, it would be our proposal to do something, but in the end, we would always comply with what came out as an order.
So that then that's a good point, and maybe it would be helpful then if you supplement what levers you would have liked to pull, but you did not have the authority to do.
Okay.
So that's late file exhibit 3, and I think just to summarize what I hear, make sure that we're on the same page. I think we're looking for a narrative regarding what actions the company took to fulfill its objective to move towards more equalized rates of return and rate design since the last rate case. And I would interpret that, Mr. Kolka, to your caveat to mean based on the proposal that you've made here in this rate case, how does your proposal move towards that objective?
Okay, understood.
All right, let's go ahead and take a break. We're going to take a 15-minute break, and we will come back at 3:40, and we will go for just under 2 more hours. Okay.
My battery. Stop. Yeah. Kills me.
I don't know whether it's still previously.
No, I'm just gonna go inside.
You can call myself. Yeah.
I didn't know.
No, it's just, no. I know, that was, I know, that's not what it was.
Great. Yeah. You like to walk around or anything? You have one that we have.
Yeah. I don't have a cough at all, but I just want something. Yeah. I know. I can't, but you know, I just, you know. So they can, that's not. Gotcha. Oh, I have a question. Yeah. People need to know if that, now this computer's. I go upstairs, I can't use stairs. You can't use. No, I can't even log on, there's nothing to log on, like I can't. Even-
Oh, you're right.
This must, okay, so you can only do one or the other.
Yeah, yes.
Okay, that was a surprise.
Oh, I know you can't use.
No, no, that, oh, yeah, no, yeah. That. Or, yeah, I used to. Yeah, I can send you, I'll send you the link, but, you can definitely watch it, you're gonna see exactly what you're seeing. Yeah. It's actually a question on notes, FYI.
Okay, if we can go back on the record and we'll resume cross for this panel by authority staff, please.
Just finishing up the segue. Another witness in the case has proposed that rates of distribution of rates between classes should rather rapidly toward equalized rates of return, defined by the rate, the unequalness of the rates of return in the cost of service study. Given the dialogue that we had, I appreciate the dialogue of the cost of service lag in a way to accommodate the future because of some data that's just developing and all those other things that you mentioned. Is the 1.0 on the cost of service study relevant?
Could you repeat that last word?
Relevant.
And everyone's mics may have been turned off for the break, so if we can just do a mic check, thank you.
Thank you, Mitch.
Thank you.
Do you want to take that?
I will start off by answering the last part of the question. I think the ratios of each class and the goal to get to 1.0 is always relevant. That said, I think you have to look at the results of the cost study, where your current revenues align and what those ratios are calculated at, and then how much movement can you make towards equalized rates of return.
I understand that, but just to make sure I understand, I'm not talking about the general idea of 1.0. I'm talking about the 1.0 as defined in the and what those the numbers would be to shift revenue between classes in the cost of service study of being as the 1.0 for people to be discussing.
I don't think it would be prudent to move all classes to 1.0 in one shift. That would be disruptive.
Was not my question.
Please restate it. I want to make sure.
If we were going to move in any direction over any period of time, is the grail, if you wish, the 1.0 from the cost of service study? This cost of service study.
Yes, I believe that Mr. Kolka started off the conversation by saying the ultimate goal in rate design is to have pure cost-based rates. Am I answering your question yet? I really am not trying to be.
No, I'm asking about the digital nature of the thing. Are the numbers from the cost of service study, if we wanted to move toward 1.0 in two steps, like was talked about in the witness, is the landing point, given the uncertainty of all the things that you've spoken about and the timeliness and all the things that can't be done and other stuff. I'm not judging those in any way. Is that 1.0 the place to go? Relevant in that point? The specific numbers from this cost of service study, or is there a bandwidth around it, or is there or how would you categorize the numbers in the case relative to that 1.0?
Let me try this, Greg.
Yes, with a caveat that I'd be much more comfortable to do it if we combined rates R and RT into one rate schedule for the cost of service, so that we minimize the chance of this migration that I think could happen, because a customer can choose rate R or rate RT. They can move from one to the other once a year. So it makes sense to me that if we were going to use this cost of service study with the inputs and all the data, that we should do it and with rate R and RT combined and make our rate design based on that.
So why I'm unsure of now what it means that you didn't do that.
We didn't do that because we historically never have done that. We did the cost of service study very similarly, except for the specific process to do customer versus demand. It's basically the same cost of service study with the same rate schedules in there. When we see this tremendous difference between, or a significant difference between rate R and rate RT, that set up a flag to say that, we need to do a little more. And when this was done, we didn't have time to look at rate R and RT and that difference in detail. Why is it there? We don't exactly know why, but we do know that customers can choose one or the other freely. So if they can choose one or the other freely, then I'd be much more comfortable going to the data that's there with R and RT combined for the purposes of the rate calculations.
What type of effort and timetable would it take to combine those and produce a different cost of service?
Within the late file time period. Yeah. We think that that can be reasonably done within the late file response time period. Meaning, I believe they're due within a week.
A late file for that model run to be made with the combining of the R and RT.
Great. So it's late file exhibit 4 to find. Okay, so it's provide a model output of the combination of R and RT.
Correct. And but right now, the proposal of the company is to not proportion the rate increase in any different way other than straight across the board, to take into account information that's in the cost of service study.
Correct.
Okay.
So this line of questioning sort of starts to go towards that revenue allocation proposal that you made with one or two on the multi-year rate plan. But if UI's proposal to defer movement to cost of based rates in this application were accepted, that is based on the cost of service study, either as filed or as amended in this late filed exhibit just requested, when would you propose customers begin to be moved towards cost-based rates to reflect a reasonable level of rate parity or revenue requirements?
Thank you for allowing us to confer. We would offer that if you would entertain the idea of us putting forth a potential change to that revenue allocation based on the results of late file 4 consolidated residential allocated cost of service, whether that would change the company's revenue allocation proposal. So it could be as soon as evaluating the results of this late file 4.
By when would that reasonable level of relative rate of return parity, by when would you aim to get there?
I'm not sure we can answer that until we see the results. Can we also include that as part of the response?
Please do so.
Okay, so I just want to make sure I've got that captured. The company is proposing to add something on to late file exhibit 4. So you're going to provide the model output, and then state whether you would make an adjustment to your revenue allocation recommendation based on that?
That's correct. And then the third portion of that is based on that, if there is a revised revenue allocation proposal, what next in order to get as close to, or if not achieve 1.0.
Okay, thank you.
Thank you, Mr. Therian.
You're welcome. Thank you.
It's fair to say that at present, anyway, the company doesn't have a plan. You essentially want to see the results of that exhibit. That's correct.
Well, the plan at the time of the filing and at the time of rebuttal testimony on January 6th, and I'll refer you to page 22 to 23, was to wait for the AMI docket to close out. We feel that after some consultation that the AMI data is more likely to affect time of use rate design, which is not as contingent upon revenue allocation among the classes. So we feel that we can give you a really solid answer in this late file forward.
Yeah, I'll just supplement that by saying distribution. So there may be, the time of day differences that we're looking at are in other components of the unbundled bill. Right now, we have time of day differentials in transmission and non-bypassable, and also in the standard service. So those values may change in the AMI docket, but absent a major change, which would be to embed time of day differentials in distribution rates, then that would not affect what we're doing here, the outcome of the AMI docket. But there was questioning in there related to time of day and seasonal differentials put into distribution, I believe. So, to the extent that anything is done in another docket, that's something that customers would have to be priced for. So.
Okay, and I will turn to some time of use and rate design related questions a little bit later. Earlier, you responded to the chair's questions about how those proceedings are important in your suggestion that you come up with a simpler revenue allocation now and address rate design later. How would the allocated cost of service study be used at the time to address rate design? I think earlier you were suggesting that essentially it had a fairly short shelf life, given the changes in the industry, some of which you cited, Mr. Kolka, and load research is an ongoing, continuous process. Would the current allocated cost of service study or amended in this late filed exhibit we just talked about, would that still have relevance at the conclusion of those proceedings in terms of informing rate design?
Going in, yes, that would be our jumping off point. We'd have to look to see if we need to add in any additional rate schedules into that than the ones that we have right now. But that's where we would start off, and other parties would, I expect, would put forth specific cost of service models, not just verbal descriptions, but actually specific workable cost of service models as to compare.
And if I think the chair noted one docket has largely concluded and others is ongoing, assuming those did not conclude, say within the next year, would the allocated cost of service study test year change in the scenario you just described?
It could, depending on the circumstances when we get to it. I mean, this would be a revenue neutral approach to designing rates. So the choice of the test year should probably be the most currently available. But the level of the rates or the level of revenue in the test year should have not too much impact on the actual design of it. It's, what we do in there to, unless there was a significant difference between running the model this year and running the model next year, the same model. If the results are similar, then, that's something that we wouldn't need to worry about going into the next one. So, I think we can use this particular model as the jump off point in any future docket that we have.
And you're talking about a future docket that is rate related as opposed to one of these on proceedings that are already underway, the two docket 1712 REO proceedings. In other words, you're not suggesting that within those dockets you would offer a new rate design based on the allocated cost of service study?
I think the only opportunity would be now in the AMI docket, REO2, but it may be out of scope in that docket to do a full cost of service study that's not time of day related. So there would, at this point, there would really be no, with RE11 being closed, there would be no additional docket established that we know of right now.
If I may offer that this is a multi-year rate plan application and that there is an opportunity annually as rates change to perhaps introduce some rate design changes also at that time. Again, in the name of gradualism, it's an opportunity.
Okay, and so those dockets in particular are not the necessarily the preferred forum for addressing relative rate of return and rate equity. Rather, another docket would focus on those.
It could be the instant docket is my point with reopeners, because this is specific to United Illuminating. To Mr. Kolka's point, you could update the test year for purposes of the allocated cost of service model. You'd have the same allocations. You'd rerun it. You'd be able to look at your ratios, see where your revenues are, perhaps make some interclass adjustments with revenue allocations and try to get closer to 1.0.
Thank you, Mr. Therian. Mr. Kolka, you testified in the last docket that there was an objective to move rates towards parity over the ensuing 4 years. This was back in 2016. Since that point, did the company implement any particular policies or actions to try to make that happen, to achieve that objective?
No, we implemented the rates as approved in docket 160604. So there was nothing that we could do on our own.
Thank you. If the company were ordered in this docket to begin to start to move customer classes and rate schedules towards equalized rates of return, the period of time, just want to make sure I understand your answer, Mr. Therian, would be determined no earlier than the filing of the late filed exhibit, the last one, the fourth one that you talked about.
That's correct.
Can you opine on, again, I understood you said we really want to see the results of that.
Yes.
But as a practical matter, let's just assume for the moment that once you combine radar and RT together and produce this late filed exhibit, that the relative disparities between residential and the over contributing commercial classes prevailed. Would that, do you have any sense of how long it would take or should take as a policy matter to try to get to that acceptable level of rate, equalized rate of returns, whether it's a bandwidth or the perfect 1.0 that one witness has suggested? Is this a 2-year process? Is it a 5-year process?
I can't answer 2 or 5, but I would say it would be closer to 5 than 2. It has to do with evaluating the individual class bill impacts at various strata. And honestly, it matters how aggressive the authority wants to be in getting to that endpoint. When we restructured in the late 1990s into the early 2000s, there were some pretty aggressive rate design changes. Since then, it's been fairly stable, with the exception of what goes on in the generation market. So if the authority wanted to move more aggressively, that's up to them. My opinion on that is more towards the 5-year than the 2-year.
Thank you. The cost study has shown, setting aside the radar and RT, whether they're mingled or not in the next iteration, it showed residential is largely under contributing and the commercial classes are over contributing. Do you have any comments on what are the impacts, generally speaking, to the company's customers and to the Connecticut economy with cross subsidies embedded to the extent that your cost of service study showed?
I cannot answer the question about the general economy. I can just opine on what I think would happen between the rate classes. Obviously, paying more than the average rating increase for residentials would be something that we would have to explain. I think that the company could do so. I cannot opine on how that would affect the general economy. I'm sorry, I can't.
Would rates in the commercial sector that were closer towards their indicated cost of service, would they help in any way with regards to the economic development portion of your proposals in terms of attracting and retaining large customers?
The two are intertwined. So there is a proposal for an economic development tariff with a set of discount percentages based on economic activity, incremental economic activity in the way of incremental investment and incremental employee count. To the extent that rates are lower by virtue of rate design, then the impact of those economic development percentages are lower, and vice versa. To the extent that rates go higher, then the discount has more of a dollar impact.
You're aware that CIEC witness Mr. Baudino recommended a pretty aggressive movement towards cost-based rates?
I am aware of that, yes.
What do you see as the benefits or risks of adopting the approach he proposed?
Well, if I may also add, he also has a very, in my opinion, aggressive economic development proposal as well. I find if you were to be moving aggressively towards cost-based rates and then also adopted his aggressive economic development, I think you could really be causing some disruption in rates between classes. So I don't agree with him on that. So I'm not necessarily saying it's one or the other. I think you can balance moving towards equalized rates of return, which, to your point, with commercial classes being below the 1.0, above the 1.0, would imply that they would get less of an increase in residential. But I think that should be tempered with any economic development tariff.
My next question concerns the multi-year rate plan proposal. Is it your testimony that a 3-year multi-year rate plan, as you proposed, is it your testimony that projections of cost of service, including capital costs and revenue requirements, out so far would fully meet the regulatory standard of known and measurable?
I think that's beyond the scope of our testimony.
Are you comfortable that the multi-year rate plan satisfies that regulatory standard?
You know, those are questions I think that have to be directed to a different panel. You know, that's really not something that tariff pricing and cost of service can answer.
Which panel would that be, Mr. Kolga?
I would say probably the revenue requirements panel, or maybe either that panel or they would be able to provide a better answer.
Yeah, just, Mr. Fairness, the revenue requirements panel will appear on a couple, well, the testimony was filed as revenue requirements. They'll appear both on the capital panel and the O&M panel and a later one. So that's Mr. Hurwitz, Mr. Dane, and Ms. Wakefield.
Thank you, Counselor.
Sure.
On the revenue allocation, that's all I had. My colleagues have any additional questions?
Yeah, just a couple. You proposed to determine the class portion of the rate increase you're requesting by by having an equal percentage where you based the percentages as percentages of the total bundled bill, including generation services. As just a delivery case, cost rate case, why did you propose that?
Customers, when they're looking at their bill, they look at the bundled bill. They have to pay the bundled bill. And that's why we wanted to equalize the increase on the bundled bill. That's really what they face.
Okay. Did you estimate the impact of what those numbers would be on the distribution? If you did it based on distribution, I believe that might have been a data request. I apologize if it was.
We may have answered an interrogatory on that. I don't recall specifically, but something rings a bell with that. I'd have to look for that and then read that back in or take that as a late file and dust off that
I think it's indicated.
interrogatory.
I think it might have been Mr. Guardino that actually calculated that. I apologize for that. So did you evaluate the impact of your proposal on the narrowing or exacerbating the spread for relative rates of return?
Can you ask that again, please?
Yeah. Did you? We know that from our discussions that if you equalize rates of return or move to do that, the classes with the lower numbers get more of the revenue increase. You are proposing by doing on the bundled rates that the versus distribution rates, that the residential customers get less of the increase. Residential classes get less of a rate increase portionality than they would have if you use distribution rates were used. That would sound like it was somewhat equivalent to exacerbating the spread in the relative rates of return. Would you agree?
I'd have to run those numbers. Would have to see that. I'm not comfortable without seeing the numbers. I'm not comfortable making that statement without seeing the numbers. Or without calculating that difference, which we can do.
Yep, it might be, it'd be very helpful if you could have a filed exhibit that would do that.
Okay, so that would be lay file exhibit 5, but Mr. Athos, you can please summarize the prompt for that.
Yeah, to calculate the impact on class rates, relative class rates of return of the bundled methodology versus to distribute the requested rate increase rather than just distributing it equally over distribution costs.
We'll figure that out, but there'll be a problem there in that the cost of service study was done at the test year. We didn't do a rate year cost of service study, but the rate increase happens in the rate year. So we can't do that calculation directly, but I think we can probably cipher something. We can figure something out to come up with something similar.
Yes, in the relative nature of the fact that you were applying the results of the 1.0 of the numbers in the cost of service as the target in the future to move to with 1.0, then there's some relationship between those, the progress being made or the lack of, or the reversal of the action that you proposed with the bundled rate calculation. So that's I know that it's in the sequence that rate cost of service and rate information is developed in the across the utility world, that it's kind of like we don't go back and look. But we've already had some discussions about the fact that the cost of service study is, while being uncertain and having not reflective of the future, that the 1.0 on your guys' mind was still the target for movement. And I'd like to know whether that, to what extent that is backtracking by the proposal that you had.
I think what we can do there is take the revenue allocation, and we'll do it for just rate year 1. Take the revenue allocation as we proposed in rate year 1, and then drop that back to the test year revenue requirement. So, what we did is we increased it. We got to this number. We did it based on a bundled basis that resulted in changes to all the distribution rates at the rate year 1 revenue requirement. I think it should yield the answer that if we multiply that by or take it down by the ratio. So let's just say the ratio is 25%, a 25% increase. So I'd drop it to a 25% decrease until we get back to where the test year revenues are. Then we can compare what those test year revenues are to what those revenues are under the test year amounts and compare them to what the actual test year revenues are. And I think that gets there.
I wouldn't want to constrain your methodology now until you work through the numbers, having been in your seats. So I would just say that that if, to the extent that it's indicative, whatever methodology you choose to do, as to whether, first of all, directionally indicative would be helpful, and then relativeness of whether we're talking the 11th decimal place or a percentage point would be also helpful,
Mhm.
just to understand that.
I think we understand the request.
The, so, if you, let me drop that. And feel free to use some of the numbers that were a part of the case if that might have been filed by other witnesses, and if that expedites your ability to do this. I'd like to move to some questions on cost allocation and the RAM components. Just pull something up here. As a starting point, there are definitely differences that everyone knows of the ways that the different components in the adjustment mechanisms get allocated amongst the classes. Correct?
That's correct.
Okay. The NBFMCC and the TAC charges, which are associated with generation transmission market or system operation, gets allocated by the 1 CP and the 12 CP method.
Correct. Non-bypassable 1 CP, transmission 12 CP.
Okay. And that would be a common practice if we roll back time and you were actually allocating generation costs and transmission costs. Those are the cost of service. A lot of the cost of service parameters that were generally accepted principles to use at that time.
Yeah, the generation capacity costs.
Correct. So, and several of the components of the system benefits charge are allocated by revenue, by energy.
The system benefit charge, the SBC?
Yes.
It's a UI, it's exclusively energy.
Okay. And are any of those costs based on activities that vary by the amount of the cost that's incurred for different rate classes?
I don't understand that.
Are the benefactors of the in terms of classes of the costs that are associated with the system benefits charge are the result of your allocation, would that be proportionate to the amount of money spent on each of those classes?
For the system benefit charge, that's primarily benefiting residential, low income or income eligible customers. So the costs incurred for most of the SBC are due to the residential rate classes.
Okay. Oh, that's helpful. Thank you. In the adjustment mechanisms, you've proposed to exclude certain revenues from the calculations of the decoupling mechanism, the true-up mechanism. Is that correct?
I think we need to get our colleague, Mr. Patel, up for RDM questions.
Mr. Mathis, can I ask you to repeat that question, please?
Sure. I'm actually going to back up one step further. The allocations that are done on for TAC and the non-bypassable charges, that I believe is based on low research data that's updated every year.
Correct.
Is that updated is there any weather normalization that takes place with that data?
No, not in the load research data.
Okay. And no, that's fine for that. Thank you for that question. For that answer, what I was wanting to talk about was the fact that the proposal by the company has some revenues, other revenues excluded from the decoupling mechanism calculations, I believe. Is that correct?
That's correct. Yeah, and details of those will be highlighted by our revenue requirements panel as well. Yeah.
Okay. In a general sense, for those charges, since you're doing some things year by year with like, why would those other revenues utilizing? Do any of those other revenues utilize resources that are funded through the revenue requirements in this case?
Coming out of the 160604 docket, we believe that we had captured all. We believe that we captured all the revenues, all the activities that were going to be funded through the revenue requirement in the other revenues. The difference here, there were no new business models coming out between 2016 and 2022 that was resulting in additional revenue derived from expenses that were included in the 2016 revenue requirement. So we were not generating new revenue on the expenses that we had already included as part of the revenue requirement.
Okay, so then I think the answer to my question is none of the revenue that you want to exclude utilized in any way resources that are whose costs of which are represented in the revenue requirements of this case.
That we want to exclude in this docket or in
the exclusion of certain revenues from the decoupling mechanism. I was trying to get at whether any of those, if to get those revenues, if there were any resources used that are funded by the revenue requirements in this case.
But is that in the RAM docket that the current RDM is being handled in, or is that in the other revenues in this docket? I guess asked a different way, are you talking about other revenues that have already happened or other revenues that will happen in the future?
Already happened.
Okay, so that docket is, that's in the RAM docket, and there, the 2006, I believe that is correct. There are no new revenues in there that are based on the revenue that are supported by the revenue requirement that was approved in 160604.
Okay, now could we take that one step further, that are they supported by the revenue requirements that are resources that whose revenue requirements are in this case?
In this case,
Yes.
that's a question for the revenue requirements panel. They'll be able to describe everything that's in there.
The use of regulatory deferrals in the within the RAM proceedings, just to clarify, is that a request of this within this application?
That's, once again, I think that's for the revenue requirements panel.
So the revenue requirements panel will be the one to ask if if revenue loss associated with economic development or the low income discount rate into a regulatory asset is whether that is connected to costs or activities that are being funded by this case. Is that correct?
They will be able to describe in more detail everything that has been proposed in this case. But I think in general, if there is a change to the sales, and remember, we get our revenues from sales of electricity, primarily from sales of electricity. And these other revenues, there may be pool attachments, there may be a few other items that come in as other revenue. To the extent that the programs like the low income discount rate and other programs may increase or decrease the retail revenue we receive. We're not talking about other revenues right now, but just the retail revenue we receive. The rate case is it's a design approach. So we're assuming that we're going to get all the sales that Mr. Patel has forecasted. We go, and in that case, we did not model, as far as I know, right? We didn't model a low income discount rate sales reduction specifically. Mr. Patel will go through in detail what was modeled and what wasn't. But whatever is modeled and gets in there, it's all handled as a single sales, that to each rate schedule. And to the extent that those sales either materialize more, then we would collect more retail revenue, which would result in the rate years when they become operational, that will result in a revenue decoupling. That in that case, if we got more revenues, that would result in a credit to customers or contribute a credit balance to what customers would get. If we see a loss of sales, it's going to go just the opposite. So that's how that works. But we don't model what the RDM is going to be in the rate years because we're designing rates according to a set of sales that we think are going to materialize.
And in the so to summarize and maybe make my question more pointed in the process, the appropriateness of creating a regulatory asset for things like discount, loss of revenues for discounts, comes from the fact that the expectation was that the sales to turning to revenue would have occurred in a certain way, assuming those discounts don't happen.
If you mean a regulatory asset, the RDM asset that gets booked and that was established back in the 2008 rate case, that particular regulatory asset, which could have an asset or could have a debit or a credit balance, that's going to depend on the sales. The retail portion is going to depend on whether we're above or below our target revenue. If it's if it's a regulatory asset for some other reason, then that's a question for the revenue requirements panel.
Thank you. If you utilized a different test year and accounted for the all the estimates of revenue and other factors that you true up in the adjustment mechanisms, would they be interchangeable?
I don't understand the question fully.
I'll withdraw the question. Unless my colleague has some more questions on the revenue allocations and the cost of service, I'd like to move on to the economic development. Good. Okay. Let's see. When you designed the, in the testimony that was put forward, you generally said that you looked at lots of places where there was economic development rates, and you got saw some that have all these different characteristics, and that was generally part of the December 13th testimony that was filed. Did you look back at any economic development rates that United Illuminating had?
Have you ever had new D rates?
Oh, no. The answer to that is no. We never really had economic development rates. We had special contract rates from the past. But as a type of economic development rate that has been proposed here, to the best of my knowledge, that we didn't have any of those.
I believe that in the late 80s, like 1987, Pure approved economic development rates for UI.
They may have. I haven't looked back. That was before my time.
And I believe they were still in use in 1996, 9 years later.
I can take a late file and go back
Sure.
into our records if you'd like.
I believe that right now, I believe that you said it in one of the data requests that you haven't made a forecast of participation in the economic development rate. Is that correct?
Correct.
Would we, as I think about the construct of the late file, but would you expect that there could be 200 customers on the economic development rate after a few years?
I couldn't speculate to an actual number. It depends on the design of the rate and the participation. That's 200 customers. Are they large customers, medium, small customers? There's also, a vast range of size that commercial and industrial customers are. So I couldn't.
Okay. Well, I mean, the rate applies to the economic development rate as you proposed applies to all those different size customers, correct?
I believe that we did not have a specific size. Did we have a specific size? No,
No, we do not have a size requirement.
So if, I'd like to have a late filed exhibit that to the extent you can find the available information of contrasting the economic development rates combined with special contracts that have an economic development purpose that UI has used in the past as far back as 1987. And compare that to the proposal that you have now, both in eligibility, level of discount, process by which you're proposing to qualify customers for those for that economic development rate participation now versus what was used before.
I can go find the tariffs, but specifics for those contracts, they probably don't exist anymore. And any kind of financials around it, they won't exist. Those will have already been, destroyed, those records. So,
well, maybe you could find, so if you can't find it, obviously directly that as a number, but my understanding was that in 1996, the discounts were somewhere between $50 and $20 million annually for approximately 200 customers. So to the extent that that could be corroborated by someone at UI, recognize that that's the 90s are a ways back.
So I can search the drives, but there's no one left at UI from that period. So that there'll be no one who has any institutional knowledge of what happened.
And well, and if there were economic development rates, I suggested that this would be as far back as 1987. If there was economic development rates in place, were there economic development rates in place sometime in the first decade of this century?
There were special contracts, but I don't know if there was something where we had an actual tariff. I'd have to go back and check. My time started in 2003, so I don't know what went on before that, other than what I've seen just in my travels through those old records.
Okay.
But I mean, I'll look on our network drives and I'll try to find what we can. There's probably no paperwork, nothing on paper, except the old tariffs. We still have copies of the old tariffs on paper. So if it's in one of the old tariffs, I can provide that.
And if you look at the old tariffs and supply that, that'd be very helpful. If you, to the extent you want to comment on whether anything would change that in your proposal here, based on the brilliance of the past. Thank you. Now, I'd like to talk about the design of the.
I'm sorry, Mr. Athens, that was a late filed exhibit
Yes,
request?
I'm sorry, yes, that's late.
Should have been, that is late file exhibit 6.
And that one I could summarize more succinctly, past economic development rates. Okay. The design you have, let me start at a more mundane point. Who are you, who is UI competing with to get to land those customers in Connecticut?
Everyone. The world. Sorry, the world. I mean, you see other states that have competing tariffs. You have tariffs. You have, other countries that are trying to woo away certain businesses. So, economic development and economic development incentives are really a worldwide
Okay, so
phenomenon.
is the competition on how rich the incentives are or the level of costs in the, in between their alternatives and Connecticut?
I think it's the latter. It's their cost structure in Connecticut and probably a lot of other factors compared to, and let's just limit my answer to the United States. So if for a company we're thinking about expanding in either Connecticut or say Indiana, just pick another random state, they may, be looking at, among other things, the cost of energy.
Okay, so if the suggestion there is that that's a factor and we improve that factor by some addition of economic development rates, does that make you rethink the even the directional tone as to whether you would suggest that the economy is negatively impacted by commercial customers having a higher rate than they would have if they were on equalized rates of return?
I think the nexus between equalized rates of return and the company's proposed economic development rate really didn't exist until we started to talk about it a little bit here today. The concept of an economic development rate was born in one of these other proceedings. And this is the proceeding in which the company essentially is making a proposal consistent with the decision in, help me, Mark.
I think that was from, I believe that was the rate design docket, but it was brought about by statute.
Okay.
Sure. I'm just trying to understand the earlier question that you discussed with my colleague, that that if rates are higher for commercial industrial customers than they would have been if the rates followed direct allocation from the cost of service study. I believe that you didn't want to venture a guess as to what impact that had on the economy.
I don't think we could quantify that. The rates are what they are and were what they were. And
I wasn't necessarily quantifying. I just was trying to think direction.
I think in a general direction, the lower electric rates are, the more competitive an area is.
Okay.
Particularly for energy intensive industries.
Okay. Can you describe very quick, generally, how for a new commercial or industrial facility customer, not somebody bigger than bigger than average, almost like thinking about it as the Amazon warehouses that pop up every 2 minutes in a different place. What's the policy for customers contributing to making a contribution to any of the costs that UI has to incur to serve them?
Mark's contribution in aid of construction question. I don't know.
To answer that question fully, I think we would need to take a late file and then go and talk to our customer engineering folk and other groups to see if there's specific policies. In general, I think that sole use facilities are going to be charged directly to a customer, but we provide network service to customers in general. So there may be a lot of expenses that are going to be part of the network, but
that'd be great to get that in a late file. I would like you also to note whether there's that contribution in any way changes based on the expected load, and whether the to any extent that you want to use examples unnamed of which company or even illustrative of what the cost of that contribution to aid construction might have be compared to the revenues from that new customer.
Okay, Mr. Athos, can you summarize that prompt for me, please?
Sure. The method, how it's determined that what the contribution aid construction would be for new customers, new commercial industrial customers. And an element of that will be the relativeness to their energy revenues that they were giving UI.
Thank you. That's late file exhibit 7.
Do you think that that if that was higher than places that we customers have alternatives to locate, that would be an impediment to economic development?
Tariff policy on contribution and aid of construction certainly could play a factor in decisions.
Okay. Have you ever, it'd be useful if you could comment as to whether you've done a recent comparison of that to other utilities or to the industry standard practices? If you conclude
I'll
that.
check with our benchmarking group, but that, I don't know if we've done that type of comparison. Specifically that type of comparison. They benchmark many things, but I don't know if that's a particular comparison they would use.
That we'll find out if they've done it by the answer. Okay. Can you I'd like to understand the rationale for the eligibility thresholds of either 10 employees or $1 million being the first threshold step for because I'm going to ask you a lot of questions about implementation. I just want to make sure that I understand how this is going to work. If it's approved and you guys get out there and start going through the paces. So can you tell me about the 10 employee threshold and the $1 million, and why you think those are interchangeable, have relevance to each other, have no relevance, whatever they are?
So this is, despite the fact that there may have been an economic development tariff in the 1980s, our thinking was that this was a new tariff, and we're helping the company pave new ground with a new tariff. So what Concentric did to help and inform the company was to do some research across the country to see what other economic development rates were, what their criteria were, what their thresholds were, and do some qualitative comparisons based on those tariffs. And we found, and this is largely in our response to CAE 0001, attachments 1 and 2. It shows the research that we did and the findings. And it was essentially a discussion and collaboration with the company to say this seems like a logical first step for the company to make. It's not a pilot, it's a tariff, but it's I would say a reasonably conservative first step to see how effective it is, and the cause and effect, not only for the ability to attract new customers, because this is a growth, if you will, economic development tariff, but also what the overall interest is. So we don't know what the sweet spot is where you know, this is a great tariff and it's helping the economy grow like crazy, or, you know, there'd be no interest in it at all, you know? So we were instructed by what others did, frankly.
Okay. For new customers, the discount applies to their entire load of the facility.
Well, there's two things. If I heard you correctly, sir.
For a new customer.
A new customer, it would apply to their entire load, correct?
Does a new customer include someone that relocates their facilities to a new location?
If it comes from outside of the service territory, that's my understanding.
Correct, yeah, we wouldn't provide an incentive for someone to move a facility from one spot in the service territory to another.
Okay, so you would treat that you would think of that essentially in a business retention kind of manner, and you've not proposed to do any business retention with the economic development, right?
We did not propose a retention rate.
Okay. For an existing customer, you've also chosen to propose that the discount be applied to only an incremental part of the incremental part of their electric bill from the that came about from the 10 customers or $1 million and then up the ladder. Is that correct?
That's correct.
Okay. And why do you? It's been suggested by other witnesses to oppose it to the whole bill. So what are the benefits that what are the benefits that the customers of UI get by having it, not the participating customers, every customer, by having that on the incremental versus the total discount, total bill?
By way of example, perhaps I could help. Sure. So when we were thinking about this, I thought about, you know, what's the incentive for an existing company to add a second shift? So if they're a 9-to-5 company and they're a manufacturing company and they want to, and they have multiple options, multiple plants across the country, why would they add a second shift in Connecticut as opposed to adding a second shift in Indiana? Well, because they're going to have an economic incentive from the electric company to do that. And it may help the economics to sway that decision to add the second shift to their Connecticut plant. And what that does for all of the other existing UI customers is that it provides incremental revenue, albeit not at full tariff rates, but well above the incremental cost to serve that incremental load. That incremental revenue then helps, all else being equal, helps reduce other customers' rates.
So the net effect that you've mentioned in some responses is that because the revenue, the incremental revenue, which you'll go through and estimate the load and then run it through the tariffs as to what the tariffs would have been, what the bill would have been with and without that load, I assume that's the, and then you apply the discount. That doing it that way is assuring that that load, that new second shift, as you said, creates a contribution to fixed costs.
That's correct.
Okay. And potentially, if you applied the discount to, if you had a very small incremental load for that was created, and you applied the discount over the entire load of a customer, the net change could be negative.
That's correct.
Have you set any methodology or process for written down in place for how you're going to do that incremental load determination for the existing customers?
Yes, in the company's proposed tariff on the second page, terms and conditions, second paragraph. If you don't mind, I'll just read it. The company may install at the subscriber's expense metering equipment at an existing customer premise to measure expanded load to be billed at the discount rate, separate from the customer's existing load, which will be billed under the applicable standard rates. If not feasible or practical to separately measure the new load, the subscriber and company shall agree upon an approximation of baseline usage by which to segment the incremental load applicable under the service agreement.
Great, thank you. That clarifies that. I must have forgotten that when I first read it. So is there any relation to the number of customers and the number of employees? Sorry, I keep saying that. Number of employees, like 10, and the relevance that is to the size of a company. If Sikorsky comes back and says they've increased their employment by 50, we want the max discount to some new load and other stuff. Is there any tolerance to what their employment level fluctuations are that would be taken into consideration?
Admittedly, not every situation was contemplated. So in your case, I think if Sikorsky adds an additional 10 employees, it'd be very difficult to track that. There is an attempt to make a nexus between increased employees and capital investment, by having the same amount of discount and terms applicable to it, but there is no baseline. I think what we're trying to establish here is there like some sort of tiering of customer size and different requirements for those different tiers? No, we did not propose that.
So are you trying, and in the general way of administering that process, that would be United Illuminating would be the decision maker as to whether it's not appropriate to be part of the economic development rate or not.
One moment, please. I'm looking for a specific language in the tariff that I seem to recall. Well, I don't see specific language that says that, but the intent is that the company has sole discretion as to whether the applicant meets the terms and conditions of the tariff or not.
And what you've described, I'm not trying to put words in your mouth, but just what you're envisioning that the application of this to a new customer, existing customer expansion, is one where there's a definitive stepwise change in their in the way what they're doing at their facility, by either by having a tangible thing like an investment, by adding that second shift, putting on another line of machinery so that they can stamp out twice as much or anything like that. Is that the action that you're trying to have the economic development rate apply to?
I would say yes.
Okay.
Your characterization is what the intent is. Yes.
And you would try to avoid one that doesn't expansions that may, or like increased employment that may come naturally and not really have an economic development based decision for them to do that.
Yes, we would like to have a tariff that avoids free ridership, very much like energy efficiency programs. You try to design them for a specific purpose and minimize free ridership. That would be the goal.
Would you, and it's a good analogy. Would you, do we generally think that in the energy efficiency that the lower the incentive is, the more the higher percentage of participants may be free riders?
The lower the benefit,
The
higher
lower the
ridership.
incentive, the lower incentives. If you tell somebody that you're going to pay 5% of their attic insulation, just to pick something I've done recently, the cost versus 50%, would you expect that the percentage of free riders would be higher in the lower lower incentive situation?
I think that's a question that could have been answered already, or better left for the conservation and load management plan that's done every 2 years, I think. There may be research on that. I know that the company, the UI, has not of and of itself for rate making purposes done any of that type of research, but that research may be published in the conservation and load management plan.
I apologize. With the reference to free riders and energy efficiency.
Exactly.
I'm really trying to wonder whether let me take it in steps. Do you believe that when this is implemented, that there will be free riders that participate in the economic development tariff?
The design is intended to, as I said before, be a fairly modest introduction. To your previous question, the company has the right to determine whether an applicant meets the terms and conditions and qualifies for the program or not. And third, I will take, and this is my reasonably formed opinion, that I think the terms and conditions around availability and any thresholds and any requirements, the lower or the less stringent those requirements are, the more likely you'll have free ridership. I don't think the percentage of the discount is as much of a factor as how easy it is to qualify.
So does that mean that that a higher discount rate, well, instead of topping off at 10%, topping off at 25%, for instance, wouldn't attract additional load?
I'm not sure I understand your question.
Well, I'm just trying to understand you mentioned free riders, and I'm trying, and I think if let's take the 2% for the location, 2% bonus for location in distressed cities. Do you believe that that's going to make a material impact between whether somebody locates in that location versus someplace else in the United Illuminating?
Thank you for that premise. I'm not sure if 2% is a magic number, but I've seen it in other jurisdictions where 2% for distressed municipalities seems to be the adder, if you will.
Okay. So if to the extent that the discount, the economic development discount that's generally available was enough to have someone go into a distressed municipality, that would create a situation where they're essentially a free rider on the 2%.
That's a possibility.
Okay. I mean, just definitionally.
Definitionally, there's always a possibility for free ridership pretty much on any program design you have, unless you make it so difficult that no one ever qualifies. So it's a balance, right? It's a balance between how stringent your availability is and the amount of discount that you have and amount of authority, frankly, that the company has to say yay or nay on an applicant. I think that's how free ridership is best controlled.
Would UI, I think, as said that you'd be doing some reporting to the Pure on the to the authority on what kind of participation there is on the economic development rate, correct?
Yes, it's twofold. First, there's the reporting aspect of it, which is what is participation while redacting customer specific information, how much the discount is as a program. So that's I think that's envisioned as some sort of compliance filing. And then the second piece is, and this is the initial proposal for the introduction of the tariff, is to account for all revenues and expenses related with this program in a regulatory asset or liability, depending on the direction of the balance. And that would also provide an opportunity for the authority to review impact on rates and the efficacy of the program.
And I'm just very focused right now, and I'll let you know when I go off it on the implementation of making the decision. Implementation of the tariff, and kind of a point of sale in a sense. So what level has it been decided as to who has the authority to say yay or nay within United Illuminating that the customer qualifies?
We've identified a group that we believe can handle that. We have a key accounts group, and the key account representatives are used to working with at least larger customers right now, and we have a number of managed accounts. Those are the larger accounts. So to the extent that larger customers will take, would seek service under this, they already have a manager, a UI account manager, who can then go in and work with them to get the data that's needed to verify the application. And if it's an unmanaged account, our thinking right now is that someone from that group will look at it, but there is an economic development group that is most likely going to be the one who will be implementing this program.
So there's an economic development group that would, in some way, shape, or form, review the application and the situation, and then sign off yes or no for that they qualify.
Well, the actual design hasn't been done yet, but that's likely going to be the end result, is that someone in that area will do the work and make a recommendation. And then at what level that has to be approved, we don't know yet.
So would should the authority expect that that there'll be documentation of that decision process for each case kept by United Illuminating?
I think yes. I think that is something that needs to be done on a case-by-case basis.
And that, subject to lots of confidentiality and care and feeding, would that be something that that then United Illuminating would be comfortable sharing with with proper confidentiality treatment with representatives of the authority?
I think that, yes.
Okay. The back to the design, it strikes me that and it was mentioned by witness for OCC, that the tiered structure and the qualification process could end up where the same amount of new load is created and they get different discount rates because of differences in employment or investment, and therefore you have a different price to the same new load. Is that something that is acceptable, something that needs to be tweaked, something that that it would be best to design out of the tariff?
So when we went about this, we thought about it in two buckets of benefit. The existing ratepayer, what's the benefit to all other existing ratepayers? And then two, the general economy. The first one we feel is really confident that we can quantify what the benefit is, and that is the incremental revenues over the incremental costs. And that helps, all else being equal, existing ratepayers. The benefit to the economy is, as I mentioned before, was beyond the scope. And in my opinion, I think it's beyond the scope of a utility to have to go and do those type of studies. I think that's somewhere we're partnering with, like the Department of Economic and Community Development, a state agency, where they run economic impact analyses. They could do studies like that to help quantify that. But to your point about the tiers, the added load is but one of the considerations. The incremental employees and capital investment is in that second bucket. So to answer your question, yes, I think it's okay. To answer another part of your question, could it be tweaked? I think this would be an evolving tariff. And again, I think as a first foray back, and perhaps back into economic development tariffs, we think this is a fair and equitable first approach.
Okay, so two customers showing up that have different degrees of employment and different degrees of investment to have them qualify could have very similar loads and be priced differently, if I understand things correctly. And right now, as you said, this is starting. Right now, I believe your answer was that you're comfortable with that.
That's correct.
Okay. You've chosen to make the level of discount when someone is viewed as qualifying very prescriptive. 5, 8, or 10% plus 2, maybe. Okay.
That's correct.
Why that structure rather than negotiated?
Well, we did not rule negotiated special contracts out of the picture. We just felt, and the company felt, that there's a balance between the administrative costs and the overall economic benefit. So let's go back to your example about Amazon. Let's say that it's more than just a warehouse. Amazon World Headquarters wants to move to New Haven. That would probably be much bigger than a United Illuminating management call as to what to do, right? There would be some significant other state government discussions, and I'm sure the company would be involved in that. And an equitable special contract arrangement could be made in concert with a much larger deal, if you would.
Is it safe to summarize that, and appreciate the example, that the consequences can be dealt with if the prescriptive nature is insufficient for the attraction of the customer?
Yes, and we did address that in testimony, where if an applicant said this is inadequate amount of discount to attract our business, it would be up to, and if I may say that the group within United Illuminating would essentially raise their hand and elevate it through their management structure to the point where United Illuminating would decide whether or not they could support that applicant in front of this commission for a special contract.
Okay. The, is it in the record, someplace of the growth of the number of customers in the, number of new customers in the classes that you, that are eligible for the, EDR?
We may have entered an interrogatory on that.
It could be something that you come back and, because I'm not, we're obviously not gonna be finished at the 5:30 for this line of questioning. Tomorrow, you can just let me know if that's in the, is it?
I think Mr. Patel has looked at that in detail. We can take an interrogatory back on that if you'd like. Number of customers over.
Well, what I'm just trying to get at a little bit is this idea that the, again, what we're gonna hopefully look forward to happening as if a EDR is approved, of what this, how to look at success. And if you have, if, you know, in round numbers, if that group of customers was growing, eligible customers had new customers, and I recognize that even in new accounts, it might not be exactly the issue, because some of it might have been relocation and not eligible. But just, if that number is 100 a year, and those are 100 potential free riders.
100 new customers a year, it's probably going the other way. We're probably losing 100 of those customers a year. Our industrial customer count has been going down for 10 or more years. The actual customer count is going down. The commercial count stays about flat.
Well, I was differentiating between new and net number. So I'm trying to actually ask you, and we can maybe pick up that a little bit tomorrow. Is the number of new customers, not the net increase or decrease. Because the number of new customers would be the people that are eligible for consideration of the EDR.
Now, we don't store data in an accessible fashion to see who is truly new. I mean, that's all in paper records, but what we have that's extractable is customer count.
Okay. If it doesn't exist, it's be pretty hard to produce. You've also chosen in the design not to discount generation services.
Absolutely. That is a competitive market, and we are not involved in that whatsoever.
Okay, so do you think that the dialogue that'll have to happen in the economic development eligibility consideration, that they'd understand that that a 10% discount is a 10% discount on part of their bill that they would see, and as compared to the belief that it was appropriate to do bundled rate design on the total bill, because that's what customers look at.
I think it's quite clear in the tariff that it was intended for delivery only. In the proposed tariff, I believe it says that.
Sure, it's proposed that way. I'm just kind of trying to understand the interaction with the customer at the time.
I think most of the larger customers are sophisticated enough to know that this is an unbundled state.
Okay. So by excluding that, the generation prices, anything that's happening on the generation services charge does not affect that example calculation we were talking about that locks in some contribution, incremental contribution to fixed cost.
Correct.
Okay. And if the discount to the generation portion was implemented, as has been suggested, you could end up with a situation because the supplier of the default service wouldn't discount. They're not in the discussion, so might not necessarily discount their cost to UI that's being passed through. You could end up in a situation where now the net incremental revenue of this new customer is less than the incremental cost to serve?
Well, the generation revenue is not ours, so it wouldn't be relevant to us.
Yeah, and I understand the way you are proposing to do this discount is you do the delivery charge calculations, and then you're going to take, instead of doing it by component, then you'll take 10% of that or 5% of that, 8% of that, and have that be a credit on the bill, correct?
Correct. A credit, the percentage based on the delivery charge.
Right, it'd be calculated times applied to the delivery component of the charge. So if it was, as been suggested by someone, another witness, that it'd be applied to generation services, that same calculation could be done, the same credit could be done, and not changing any of the transaction between associated with generation services revenue.
No, not by us.
Right. Okay. So that tells me that the design that was making it so that you could assure a contribution to fixed costs would be impossible to design into that if you were discounting generation costs.
That's correct.
Okay. Or should discounting generation charges?
No, charges, right. The revenues that would be discounted would be an unknown, and it would potentially disrupt the contribution and aid in construction calculation. That would be correct.
I was going to move to, actually, let me just take a couple seconds and talk about about cost recovery and like. So you've proposed to take the costs associated with implementing the discount and track that into a regulatory asset. Not worry about the discount now. We're just talking about the cost of that, to do that. Would that include the key accounts person time? Or is it an incremental cost?
We have to be careful about that because that incremental, that person's time, if it is part of that person's business and that person's salary is in base rates already, I don't know, we'd have to talk to the accounting group on how to handle that. It's definitely not anything in the revenue requirement now. So we're not looking at this point for any incremental labor associated with it. So to that extent, if they need to hire someone in addition to because there's too much work related to this, then that would be an incremental cost that we would seek to record. We'd have to ask the accounting group on exactly how to do that. But conceptually, if it's an incremental cost, that's the kind of thing we want to capture as part of this. If it's someone who is able to do this in the normal course of their job, those costs are already included in rates. So it becomes a much stickier point to try to get those out and get those recovered somewhere else. We would have to, do a lot of work on that.
Well, just to make sure that I understand the definition of stickier point, would you agree that if an account executive spends half of their time for 3 weeks courting this economic development customer and helping them go through the DECD process, because you'll obviously be working with them and other stuff, that, and then they don't touch another EDR for a while, for 6 months, that you would not be putting their time for that half time for 3 or 4 weeks, whatever it is, into the regulatory asset that you're requesting to be recovered at a later date.
I think it gets to a point of magnitude. If it's not a lot of time and money, then we probably wouldn't. If a person started spending a lot of time doing it, then that is an indication that maybe there needs to be an incremental resource. So if it's something that someone can do in the normal course of their job, and it just becomes one more thing that they do, as part of everything else, then I don't think that would raise to the level of putting it in as an incremental cost, because we'd have to pull it out of where it's already getting recovered. And when you do that, I think that adds a lot of complexity to just reporting and accounting and everything that may not be worth it to track a small amount of incremental time.
Okay.
But larger amounts, yes.
So it sounds like that for the individual account person, you're keeping that door open, and depending on how it goes.
Yes.
Okay.
The time could be recorded on a time card. They could capture that. It's just what to do with that. That's probably something that we would need authority guidance on, as how to handle that.
Okay. And is any of that, I believe I think I know the answer to this. So but incremental costs that might have to happen. Suppose that a team of people from UI joined the Department of Economic Development and flew down to North Carolina to close the deal and to get that customer to move up here. Would expenses be considered incremental costs?
Most likely. If they were not expenses that would have been incurred outside of this proposed EDR, then I think those are the type of incremental costs that we'd like to capture.
Okay, I think this is a good point for me to stop there.
All right, very good. Then we will stop here for the evening, and we will pick up tomorrow at 10 a.m. We'll resume right back where we are. Thank you.